Yes, from. Urgency? No urgency.
Subject matter that now we are covered by something that means that this money is not payable to
Wait for some time. Yes. No, not now. Yes.
The subsidy matter, the farmers are already.
What matter?
Subsidy of the seeds matter. The farmers are already delivered the crop matter. The government.
Here for the farmers. Hand over. Yes, next.
Your Lordship, it was filed in May, July 23, and now no hearing has been done, and likelihood is dependent on the paper.
Why?
The Punjab National Bank had taken my place on rent, and since 2022, the 1870.
Not now. Yes.
My matter was in the list. Now it is somehow it has worked out.
What somehow? You must have been absent when it was called on. Cannot go out of the list automatically. Sorry.
No, not this way. But it was appear on report number.
Sarafin, not right now. Cannot add right now. Yes.
When the determination has been changed, it was worked.
Not right now. Yes.
Let it be listed.
No, not right now.
May I mention, Lord, the matter I was submitting yesterday, Lord, really in the nature of a confession. Lord, we had the RMC, Lord. We had argued, Lord, on the
Yes, yes.
lifespan of RMC. Lord, by inadvertence, Lord, the particular number of hours while writing the notes I found, Lord, is not there in the petition. Lord, I had included it. Have prepared a supplementary affidavit with the PWC, Lord, PWD and the
Oral arguments were over, Mr. Chaudhary.
yes, and the Indian standards, just to establish that.
Put it in your written notes of arguments and give a copy to the other
I
side.
have already given a copy yesterday.
If they want a hearing on that, I'll do that. But I
Lord,
cannot permit now.
Really, my Lord, confession
it's all right,
and
Mr.
apology,
Chaudhary.
Lord.
But give an advance copy to them so that
I've
they can
given yesterday, I'll
and
give
just
a-
indicate to them that I have incorporated this with
I
leave
will
of.
speak to them.
Yeah, my lords, kindly to mention a matter, it's item 221 of the monthly list, my lord. My name is in the denied entity list. The my lord predicament I suffer is every time, my lord, I am given, my lord, the export credit guarantee commission, I am being required to put 100% amount by way of bank guarantee. Though, my lord, I have taken up the company by virtue of, my lord, change of management in the, my lord, CIRP process in NCLT. I mentioned this.
19th as upgraded matter. 19th
So grateful,
February
my lord.
upgraded matter.
So
Yes.
grateful, my lord.
May I be permitted to mention
Yes.
one matter? It is running in your lordship's daily list, my lord. My lord, it is with regard to I am being denied to be provided with my original sale deed, my lord, on the ground that it bears some forged stamp duties for the last 32 years,
Want
my
to
lord.
pay that amount and get
Yes, that is the only
handover.
issue.
Yes. It upgraded it. Yes.
It
Upgrade.
will be held on 6th of February, madam.
Next
It
week.
has been noticed as challenge, madam, pending, madam. They have fixed the date of auction on.
2nd February upgraded. Tomorrow. Handover. Upgrade. Yes. Please wait for some time. Yes. Item number 4 appeared. Acha.
Was fast and different for the private consider the submission on the basis of the submission made by submitted that the civil.
What do you want now, Mr. Chatterjee?
What has happened, Lordship? Some facts have been suppressed. One. Number 2, Lordship, I got the notice yesterday at 3:30. That is there, Lordship. I got the.
That matter has been disposed of. File a formal application, Mr. Chatterjee. Point these out in a formal application, seek a review or modification or whatever. You have to file a formal application for that. Yes.
Connection will
Even then. Yes. You want connection? Hand over, please. Yes. Please repeat, Mr. Acharya. I couldn't hear you. You have a guarantor. You are a guarantor.
My entire bank account has been seized. I am unable to make a transaction.
Hand over.
I am ready to, my lord, pay
Hand
the
over.
amount.
Yes. Next.
Let it be.
Yes. Hand over. Upgrade it.
What has happened?
Be a bit louder.
The biometric device of the marriage officer has not been registered without any reason. That is the
Hand over. Yes. Yes. Be a bit louder, please. You are a what vendor? Serum. It is not in the list at all. Not in the list. So ordinary inclusion for the time being. Yes. It এমনি include হবে. Yes. Hand over. Yes. Yes, Mr. One. You want a connection or want a disconnection of somebody else? You want restoration? The hand over.
But I'm
No other, Mr. Vanna. Yes.
26, my lord. This matter, your lordship was pleased to stay the operation of the cancellation order of certificate, my lord. But they are not allowing me to attend the school, my lord. And it is applicable to 26 of the, my lord.
Then you have to file an interlocutory application.
Application, it is appearing in the list. I have filed this application and it is
Applications are taken up on Fridays, every Friday.
26, it is appearing under hearing, my lord.
Under hearing,
Yes, my lord. Though they have not used any affidavit, they are not appearing, my lord, in this matter.
give the slip. It will appear as an application. The application.
Extension of interim order.
My lord, may I brief, my lord, in this matter, an interim order was passed, my lord, that expired yesterday. I tried mentioning the
This is
matter.
for extension.
Yes, my lord.
Hand over.
My lord, in this matter, this item number 677 of combined list, senior citizen and extremely old ill person. At any date as my
What do you
lord,
want? What is the relief sought in the writ petition?
uplift at any date as
What is the relief you have sought in the writ petition?
my lord, a water connection has been forcefully given over the
To somebody else. You want disconnection of that water connection?
no. I want
No, not right now. I'm sorry.
my lord,
No.
it's very urgent, my lord. It
No.
could be any date, my lord. As
No,
my
there is
lord
no
wishes.
urgency. Yes. Restoration hand over. No. At the time of origin set, 3 p.m. Yes.
Compelling circumstances, Your Lordship. I'm mentioning, Your Lordship, I mentioned on Monday, Your Lordship, here the petitioner was seeking for renewal of his arms license, Your Lordship. Your Lordship, on that day directed to check the rent. Your Lordship, I have.
And over it will appear as an upgraded matter on February 20th. 20th February, upgraded matter. Yes. Be a bit louder.
Sorry, my lord, my house has been.
No, I've said no to you. Yes.
I have given notice also.
Please. You shout, just shout. Yes.
Matter is relating to wrongful withholding
Waste
of
time on these things. Yes.
all the legitimate dues of the petitioner, Milord, amounting to 57 lakhs 12,000. Now, Milord, what happened in the meantime is the matter came up for hearing before.
Claim the dues.
Yes, Milord.
No, not right now.
Milord, it's pending.
So you are not there. Yes.
Kindly to mention item number 124, Milord, the challenging the decision-making procedure of the particular tender, Milord, which is already vitiated with fraud and manipulation.
Mr. Sinha, not right now.
Milord, I have already sought.
Wait for some time. No. Yes, Mr. Mukherjee.
Stipulating the date of criminal proceeding where I am supposed to produce some documents which is released by my authority under Right to Information Act. That lordship prayer has been rejected.
What prayer?
My prayer for getting the documents.
Hand over. Yes. Upgraded. Yes.
Stamp duty and registration.
Hand over. Upgraded. Yes. Only non-prosecution. Yes. Hand over. You are the financial institution. Hand over. Yes. Hand over. Inclusion of what? What is the matter about? Come back on Monday. Prepare yourself. Come back on Monday.
I will mention one matter relating to disconnection of electricity, my lord. Petitioner has been without any default, has
Hand
been
over.
suffering from 2020.
Yes.
Permit to mention an application for
Louder.
application for application for appropriate order, lordship.
Hand over. Application hand over.
Lordship, the case is about I'm a 24 years prisoner. I'm inside the prison custody.
Wanting early premature release.
No, not premature release. Premature release application has been filed.
What
It
do you
has
want now?
parole. Lordship,
Hand over.
My lord, listed motion for inclusion in the list, my lord. In spite of registration of the deed of the petitioner, my lord, he did not get the same from the authority.
Ordinary inclusion, not upgrade. Any inclusion code. Yes.
Lord, item number 68, Lord, of your lordship's list, Lord, upgradation, Lord. My Barcam restaurant, Lord, has been closed down. The not Barcam restaurant closed down. The live band performance has been closed by the authority concerned.
Wait for
Lord, your lordship, my all staffs, Lord, are starving, your lordship, kindly.
no.
68.
Staff cannot serve only for live band stuff.
So, Milord, unless Milord, this is started, Milord, all these.
These are not right now. Not right now.
May I be allowed to mention a matter, Your Lordship? I have already served the notice, Your Lordship, to the other side, Your Lordship. The urgency is that, Your Lordship, the petitioner is the marriage officer, Your Lordship. marriage registered, your lordship, who solemnize a marriage, your lordship. When he applied for the certificate, your lordship, then he got a mistaken certificate, your lordship, in which, your lordship, some apparent mistake was appeared in the certificate, your lordship. When he applied for the correction, your lordship, that time, your lordship, the marriage officer, your lordship, legal officer, your lordship, he consequently also sent a notice, your lordship, to the marriage officer, in which, your lordship, the indication was that, your lordship,
You are yourself the marriage officer.
your lordship, I'm the marriage officer, your lordship, the marriage.
What have you
marriage
challenged?
register. I'm challenging the impugn order of the impugn notice of the legal officer, your lordship, that was sent, your lordship, from the department, your lordship. When he applied for the correction, your lordship, of the marriage certificate,
Yes.
then that was denied, and consequently, your lordship, a notice was issued to the marriage register, indicating that she may be suspended, your lordship.
Hand over.
Thank
Upgrade
you,
it. Upgrade it. In person, please wait till the advocates are over. Then I'll take. This will appear on 20th February as upgrade. Or it's 20th. Yes. Louder. Deeds are not being 21st February upgraded. Hand over. Only listing, then list. Yes. Hello, emni list দিয়ে দিও। Hand over. Hand over. Hand over. Hand over. Hand over. Yes.
This is wrongly by the high in this unauthorized construction. The concept matter.
To be mentioned, right to be mentioned on the slip and hand over a slip.
My lord, item number 34, my lord, matter is relating to police in action, my lord. Wrongly it has
To be mentioned, kalke দিয়ে দাও 34 for release.
item number
Right in the slip for release. Yes.
Lordship, mentioning for upgradation appearing as item number 237, Lordship. It has been mentioned several times, but it has not been upgraded. Lordship,
What's ground for upgradation?
the petitioner has invested an amount in a government scheme and he has not got the profit from the scheme and therefore he is suffering.
Hand over. It will appear on 22nd February as upgraded matter.
Your lordship, new electricity connection.
You want an electricity connection? Hand over. Yes.
My lord, may I be permitted? This is for inclusion application, my lord. Yeah, my lord, most
applications hand over.
My lord, but it may be in a
Applications
position
are taken
to
up on Fridays.
Oh, yes.
We'll let us.
Lordship, this is an urgent motion. The petitioners are poor cultivators and they are cultivating the seasonal crops, but the respondents are disturbing them and not letting them to cultivate the crops. Therefore, I'm praying for listing the matter under
What have
urgent
you
motion.
asked for in the writ petition?
Yes,
What
Lordship.
relief are you seeking here?
To let them cultivate their own land.
Writ court cannot grant that. If you have asked for police help, it will go to Justice Sengupta.
Lordship, actually.
Anyway, upgraded it দিয়ে দাও দেখে নাও. Yes, hand over. Yes, sir.
My contractor has worked in a government contract, my lord. Work completed, my lord. Will not pay, my lord.
Is this the same matter your father was mentioning in the morning? Is it the same matter? Different? Hand over. Give a slip. Yes. Extension hand over. Yes. Yes.
But mentioning is that updatation of the matter, DM actually South Indian Bank filed that section 14 application before the DM and 1 year.
Hand over. Yes.
Contempt application.
Contempt application hand over. Yes, Mr. Sin, I'll complete this side and I'll not come back. Yes, what is your
my client is in prison for 32 years, my lord. It's a premature
hand over?
application
Hand
for
over.
upgradation, my lord.
Hand over, but it will appear on 22nd February. 22nd February as upgraded.
Upgrade matter, my lord.
Why?
My lord, illegal nursing home is necessary without valid license, my lord.
Wait for some time, not right now. Yes.
Rather, my lord, this is an unusual mention.
Use the mic.
My lord, this is rather unusual. This matter is, my lord, appearing as item number 818 of your lordship's monthly list. All of a sudden, my lord, this matter has been taken up and appeared as a item number 14 of supplementary list and my lord, got disposed of day before yesterday. Respondents has never been
File an
notified.
application for recall. We'll consider. Yes.
My lord, item number 184 of the combined list, my lord. My lord, the contractor already has done the work, my lord, contract work. Completion certificate is issued. Thereafter, my lord, no bill is paid.
Please hand over. It will appear as an upgrade matter on 23rd of February. Upgrade matter. Yes. Yes. Pull.
Your Honor, I am Kaushik Mishra, party in person, have come to you because for my case number 15571.
You don't have any advocate?
Yes, I have any. I have an
You cannot
advocate.
mention personally. The advocate has to
I
mention.
have advocate, but as the matter was fixed on 6th September, for quick investigation, 6th September it was fixed. The
Anyway,
date was
if you
fixed.
have an advocate, I cannot
But
hear you directly.
He
You
is
don't
not
have the right.
helping me in proper way, sir.
No, either you take a no objection or the advocate has to submit.
Lordship, may I?
You are appearing.
Yes,
Yes,
I want
madam.
to appear on behalf of him because the advocate is shown at Mistro is not picking
Take a
his
no
call.
objection, you mention the matter. Why you
He's
asking him?
not accepting his call. How should I go there? I don't know him also, and I don't know his number. That's why if you
What?
Lordship,
He is not giving a no objection.
yes, he's not picking his call.
He is
even.
ready to give me no objection with for money. He is forcing money.
If you Lordship give permission, then I can
You
appear.
properly read the code of civil procedure. Come back tomorrow and tell me what is the provision. If the advocate refuses to give a no objection, come back tomorrow and give me the provision. If you can give me only the provision of the code of civil procedure, I'll grant that order. But you have to give me the provision tomorrow. Come back and mention tomorrow.
Sir, one thing can I tell you, sir?
When? No.
Sir, I'm a teacher and
Still now you have an advocate, I cannot hear you directly. Definitely I'll hear you through an advocate unless you get a no objection. If you don't get a no objection, she has to know what is the process. Come back tomorrow.
Okay, thank you. Thank you, sir.
You come back tomorrow and mention the matter and mention the proper provision. If the advocate does not give a no objection, what is to be done?
Thank you, sir.
Yes. Dakota.
Upgraded matter item 1.
Yes.
My lord, I am for the petitioner.
Yes, Mr. Mukherjee. Now you have that affidavit of service.
It is next matter, my lord. It is first matter. They
After.
prayed for not today, yesterday.
As where is the affidavit of service in this matter?
Yeah, it is already filed.
Already filed. Yes. What is the matter? You are appealing for the state.
Mr. Amitesh Ben is appealing for this table.
Yes. What is the matter?
My lord, page 17, the order passed by your lordships. I just praying for implementation of that order. That order was not implemented.
Yes, you are not doing it. Why?
I have no instruction, my lord. Kindly give direction, my lord. I will comply with the order.
That direction is already there.
Yes, my lord. But my lord, I have no idea in 2019 or 2021 what happened, my lord.
Learned counsel for the petitioner submits that despite a specific order dated November 22, 2021 by this court passed in WPA 23936 of 2019, directing the respondent number 3, he is also the respondent number 3 here.
Yes, ma'am.
Directing the respondent number 3 to forward the representation of the petitioner to the respondent number 2, being the Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal, within a fortnight from the date of communication of the order and subsequent consideration of the representation, nothing has been done in that regard by the respondents, full stop. The matter shall be placed in the list next on February 6, 2024, fairly at the top under the heading Upgraded Matters, when the respondents shall file a brief report explaining the non-compliance of the said direction. Full stop, it is made clear that in the event the respondents fail to show sufficient cause, a rule of contempt may be issued by this court. Please communicate this order formally and you also communicate.
Yes, grateful, man.
Yes, next.
Item 2.
My lord, I appear for the petition.
Yes, Mr. Dotto, what is the matter?
I appeal on behalf of the respondent number 3, Axis Bank.
My lord, I am appearing for respondent numbers 1, 2, and 4 in the matter.
All right.
My lord, the
Pursuant to
petitioner,
Lordship's direction, on the last occasion, I had indicated that I'll come back with written instructions in the matter. I have circulated the copies of the written instruction here and now in court to both my learned friends. May I just hand over a copy of the written instructions?
What's the matter about Mr.
yes, my lord. My lord, the petitioner was a borrower. Initially, my lord, credit facilities availed from Bank of Baroda. Thereafter, my lord, the credit facilities were, my lord, taken over by Axis Bank. The securities were also handed over to Axis Bank. There is no dispute that the dues of Axis Bank have been repaid. My lord, as security, there are two, my lord, nature of, my lord, security documents. One was, my lord, the title deed in respect of a property in Sector 5, Kolkata. And the other was, my lord, shares held by City Networks, my lord, another company, the holding company of the petitioner. Shares held by the holding company in the petitioner. Those shares were also pledged. These are the, my lord, nature of securities. Now, once I, my lord, clear the dues, my lord, I request them to release the securities. They don't release the securities. Ultimately, they take a stand that the holding company with whom, my lord, there is a separate credit facility, the holding company is in default, and therefore the securities which I had given, the petitioner had given, we are going to withhold those securities. My lord, there is a scheme of, my lord, Reserve Bank of India, my lord, an ombudsman scheme. Under that, it's, my lord, the scheme is, my lord, formulated under the, my lord, Banking Regulation Act and the, my lord, Reserve Bank of India Act. The scheme really says, my lord, if there is a deficiency in service, these are, my lord, banks and financial institutions are considered as regulated entities. If there is a deficiency in service, my lord, I can approach the ombudsman. I approach the ombudsman with a complaint saying all this. My lord, bank files a reply. Ombudsman with a, my lord, order, my lord, cryptic order, my lord, one line reason says that there is no deficiency in service so far as the regulated entity is concerned and has rejected. I am here challenging that order before your lordship. Now, before I take your lordship to that order, my lord, kindly permit me to place, my lord, only few documents which according to me are relevant, my lord, for this purpose. My lord, kindly comes to page 62, kindly come to, my lord, page 43, where the scheme starts.
Yes.
At the, my lord, top of the, my lord, page, scheme for resolving customer grievances relation to services provided by entities regulated by Reserve Bank of India in expeditious, cost effective manner under so and so. Then, my lord, kindly sees subsection 1, section 1, subsection 4. Scheme shall apply to services provided by a regulated entity in India to its customers under the provisions of so and so. Now, my lord, definition clause, section 3, kindly comes to page 44. My lord, G. Deficiency in service means a shortcoming or an inadequacy in any financial service or such other services related thereto, which the regulated entity is required to provide statutorily or otherwise, which may or may not result in financial loss or damage to the customer. And next page 45, J, my lord, regulated entity is defined. Means a bank or a non-banking financial company or a system participant credit information company, we are not bothered with that, as defined in the scheme, or any other entity as may be specified by Reserve Bank from time to time to the extent not excluded under the scheme. Now, my lord, the scheme also provides the, my lord, powers and functions of the ombudsman. Kindly come to page 47.
Yes. 47.
My lord, section 8. Ombudsman, deputy ombudsman shall consider the complaints of customers of regulated entities relating to deficiency in service. And, my lord, how it is to be done, the manner and method is, my lord, provided in this provision, my lord. Yeah. Now, my lord, kindly comes to, my lord, page 53. I'm sorry, my lord, page 51 first, my lord, page 51, section 14. Resolution of complaints, my lord. This is the procedure how the ombudsman is to act when it receives, my lord, a complaint. Then 15 says, my lord, award by ombudsman. And 16 at page 53 says how they can, on what ground they can reject. I am, my lord, relying upon 16 because this is the ground they have, my lord, indicated in the impugned order. Deputy ombudsman or ombudsman may reject a complaint at any stage if it appears that the complaint made is not maintainable under clause 10, is in the nature of offering suggestions or seeking guidance or explanation. They have not relied upon this. They are relying upon 2A. Ombudsman may reject a complaint at any stage if in his opinion there is no deficiency in service. Now, my lord, when it says in his opinion and they are to consider the complaint, my lord, it is presumed that they will discuss why, or my lord, there will be some reasoning in the order why they are, my lord, rejecting my challenge. Now, this is, my lord, really the purport of the, my lord, scheme. My lord, kindly comes to, my lord, 54. At page 54, 17.3. Complainant may aggrieved by an award under so and so 15.1 or rejection of a complaint under 16.2C to 16.2F within 30 days of the date of receipt of the award or rejection of complaint, prefer an appeal before the appellate authority. Why I am, my lord, showing this? Because they have taken a ground that there is an alternative remedy. And, my lord, so far as 16.1a is concerned, 16.2a is concerned, there is no appellate remedy provided in the scheme. Now, my lord, my Bank of Baroda's, my lord, sanction letter starts at 62, my lord, kindly comes to my lord 62. And lordship may kindly come to page 68, where the security details are mentioned. 62 it starts, my lord, 68.
Yes.
First charge on equitable mortgage over leasehold land at plot number so and so, sector 5, Salt Lake. This is the, my lord, property I was talking about. Then personal guarantee of so and so, company to arrange perfection of security maximum. I am not bothering your lordship with this. Lordship kindly takes note of the first entry, my lord, under the heading collateral security. Now, my lord, thereafter, lordship kindly comes to page 81. My lord, this is the document, the first sanction, my lord, from Axis Bank. This is with reference to your request. We are pleased to convey the sanction of the following credit facilities. Detailed terms and conditions of the sanction are mentioned in annexure enclosed herewith. Now, my lord, kindly comes to page 83. My lord, in the table, my lord, clause 6. Primary security, exclusive security interest, movables. My lord, the third bullet. Exclusive security interest by way of mortgage over the leasehold land and building at so and so, sector 5, Bidhannagar, Salt Lake. And then, my lord, pledge over 29.99% shares of ICNCL. ICNCL is the petitioner before your lordship, held by City Networks Limited in compliance with the extent regulations. Then the next line is pledge to be released up on perfection of all the stipulated securities. So, my lord, according to us, we were entitled to release of the pledge immediately after, my lord, the title deeds were made over to the Axis Bank by Bank of Baroda, because it was a takeover. Now, my lord, kindly comes to the pledge agreement at page 199.
Yes.
My lord, it starts at 199. The relevant, my lord, I want to show your lordship the schedule. It's at, my lord, 237. These are the, my lord, shares at 237. There's a schedule, my lord, which is part of the pledge agreement. These are the shares of Indian Cable, that is petitioner, held by City Networks, which was pledged. Now, my lord, after this, my lord, I'll show the handover, my lord, of the title documents. Kindly come to, my lord, page 256. This is, my lord, the schedule of securities we had, my lord, given in the form of a schedule. The registered deed is mentioned and the, my lord, share certificate of, my lord, this company held by City Networks. 257 is, my lord, the no due certificate issued by Bank of Baroda. After the table, my lord, kindly takes a note. This is to certify that the account has been taken over by Axis Bank on 5th July 19 and there are no dues in the aforesaid loan account. No due certificate is being issued at the specific request of the company. Now, kindly comes to, my lord, page 258. My lord, the subject at the top, my lord, release handover of original sale deeds, documents, etc. in the account of so and so. We refer to your letter dated so and so with regard to the caption subject. We are handing over the original sale deed, documents, etc. for the property comprising of so and so. This is, my lord, letter written to Axis Bank. So, my lord, the particulars of the documents are mentioned in, my lord, 1 to 6, my lord, in this letter, which includes, my lord, the documents with regard to the plot of land. Now, my lord, in the affidavit in opposition, they have admitted, I need not, my lord, there are admissions here also, but I want to show one paragraph from the affidavit in opposition. Kindly takes note of paragraph 5, Roman 28 at page 11 of the affidavit in opposition. My lord has found. In the meantime, my lord, it starts. In the meantime, on or around November 2022, petitioner number 1 repaid the facilities granted by the answering respondent, which is Axis Bank, under ICNCL loan agreement, and requested the answering respondent to release the securities given for credit facilities granted to the petitioner number 1. So there is no dispute that I had repaid the dues of Axis Bank as well. Now, my lord, after repayment, I requested them to issue, my lord, release the securities and issue a no due certificate. There are numerous correspondence in this regard. I'll just show, my lord, the first correspondence and the last one. My lord, 260. 264, my lord, kindly first comes to 264.
The writ petition.
Yes, my lord, of the writ petition. Affidavit, I will not, my lord, show any other document from the affidavit. Last 264, my lord, the email at the top, my lord.
Yes.
1st August 19, 10:55. This is from, my lord, petitioners to the, my lord, bank, Axis Bank. We have provided all securities as per term line. City Network has pledged share investment in ICNCL as security during the transition. Please arrange to do the needful for OD and intimate us. Arrange to release shares as mentioned above ASAP, as mortgage documents has been executed already by us. My lord, this was issued during the time when, my lord, the facility was taken over by Axis Bank, mortgage was also created, and the, my lord, during this transition period, they wanted some additional security, so the pledge of shares were given. We wanted release of the shares. They did not give us. We also did not really pursue them. Because we had the, my lord, intention to, my lord, repay the entire dues. Now, after the repayment of the dues, my lord, kindly comes to, my lord, page 302. This is, my lord, the statement I have annexed, which would show, my lord, this is really not necessary because of the stand taken in them. I would, my lord, request your lordship to come to page 323, my lord, directly. 323. My lord, second paragraph. In the same context, we want to inform you at present we are not in requirement of any working capital facilities. Hence, request you to please close our OD facilities. So and so, we request you to please do the needful and confirm us the same. Let us know the needful. In addition, support us in providing the no due certificate with release of securities, original title deeds, and share certificates. This is my request, and I continue with this request time and again. My lord,
refusal, Mr. Dattu. Let us come to the refusal.
Yes. My lord will then kindly come to page 357. My lord, it's the same document is at 365. This is, my lord, horizontally. If lordship has some difficulty.
65 is better.
Yes, 365. Same email is there, my lord. My lord, at the middle of the page, dear sir, this is with reference to your email below. The no dues for your loan is still under consideration internally. Primary observations are related to your holding company, its debt thereof, and the business linkages with ICNCL on same. We will take some more time to process the no dues internally, addressing the said observations. Please note, provisions of Companies Act gets triggered post issuance of no dues. Considering our year-end activities, approvals addressing the above observations would take some more time for us to process. We will get back to you once the same is considered. Ultimately, my lord, they don't consider. We write similar such letters, my lord. I then, my lord, invoke the, my lord, provisions of the scheme. Kindly comes to page 380. My lord, it is, my lord, online submitted. So this is the, my lord, text of the complaint, and there is a, my lord, restriction with regard to the number of letters or number of words that can be, my lord, put in that online portal. So this is the gist of the complaint we had made. And my lord, I just want to read, my lord, from the fourth last paragraph. Our email dated so and so. Were responded by stating that NOC for your loan is still under consideration internally. The mail which I just now showed, my lord. And that the said request to be considered basis debt resolution security improvement of the holding company. We have also received similar response from the MD desk of bank on so and so. Responses are unacceptable, unjustified for the following reasons. Company and city are separate legal entities. Credit facilities availed by us and those availed by city from the bank are independent transactions governed by their respective sanction letters. We cannot be held responsible or penalized for any default or delay by city in repaying its dues to the bank, nor can we be asked to improve or enhance city's security position as a condition for releasing our securities or issuing a NOC. My lord, the pledged shares or the, my lord, document, the title deed in respect of the Sector 5 property, they do not form part of the sanction advice which has been issued to city. They are independent. But because, my lord, I had repaid and they have some dues against the holding company, they are trying to, my lord, say that I will withhold these security documents to recover any dues that the holding company may ultimately not be in a position to pay.
The immovable property has nothing to do with city.
Nothing to do with city. Now, my lord, page 381 is the acknowledgement, my lord, that I had, my lord, made the complaint. And then lordship kindly comes to 383A, their response to my complaint. At 391, the same document is there, my lord. It is, my lord, not horizontal. So lordship can read from 391. 15 June 2023, my lord, email, yes. This is with reference to your complaint, so and so. In this respect, we would like to place the following. ICNCL is a subsidiary of City. City holds about so and so shareholding of ICNCL. City is part of SL group of companies. City is engaged in the business of so and so. My lord, first 3-4 paragraphs is really, my lord, about City. Kindly come to, my lord, paragraph 5 at page 392. In the meantime, ICNCL has repaid the amounts under the, my lord, 392, my lord. In the meantime, ICNCL has repaid the amounts under the credit facilities granted with a sanction letter. On 16 January 23, bank addressed a letter to City requesting it to extend the security for the credit facilities granted to it by the bank. However, City failed to extend the security to the credit facilities granted to it. Under the finance documents entered between bank and City, bank was entitled to call for additional security. Since City's account was declared NPA and a sum of rupees 193 crores was due and payable by City to the bank, bank was entitled to retain the shares provided by City. This is their stand, my lord. My lord, now the order, my lord, kindly comes to, my lord, 394. It's kindly comes to, my lord, page 395, clause 2, my lord, or paragraph 2 is really, my lord, what is important. Bank submitted that ICNCL is a subsidiary of City. Both companies had availed loans. Total of 775 crore credit facility was sanctioned to City. As security, City being the holding company as well as being intrinsically linked to the business of ICNCL, created a pledge of 29.99% shares of ICNCL held by it. Further, as the entire amount under the credit facilities granted to City has become due and payable, City account was declared NPA. In the meantime, ICNCL cleared its loan dues and requested for release of security and NOC. Hence, bank requested City to extend the security for the credit facility as a sum of rupees so and so is still to be paid by City to the bank. But company failed to extend security. Hence, bank has retained ICNCL shares pledged by company. Deficiency on part of the bank is not evidenced. Complaint is rejected. And then para 4, my lord. Para 3, it's under 16(2)(a) that they are rejecting, my lord, this. And para 4, please note that complaints closed under the above clause are non-appealable. My lord, when we filed the writ petition, my lord, we had also annexed, my lord, a Reserve Bank of India, my lord, circular. My lord, kindly comes to page 397. But this, my lord, I must indicate, my lord, there is a cut-off date. My lord, first come to 398, clause 9. These directions shall be applicable to all cases where release of original movable, immovable property documents falls due on or after 1st December 2023. Now, what does this say, my lord? Kindly comes to 397. In terms of guidelines on fair practice code issued to various regulated entities, since 2003, REs are required to release all movable, immovable property documents upon receiving full repayment and closure of loan account. However, it has been observed that REs follow divergent practices in release of such movable, immovable property documents, leading to customer grievances and disputes. To address the issues faced by the borrowers and towards promoting responsible lending conduct among REs, following directions are being issued. Release of movable, immovable property documents. REs shall release all original movable, immovable property documents and remove charge registered with any registry within a period of 30 days after full repayment settlement of the loan account. So even, my lord, till date, my lord, since it is, my lord, being withheld, my lord, if this circular is also applicable, because it is now after 1st of December that the issue has come up, my lord, I would say, my lord, even the RBI says that it has to be released. It's a deficiency in service which has resulted in customer grievances and disputes. That was the reason why this circular was, my lord, issued by RBI. Now, my lord, in the yes, my lord, my junior rightly points out, kindly comes to, my lord, page 390A. There is also a provision where, my lord, banks or REs are directed to, my lord, compensate for each day of delay. Clause 6, my lord. 6,000, 5,000 rupees for each day of delay. My lord, in the objection, my lord, filed, RBI has not filed any affidavit. Axis Bank has filed an affidavit. My lord, objections are primarily on the ground of, my lord, maintainability of the writ petition. My lord, the first ground is that the writ petition is not maintainable because it is against Axis Bank. My lord, to that, I would say, my lord, my primary relief or challenge is directed against, my lord, the order passed by Reserve Bank of India, the Ombudsman order. My lord, the Ombudsman order is under challenge, and which is, my lord, the Ombudsman is created under that scheme. The second ground he has taken, my lord, is that there is an alternative remedy before a civil court. According to them, my lord, these are contractual disputes. My lord, I understand if, my lord, there was some issue with regard to, my lord, the dues, whether, my lord, the entirety has been paid or to what extent it has been paid, it would have fallen within the realm of contract. My lord, possibly, my lord, I should have or I could have approached civil court. Here, my lord, after the, my lord, stand in the letters and, my lord, in the affidavit, there is no dispute that the dues, so far as the petitioner is concerned, is completely repaid. The only issue is, can bank withhold the security documents to satisfy the dues of another entity, which is a third party, according to me. My lord, here, my lord, the situation is, it is a holding company. So they are trying to, my lord, catch hold of the securities of the subsidiary. But in law, my lord, these are two, my lord, separate entities, distinct and separate entities. So, my lord, this argument should also not, my lord, apply.
They are also probably citing bankers' lien of some sort.
Yes. But bankers' lien will not apply. Bankers' lien, my lord, would have applied, my lord, if it was, my lord, the dues of this entity, which was, my lord, not repaid.
Same answer to all their arguments that these
yes.
different.
And, my lord, this issue is no more res integra. In fact, Lordship had the occasion to deal similar matter in similar, my lord, situations. Lordship had passed orders. And, my lord, the other, my lord, thing I would like to say, when, my lord, the petition was moved first, Lordship had recorded that the petitioner was successful in demonstrating a prima facie case. My lord, no objection with regard to any maintainability was raised. Now it is after affidavits. My lord, I have only one decision to cite in this regard, where, my lord, if it is after affidavit and, my lord, everything, all the facts are before your lordship, my lord, whether this point, if it was not reserved, whether it can be, my lord, raised. There is one Supreme Court, my lord, on this, my lord, I like to show that. My lord, the other, my lord, point he takes is locus. My lord, to that he says that so far as the title documents are concerned, it is your property, you are asking for return of the title deeds. So far as the pledged shares are concerned, it is really city who has pledged shares held in petitioner with the bank. So why the petitioner would be entitled to move at least to that extent? My lord, factually, City Network is undergoing, my lord, CIRP. And they have also, my lord, RBI today has handed over, my lord, instruction. My lord, from that instruction, it appears that they are contemplating another Section 7 against City. Be that as it may, my lord, the person who had arranged for the security, my lord, after repaying the dues, has approached the bank for release of the securities. My lord, securities can be given, even a guarantor, my lord, guarantors can give securities by deposit of title deeds or other things. My lord, it is, my lord, the responsibility of the borrower. As the borrower, I have requested the bank to release the securities. In law, if he is not entitled to, my lord, withhold the securities
Mr.
after
Datta, please clarify me on this. The shares were of you, your shares.
City was holding 29.99% shares in petitioner. And that share, those shares, during the transition period when the takeover was to take place,
Then City is the owner of those shares
City is the owner of those shares.
for all practical
That is the reason why he has, my lord, Mr. Medora has taken this point in the affidavit that you possibly cannot raise this issue.
How could you mortgage at the first instance?
No, it's my lord, in the nature of a guarantee. My lord,
How could you give it as a security?
I did not. My lord, City gave it.
As a City gave.
City gave it. My lord, it was only for the transition period. The value of the, my lord, property at, my lord, Sector 5 is sufficient to cover
Sector
the
5 is
entire
different. Property.
Yes.
Just
No,
segregating.
what I mean to say is, my lord, the value was sufficient to meet the liability, the facilities which was granted in favor of the petitioner. This security, which was provided by City, was as an interim arrangement. It was only during the transition period when the Axis Bank was taking over the loan from Bank of Baroda, because, my lord, there are certain formalities to be done, and bank hands over the title deed to another bank. I don't get it to, my lord, again deposit with Axis Bank. So this took some time. They wanted to disburse. So in the meantime, they wanted some security. So City, my lord, gave these shares. City was entitled to get release of these shares, my lord. This did not happen. After the dues have been repaid, my lord, as petitioner, as borrower, my lord, I requested the bank release all the securities. Not only my security, but also the guarantee which was given.
On the shares of City, you have got a worse case than your property.
My lord, if I look at it in a different way, what right does Axis Bank has to hold on to the shares? My lord, the sanction terms are very clear. It is, my lord, for a specific purpose, for a specific facility granted to a particular entity. And if the repayment is done by that particular entity,
City account became NPA after you pledged after you took the loan, after or before?
My lord, it was after. My lord, my lord, I just pointed out that
the quality of those shares change.
On 28th of August 2019, City account was declared as NPA.
2019.
2019.
And you took your loan? They took their loan when?
My lord, this was done in, I'll give you a lordship the date.
Because
March 2019.
Yes, because I will not interrupt now.
March
I am not
2019.
a party to be heard at this stage, I believe. But still, what follows and what I've little understood from the matter is the agreement, which is the pledge agreement dated 30th March 2019,
I'll hear.
is the main agreement which is the decisive factor.
Yes, Mr. Dattu. What else?
Yes, my lord. So in the affidavit, my lord, apart from, my lord, admitting that there are no dues of petitioner, they have really, I have not dealt with it in my reply because I felt it was not necessary. They have, my lord, said a lot about the transaction that Axis Bank had with City. And what is the nature of the transaction? What is the present status? So as the petitioner, I did not deal with that.
Cite your judgments quickly, Mr.
Yes.
Dattu.
Kindly, my lord, first
We'll now go over to the Axis Bank, then come to the Reserve Bank.
Yes. My lord, first, my lord, I cite 2023 SCC Online Delhi 6790. My lord, this was a similar case. Kindly, first paragraph is only, my lord, to understand what was the, my lord, challenge.
This is on what proposition, Mr. Dattu?
My lord, ombudsman, my lord, under the scheme here also, my lord, it was, the challenge was that they were not releasing the security documents. My lord, kindly comes to, my lord, paragraph 35 onwards. The finding of the, my lord, court.
Yes.
And, my lord, also, my lord, to deal with the issue of maintainability. In light of the foregoing decision, this court is of the considered opinion that a quasi-judicial body such as Ombudsman is reasonably expected to pass a well-reasoned order, and any empty formality thereto deserves to be weeded out. Adherence to the principles of natural justice is cornerstone of a just and fair legal system, as it also proves to be a quintessential safeguard against any adjudicatory arbitrariness in judicial or administrative proceedings. Therefore, undeniably, Ombudsman is duty-bound to pass a reasoned order which would eventually foster a great transparency in the decision-making process and inspire confidence of the common man in efficient dispute resolution through such bodies. Ombudsman scheme, which seeks to achieve an honest, cost-effective, speedy resolution of complaints of consumers against regulated entities, cannot be reduced to a tantalizing promise as it bridges the gap between the regulated entities and countless helpless individuals meandering for justice. While deciding upon the complaint, Ombudsman must fathom out appropriate reasons of rejection to uphold the integrity of its office and prevent it from becoming.
Mr. Datta, yes.
Yes. My lord, then my lord, Justice Datta's judgment is, my lord, already, my lord, quoted. I am not separately citing it at paragraph 33. Our High Court's view was in another matter, same, my lord, against, my lord, the Ombudsman. Then, my lord, I cite, my lord, no, eight. Your Lordship's judgment, Pearson Drums and Barrels Limited. My lord, it's my lord, paragraphs, kindly takes a note of the paragraph numbers 14, 22, 23 to 34 and 35. I'll not read the entirety of it, but the reasoning of your Lordship. Paragraph 22, 14, 22, 23 to 34 and 35. Lordship in this judgment has held, even if it is a private bank, my lord, writ petition is maintainable because it was discharging public function. My lord, kindly comes to, my lord, paragraph. I will just, my lord, read 2-3 paragraphs from 34 onwards.
Yes.
However, on the facts of the case, respondent number 4, while discharging its public duty, which is within the domain of the state to discharge, acted dehors of its own promise of refund, on which petitioner acted, which debars respondent number 4 by the principle of estoppel from refusing to refund the processing fees. Fresh sanction letter dated so and so in no uncertain terms indicated that unless petitioner returned the duplicate copy of the same with annexures duly sanctioned by authorized signatory, petitioner, company and guarantors as a token of acceptance of the terms and
on the facts of it.
Yes. Then, my lord, 35. Bank cannot now resile from its stand, which is revealed from a conjoint reading of in principle sanction letter and email asking for processing fees. Entire processing fees would be refunded in the event the sanction did not go through from the end of the respondent number 4 by any reason. In the present case, the reason was that bank sought a novation of the in principle sanction agreement by issuance of a fresh sanction on deviated terms. Decision of the respondent number 4 and that of Consumer Education Protection Shell of Reserve Bank to refuse the claim for refund of entire processing fee has to be set aside. My lord, here, my lord, the objection was raised that it's against a private bank. And this is, my lord, not, my lord.
Why is this judgment relevant? Apart from the fact that I delivered office.
No. That is not the purpose why I am citing this judgment. My lord, in that case, my lord, I have to, my lord, just take your lordship through the facts. No. It is, my lord, not because of the name.
Because it's writ petition is maintainable against private bank. That can be one of the propositions which you. So I'll take that proposition and let us move on to the next judgment.
I just want to, my lord,
need not clear
paragraph, my lord, 22 onwards, my lord, they also relied upon Federal Bank, my lord, judgment because the issue of, my lord, maintainability of the writ petition was raised by the, my lord, against private. That is the reason why I am saying.
Absolutely. What else?
There is an appeal pending from this decision.
Tendency of appeal.
No, there is no stay. There is no stay.
Does not.
My lord, the last decision, my lord, 2004 7 SCC 166.
On what proposition, Mr. Datta?
My lord, if the, my lord, right is not reserved,
yes,
on the, my lord, issue of maintainability, my lord, that paragraphs, my lord, 6, 8, 9, 11, 13 to 15. My lord, kindly comes to, my lord, paragraph 14.
Yeah.
Assuming that the explanation given by the appellant that the suit had been filed by one of the directors of the company without the knowledge of the director who almost simultaneously approached High Court under Article 226 is unbelievable, question still remains whether filing of the suit can be said to be a fact material to the disposal of the writ petition on merits. We think not. Existence of an adequate or suitable alternative remedy available to a litigant is merely a factor which a court entertaining an application under 226 will consider for exercising the discretion to issue a writ under 226. But the existence of such remedy does not impinge upon the jurisdiction of the High Court to deal with the matter itself if it is in a position to do so on the basis of the affidavits filed. If, however, a party has already availed of alternative remedy while invoking jurisdiction under 226, it would not be appropriate for the court to entertain the writ petition. My lord, last 3 lines, my lord, of this paragraph. Therefore, the fact that a suit had already been filed by the appellant was not such a fact, the suppression of which could have affected the final disposal of the writ petition on merits.
You have not even filed a suit.
No. So he said that I can approach the civil court
You're on a better footing.
I am on a better footing.
Yes.
My lord, I am only, my lord, requesting, my lord, or praying before your lordship, not only to, my lord, set aside the order of the ombudsman, but also, my lord, direct the bank, my lord, which is a nature of a consequential relief, to release the securities.
That would be allowing what the ombudsman could. I mean,
Yes, now that it is after affidavit, everything is before your lordship, sending me back to the ombudsman, my lord, is really, because it is my documents which are being, my lord, withheld by the bank without any reason.
anything else on the proposition, Mr. Dotto, that which they are taking, that they are entitled to withhold on that? You say you are separate juristic entities regarding the shares. Because I want to be satisfied on that count also. I want to hear your version on that before I go on to the
My lord, 171, I'll just read once.
Yes,
Contract.
171 they have cited. They have relied on. Contract একটা দাও।
ওটা দেখানো হলো না।
Contract act। ঠিক আছে আমি
Copy. General Lien of Bankers, my lord. Lordship has a copy.
Yes.
Bankers, factors, wharfingers, attorneys of a high court, and policy brokers may, in the absence of a contract to the contrary, retain as a security for a general balance of account any goods bailed to them, but no other persons have a right to retain as a security for such balance goods bailed to them unless there is an express contract.
So they are
to
saying that
effect.
even in the absence of a contract to the contrary, they can do it.
Only
But
if,
you
my
are
lord-
qualifying if it was pledged by them at the first instance.
Yes, and
you did it.
Yes, my lord. Second reason, my lord, this, my lord, 171 applies in a situation where there is a contract. It is between two parties. My lord, if I had other facilities with Axis Bank, where, my lord, they
Absence of a contract to the contrary. That is the language.
bankers, factors, so and so, in the absence of a contract to the contrary, retain as a security for a
That's why they
general
are
balance
denying
of account. My lord, this general balance of account has to be between Axis Bank and the petitioner, not between Axis Bank
That's
and
what
third
I'm
party.
saying. You have to read it down to include only those persons. He has to have a relation with you
Yes.
vis-a-vis that property.
Yes, vis-a-vis that property.
There is a contract to the contrary because creditors was supposed to be released.
So city never bailed the goods to them.
And there is, my lord, a contract to the contrary. There is a pledge agreement which says that they were required to release it. The pledge agreement I have disclosed. In terms of the sanction letter contains that the pledge agreement is there. So in terms of that, it was supposed to be released. So they cannot, my lord, exercise lien also. My lord, since lordship pointed out the last one, again, not because of, my lord, the name, but this is important. My lord, only one paragraph, because this issue had come up in this matter. My lord, kindly comes to para 6. It is unreported.
Unreported, you have to give up. Yes.
I have given a copy, my lord. Even if it is assumed that my lord, para 6, even if it is assumed that petitioner number 5 is liable to repay as a guarantor a loan taken by a third-party company of which the wife of the petitioner number 5 is a director, same could not create a lien on the loan account deeds deposited by the partnership firm, which is an entirely different entity altogether. My lord, the same issue had come up here. Then, my lord, kindly sees, my lord, paragraph 8. Next page, the defense of the bank cannot be accepted being not tenable in the eye of law insofar as bank seeking to furnish details of documents in question in the event it were to be found that title deeds and other security in respect of both the loans were common, it would be a gross negligence on the part of the bank, since for the same title deeds and other security, bank could not have created two separate mortgages in respect of two different loans taken by entirely different entities. Thus, I do not find any reason to drag the matter further by directing affidavits unnecessarily. My lord, here lordship had disposed of at the, my lord, motion stage without calling for affidavits.
Para 7 is also important.
So I'll my lord, place that, my lord. Mere fact that petitioner number 5 may be common in the sense that he is a partner of the petitioner number 1 firm as well as a guarantor in respect of a different loan by a third-party entity cannot furnish a ground to the bank to withhold the title deeds and other security of the partnership firm, which has no connection whatsoever with the loan.
Facts are different here.
No, but the analogy is
Principle.
just because I am the subsidiary of the holding company, my lord, you cannot, my lord, retain the security documents, my lord, to, my lord, clear the dues of the holding company. Security documents of subsidiary to, my lord, clear the dues of holding company. There, my lords, if they can produce that city, the sanction advice issued to city contained this pledged shares as a condition, or, my lord, this was of part of security, possibly what my lord bank is saying is correct. But if in the absence of that, they cannot withhold on these securities to my lord realize money for my lord dues of city. So my lord, I would my lord humbly pray lordship, instead of my lord, if lordship is with us, instead of remanding it, I would my lord pray lordship kindly considers and dis. Grateful, my lord.
Yes, Mr. Badod.
Can you give me a moment, madam?
Yes.
May please, your lordship. Well, so far as my arguments are concerned, Mr. Datta has, of course, kind of indicated what my arguments will be, and your lordship has heard the same. Before I deal with the merits of the matter, my lord, certain objections so far as the maintainability of the writ petition is concerned, my lord. 4 or 5 grounds on which I am opposing the maintainability, my lord. First is, my lord, Axis Bank is the party against whom the petitioner is seeking its relief. Because if he were to succeed in this writ petition, it is Axis Bank who will have to hand over the necessary documents. So relief is essentially being sought against me. The RBI is a mere intermediary. So primary relief against me, it's not just consequential relief as Mr. Datta has tried to portray. It is the primary relief which he is seeking, which is against me. So far as Axis Bank is concerned, my lord, it's an admitted position that we are not state. We do not come under the definition of state as per Article 12. And so far as this transaction is concerned, between Axis Bank and the petitioner or the petitioner's holding company, Citi, there is, my lord, there has been no discharge of public function. It's purely in the realm of contractual disputes, purely in the realm of civil nature. So no public function was being discharged by the bank so far as these transactions are concerned. Hence, Article 12 is not applicable to me. That's one argument. I'll rely on some judgments, my lord. Second, my lord, the disputes in nature are contractual disputes. That's linked to my first argument. Third argument, my lord, on this point is that they have an alternate and efficacious remedy in the nature of filing a civil suit. It is not that they are precluded of any remedy. It is not that they will be left high and dry, but they have an efficacious alternate remedy available to them. Fourth point, my lord, is that Citi, whose shares these are, has not been made a party to this proceeding. Mr. Datta has fairly submitted that CIRP process is going on so far as Citi is concerned, but neither has the IRP, the interim resolution professional or the resolution professional, been made a party. So in the absence of Citi in this proceeding, no relief can be granted. My humble submission is that Citi is a necessary and proper party so far as this proceeding is concerned. Lastly, point of locus, which has fallen from your lordship also. Mr. Datta's case is in respect of 2 sets of documents or two sets of security. One is the Salt Lake property and the other are these shares. So far as the shares are concerned, my humble submission before your lordship is that the petitioner has no locus to make any claim before your lordship in respect of these shares. He is admittedly not the owner of these shares. He is not the shareholder. It is his shares. The shareholder or the share owner is Citi. So if anybody has to make any claim in respect of these shares, it has to be Citi, either directly or through the RP, who's now in charge and control of the affairs of Citi. So the party who is entitled to claim any right in respect of these shares is not before your lordship. Mr. Datta is, on the other hand, batting for this party. And he has no right whatsoever to do that.
But you accepted these shares as security for his loan.
That's right. And I accepted it from Citi. It is not that I accepted these shares from the petitioner. I accepted these shares from Citi. Because Citi gave me these shares, I extended credit facilities to the petitioner. Had these shares not been given to me, I may not have advanced these credit facilities to the petitioner. So today, if any party has any right
so you have to return, you have to notionally return, you have to return it to Citi.
If at all, yes, I will argue also on merits that I still do not have to return them to Citi. That's my second.
Obviously, that's your argument.
Yes.
I mean, but so if you had to, then you had to.
If I had to, then it had to be to Citi alone and not to him. He cannot espouse the cause of Citi through this writ petition. For the Salt Lake property, perhaps he can espouse the cause. But so far as the shares are concerned, my lord, he has no right whatsoever. They are his shares. He should not be bothered with who his shares are lying with. Well, I'll deal with the judgments towards the end, my lord, but I do not have too much to say, my lord, because the facts are by and large admitted. I would just want to show a few pages to your lordship so far as my right to retain these shares are concerned. Of course, my argument will be primarily on the basis of section 171. And I will show one document to demonstrate that I have a right to retain these shares. My lord will kindly take page 113 of the writ petition. This is part of the term loan agreement entered into between the petitioner and Axis Bank.
Yes.
Well, I'm relying on clause 13.3. Petition. May I place this clause, my lord?
Yes.
It's title set off. B is relevant, but I have to place A just to for continuity. The borrower agrees and acknowledges that the bank has an absolute right to settle any indebtedness whatsoever owned by the borrower to the bank under this agreement or under any other document agreement by adjusting, setting off any deposits, and or transferring monies lying to the balance of any accounts held by the borrower with the bank without giving prior notice to the borrower. However, the bank will intimate the borrower of such exercise of rights under this clause 13.3a. The bank's rights hereunder shall not be affected by the borrower's bankruptcy, death, or winding up. Subclause B, my lord. In addition to clause 13.3a above, notwithstanding the payment of any of the loan obligations under the facilities, the borrower hereby expressly gives the bank the power to appropriate proceeds out of any and all security interest created in favor of the bank under the security documents or deposited with it or under its possession or control towards satisfaction of any amounts due to the bank on account of another agreement or transaction entered into by the borrower or any of the affiliates of the borrower with the bank. So he has also given me a right through his agreement to utilize the securities which are granted to me in respect of any other claim which I may have against any of his affiliates. So far as Citi is concerned, Citi is definitely an affiliate, in fact, the holding company of the petitioner. So that from this clause stems my right to retain these securities. One further document which Mr. Dotto has shown, but I want to show another page from the document, the pledge agreement, my lord. The pledge agreement started at page 199. Part of volume 2, my lord. Well, we'll kindly see who the parties are to this pledge agreement. The pledge agreement executed at the place set out in serial number 1 of the schedule 1 and on the day, month, and year set out in serial number 2 of the schedule 1 by 1. The persons named in serial number 3 of the schedule 1 hereinafter referred to as the pledger of the one part, and 2 is Axis Bank Limited. Kindly, my lord, see, my lord, serial number 3 of the schedule 1 to determine who the pledgers are, who the parties are to this agreement. Lordship will find that at page 229. Kindly, my lord, take the table at page 229, serial number 3, name and address of the pledger and all other details for the notice clause. Citi Networks Limited, a company within the meaning of the Companies Act. So this document by which I was granted pledge in respect of these shares, the petitioner is not a party to this agreement. The party is Citi. So any right in respect of these shares can only be asserted by the pledger, who is Citi. Mr. Dotto cannot make submissions on behalf of Citi. He is trying to adopt a circuitous route to achieve what he cannot. So, my lord, broadly speaking, then, my lord, section 171 of the Contract Act. May I just place it? Lordship has already seen it, but may I place it once again, my lord? Section 171, general lien of bankers, that would include me, my lord, factors, warfingers, attorneys, and policy brokers. Bankers, factors, wharfingers, attorneys of a high court, and policy brokers may, in the absence of a contract to the contrary, there is no contract to the contrary here, retain as a security for a general balance of account any goods bailed to them, but no other persons have a right to retain as a security for such balance goods bailed to them unless there is an express contract to that effect. So the second part of this section is not really applicable out here. What is relevant, my lord, is the first part of this section. May I just indicate once again, bankers may, in the absence of a contract to the contrary, retain as a security. So what I am doing, my lord, I am retaining as a security for a general balance of account any goods bailed to them. What has been bailed to me, my lord? The shares. And what am I retaining them for, my lord? For a general balance of account between the pledger and me, between the party who has given the security and me. Mr. Doctor has tried to argue that I may not be having any other claim against him, and therefore I do not have a right under section 171. That is misfounded, my lord, with the greatest amount of respect. The general balance of account has to be between the person who has given the security and vis-a-vis the bank. It is an admitted position that I have over a claim of rupees 200 crore against Citi. I have filed my claim also before the IRP or the RP, whatever status is now, against Citi in the NCLT proceedings. So that section 171, my lord, is squarely applicable. The contract also allows me to retain these securities, not just the shares, but also the Salt Lake property. In any event, my lord, I fall back on my first submission that the writ petition is not maintainable for those 4 or 5 reasons which I have submitted before your lordship. Now, my lord, some judgments which I seek to rely on.
Before proceeding with that, Mr. Medora, so we can segregate the pledge agreement, the shares which pertain to the pledge agreement, and the property. What is your answer on the property? Why shouldn't you release those title deeds?
So far as the property is concerned, my lord, I showed that clause at page 119. I'm sorry, 113 perhaps.
Yes.
Where, my lord, I'm given the right to retain even the Salt Lake property or any security for any transaction with any affiliate of the bank. So yes, so my argument on shares is definitely at a higher level. I have various arguments on that. So far as the Salt Lake property is concerned, twofold argument, my lord. One is writ petition is not maintainable for various reasons. And secondly, on merit, he himself has given me a right to retain the title deeds in respect of this property in terms of this clause at page 113. Just 10 paragraphs. The other argument which my learned junior friend says, my lord, is that so far as this group is concerned, Citi and the petitioner, Indian Cable, ICCNL, they're part of the group called the SL group.
Yes, you have mentioned.
Yes, I've mentioned that. And there's been a complete mismanagement of this group.
They're bad people, basically.
Bad people.
Next argument. Yes.
Now, my lord, so far as the judgments are concerned, my lord, of course, Mr. Dotto's judgments, I've just received them today. So I'm not too sure how appropriately I'll be able to deal with them. But so far as my judgments are concerned, my lord, two sets of judgments I'll provide, my lord. There are various judgments. I won't show all. One is with regard to the maintainability point, and the other is with regard to the section 171 point. But so far as the maintainability, before that, my lord, I must show one judgment because Mr. Dotto took the point that I cannot raise this argument on maintainability now because affidavits have been completed, etc. My lord, two submissions, my lord, in this regard, my lord. Lordship hasn't till date held this writ petition to be maintainable. No interim order or interim protection has also been given to him. Your lordship is for all practical purposes hearing this matter for the first time after affidavits have been completed. So, my lord, no interim order granted in their favor, therefore point of maintainability can still be taken. Now, my lord, the judgment which I seek to rely on, my lord, I do not have a copy of it, but I'll hand over my copy if your lordship will permit me to just place two paragraphs from this. Paragraphs 37 and 38 of a judgment reported in 2008, volume 12, SCC 675. Short paragraphs, kindly permit me to just place that. Para 37, 38. The para 37.
Please give me half a minute. I'll just. I'll let you go on placing. I'll just.
I can wait, my lord. No difficulty.
Please give the citation once more.
My lord, 2008, volume 12, SCC 675.
Yes. And the
Para 38 only. Para 37 may not be that relevant. Para 38, which is at page 688 of the.
yes.
With respect to the learned judge, it is neither the legal position nor such a proposition has been laid down in Suresh Chandra Tiwari that once a petition is admitted, it cannot be dismissed on the ground of alternative remedy. It is no doubt correct that in the head note of All India Reporter, page 331, it is stated that petition cannot be rejected on the ground of availability of alternative remedy of filing appeal, but it has not been so held in the actual decision of the court. The relevant para 2 of the decision reads thus: at the time of hearing of this petition, a threshold question as to its maintainability was raised on the ground that the impugned order was an appealable one, and therefore before approaching this court, the petitioner should have approached the appellate authority. Though there is much substance in the above contention, we do not feel inclined to reject this petition on the ground of alternative remedy, having regard to the fact that this petition has been entertained and an interim order passed. Even otherwise, the learned judge was not right in law. True, it is that issuance of rule nisi or passing of interim orders is a relevant consideration for not dismissing a petition if it appears to the High Court that the matter could be decided by a writ court. It has been so held even by this court in several cases that even if alternative remedy is available, it cannot be held that a writ petition is not maintainable. In our judgment, however, it cannot be laid down as a proposition of law that once a petition is admitted, it could never be dismissed on the ground of alternative remedy. If such bold contention is upheld, even this court cannot order dismissal of a writ petition, which ought not to have been entertained by the High Court under Article 226 of the Constitution in view of availability or alternative and equally efficacious remedy to the aggrieved party, once the High Court has entertained a writ petition, albeit wrongly, and granted the relief to the petitioner. So, my lord, my submission is, my lord, what flows from this judgment is the point of maintainability can be decided by your lordship even at this juncture. Even when your lordship is considering this matter at the time of final hearing, after affidavits have been completed, your lordship is well within your lordship's rights under Article 226 to dismiss the same on a preliminary point of maintainability.
What is the alternative remedy? Suit.
My lord, so far as alternate remedy is concerned, suit, and not just alternate remedy. I would humbly beseech your lordship to consider this aspect that it's a point of maintainability. Maintainability can be on various points.
Why not maintainable?
Because, my lord, I am not state.
Oh, that.
Yes, I am not state. Disputes in nature, disputes between the parties are contractual in nature. The point of locus also, so far as the shares are concerned.
Yes, yes.
So all these points, none of your lordship is not precluded from passing a judgment in respect of any of these preliminary points, merely because your lordship is hearing the writ petition at the final stage.
What else, Mr. Madre?
Now, my lord, the judgments on the point of maintainability, the first judgment which I seek to rely on, lordship is familiar with this judgment and it was referred to in some judgment which Mr. Dotto placed, the Federal Bank judgment, which is reported in 2003, volume 10, SCC page 733.
Thank you.
Please keep the next judgment. Well, the three paragraphs I seek to rely on from this judgment. The first is, my lord, paras 18, 32, and 33. The para 18 will be at page. My lord, lordship has para 18, my lord. From the decisions referred to above, the position that emerges is that a writ petition under Article 226 of the Constitution of India may be maintainable against 1, the state, that is government, 2, an authority, 3, a statutory body, 4, an instrumentality or agency of the state, 5, a company which is financed and owned by the state, 6, a private body run substantially on state funding.
You can come under 7 or 8. Either 7 or 8.
7, a private body discharging public duty or positive obligation of public nature. So my submission is I'm not, so far as these transactions are concerned, I'm not. And so far as 8 is concerned, a person or a body under liability to discharge any function under any statute to compel it to perform such a statutory function. So even this under, I do not come under. And the two other paragraphs from this judgment, 32 and 33. Hmm, 26. Will you kindly permit me to place para 26 first before I come to 32 and 33. Lordship, as para 26?
Yes.
A company registered under the Companies Act for the purposes of carrying on any trade or business is a private enterprise to earn livelihood and to make profits out of such activities. Banking is also a kind of profession and a commercial activity. The primary motive behind it can well be said to earn returns and profits. Since time immemorial, such activities have been carried on by individuals generally. It is a private affair of the company, though the case of nationalized banks stands on a different footing. There may well be companies in which majority of the share capital may be contributed out of the state funds, and in that view of the matter, there may be more participation or dominant participation of the state in managing the affairs of the company. But in the present case, we are concerned with a banking company which has its own resources to raise its funds without any contribution or shareholding by the state. It has its own board of directors elected by its shareholders. It works like any other private company in the banking business, having no monopoly status at all. Any company carrying on banking business with a capital of 5 lakh will become a scheduled bank. All the same, banking activity as a whole carried on by various banks undoubtedly has an effect on the economy of the country in general. Money of the shareholders and the depositors
So this distinction between nationalized and private banks, a time has come to rethink this, to revisit this in the age of privatization. So this distinction may not be smudged now, somewhat. So because you are having powers, private banks are also having powers under the SABYASACHI Act and other equivalent to nationalized banks. So you assume to yourselves powers which are, previously were within the domain of courts and all. So you can do things which was unimagined previously, could not have been imagined.
Yes, of course.
So this distinction between nationalized and privatized bank is not so important now.
I appreciate that, my lord.
We have this is 2003.
This is 2003.
We have come a bit.
It's been a while. Yes.
Yes. Para 27 also the first line. Such private companies would normally not be amenable to writ jurisdiction. You have a point there, but that is debatable. 32 is more in your favor, probably. Stronger rather.
Yes, 32 and 33.
That is one of the lines which we take generally to issue writs against private bank. 32.
May I place 32 and 33? Before I place it, madam, may I just say this one thing, my lord?
Yes.
Agreed, my lord, that perhaps the blur or the line between private banks and nationalized bank today is blurred. But at the same point of time, while deciding this writ petition, your lordship will still perhaps have to determine whether I was discharging
nature of the transaction.
Nature of the transaction. My lord, para 32, my lord. Merely because Reserve Bank of India lays the banking policy in the interest of the banking system or in the interest of monetary stability or sound economic growth, having due regard to the interests of the depositors, etc., as provided under Section 5CA of the Banking Regulation Act, does not mean that the private companies carrying on the business or commercial activity of banking discharge any public function or public duty. These are all regulatory measures applicable to those carrying on commercial activity in banking, and these companies are to act according to these provisions, failing which certain consequences follow, as indicated in the Act itself. As to the provision regarding acquisition of a banking company by the government, it may be pointed out that any private property can be acquired by the government in public interest. It is now a judicially accepted norm that private interest has to give way to public interest. If private property is acquired in public interest, it does not mean that the party whose property is acquired is performing or discharging any function or duty of public character, though it would be so for the acquiring authority. The last paragraph, para 33. For the discussion held above, in our view, a private company carrying on banking business as a scheduled bank cannot be termed as an institution or a company carrying on any statutory or public duty.
The next sentence is the single most important sentence in this entire judgment. Please read it.
A private body or a person may be amenable to writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligations or such obligations of public nature, casting positive obligation upon it.
That is the crux of this judgment.
Yes.
So you see in this case, this transaction, you are not doing that.
Absolutely not. The next judgment which I seek to rely on, my lord. My lord, Well, this is again, my lord, with a point dealing with the ombudsman, which is why I'm placing reliance on this judgment. It's reported in 2023 SCC Online, Delhi, page 92. Paragraph. Kindly give me one moment.
92. 2023 SCC Online Delhi.
Kindly come to paras 21 first. Para 21, Mala, talks about, Mala, the principles governing this court's jurisdiction under Article 226, and it quotes a judgment of the Supreme Court. So I'm not placing that in detail, my lord.
22 is relevant.
Para 22, yes. The banking ombudsman, which is a specialized authority and only deals with the disputes between banks and customers, has held in favor of the bank. And this court, while exercising its jurisdiction under Article 226 of the Constitution of India, should not interfere with the decision taken by an expert body unless the decision is perverse. As pointed out earlier, whether clause 11.2, which has been relied on by the bank, will be applicable in the present case, or clause 11.1 and 11.1, which have been relied on by the appellant, will be applicable, has to be decided by leading evidence by both the parties in an appropriate forum. As stated earlier, admittedly, there has been an obvious mistake on the part of the appellant in filling up the RTGS form, and what would be the effect of that mistake in the instant case can only be decided after leading evidence. On the basis of the material available before this court, it cannot be said that the decision arrived at by the banking ombudsman is perverse, which requires interference under Article 226 of the Constitution. It is well settled that writ courts in exercise of their writ jurisdiction do not substitute their own conclusions to the one arrived at by the expert bodies. And my lord, one more paragraph, my lord. Which one? 18. The outside. That's okay. So this is so far as this judgment, the third and last judgment which I seek to place reliance on, my lord, so far as my arguments on maintainability are concerned, my lord, is the NP Shah judgment. This one. Yes, I made the paragraph. You have a copy? So this is the judgment reported in 1994, volume 3, SCC, page 552, and paragraph? Para 22, my lord. The para 22, just one paragraph. Yes. We are unable to see any substance in the argument that the termination of arrangement without observing the principle of natural justice or de alteram partem is void. The termination is not a quasi-judicial act by any stretch of imagination. Hence, it was not necessary to observe the principles of natural justice. It is not also an executive or administrative act to attract the duty to act fairly. It was, as has been repeatedly urged by Sri Ramaswamy, a matter governed by a contract or agreement between the parties. If the matter is governed by a contract, the writ petition is not maintainable since it is a public law remedy and is not available in private law field. Example, where the matter is governed by a non-statutory contract. Be that as it may, in view of our opinion on the main question, it is not necessary to pursue the reasoning further. So, my lord, these are the judgments on maintainability. My lord, two judgments on the point of lien, syndicate bank. Syndicate bank. The first judgment on the point of lien, which I seek to rely upon, is, my lord, a judgment reported in 1992, volume 2, Supreme Court cases, page 330. Paragraphs 6 and 7. 6 and 7. Well, kindly come to paragraph 6 at page 336.
Yes.
May I place this, my lord? In Halsbury Laws of England, second edition, so and so, lien is defined as follows. Lien in its primary sense is a right in one man to retain that which is in his possession belonging to another until certain demands of the person in possession are satisfied. In this primary sense, it is given by law and not by contract. In Commerce on Bills of Exchange, 13th edition, page 91, the meaning of banker's lien is given as follows. A banker's lien on negotiable securities has been judicially defined as an implied pledge. A banker has, in the absence of agreement to the contrary, a lien on all bills received from a customer in the ordinary course of banking business in respect of any balance that may be due from such customer. In Chitti on Contract, 26th edition, page so and so, the banker's lien is explained as under extent of lien. By mercantile custom, the banker has a general lien over all forms of commercial paper deposited by or on behalf of a customer in the ordinary course of banking business. The custom does not extend to valuables lodged for the purpose of safe custody and may in any event be displaced by either an express contract or circumstances which show an implied agreement inconsistent with the lien.
This entire thing is between banker and the customer.
Yes.
Here you rely on the pledge agreement to
That's
say
right.
that this pledge agreement was the genesis of this rights of.
Yes. And the pledge agreement is entered into between bank and city,
Right.
not the petitioner.
Right.
One last judgment, my lord. Have that. PK. PK Parthival, no?
Yes, absolutely similar.
No, this is the judgment of the Madras High Court. Facts are quite similar, my lord, in this case.
So matter will continue after the
Very well.
after 10
Yes,
minutes.
yes. I'm grateful.
would be in fact no general gain, as banks have been had to have, if it would be deposited with a utilized for recovering due
Which
bank
one
for
is
which
this?
the Delhi High Court, sir.
Yes, Mr. Yes, madam. Have you placed it or not yet?
Not.
No, no, just keep that handy. Well, the judgment of the Madras High Court, which I
Yes.
handed over. The similar facts, my lord, in our situation, it's a short order, my lord. Let me just place a few paragraphs from this judgment. Kindly take the very beginning, my lord. Petitioner seeks a writ of mandamus directing the respondents, Canara Bank, to return the title deeds placed with it by creating a mortgage deed document bearing so and so, dated so and so. The petitioner had stood as a guarantor for a sum of rupees 25 lakh, availed as overdraft facility by one G. Mahendran from the respondents, and had deposited the documents of title which he is seeking to be returned. The said loan of G. Mahendran was discharged and letter of clearance was also given. During the subsistence of the said guarantee, the petitioner himself obtained an overdraft facility to the tune of rupees 35 lakh and had executed another mortgage by depositing title deeds, the value of which is equivalent to the overdraft facility extended to him. According to the petitioner, the said property satisfied the security of the loan extended to him personally. The petitioner is now claiming return of the said document, which he had given as security for the overdraft facility availed by G. Mahendran, which is discharged in full. When refused by the bank, a legal notice was issued on so-and-so date, calling upon the bank to return the documents, mortgage as guarantor for the OD facility extended to Mahendran. The second respondent also sent a reply claiming banker's lien over title deeds as per section 171 of the Contract Act for the loan extended to the petitioner himself, which is an OD facility for a sum of rupees 35 lakh. Para 4, my lord, as the petitioner had not specifically agreed to mortgage the said property for the loan stroke OD facility availed by him, it was contended that the bank cannot retain the document as general lien and sought for return of the same. Hence the petition. Now, I will kindly come to para 6. Therefore, the question that would arise for consideration in the writ petition is whether the bank is empowered to exercise its powers under section 171 of the Contract Act by extending the banker's lien over the property which was given as security for the credit facility availed by G. Mahendran, though admittedly is discharged. So similar facts, my lord. Then 171 is set out, para 8. The concept of general lien itself is in respect of what is called collaterals, that is documents, securities, etc., which are in the custody of the banker and are intended to cover the banker's claim against a customer. Para 9, it is not the case of the petitioner that the general lien that is exercised by the respondent's bank is for the borrowal of a third party for whom he had given the security, but it is for his own credit facility that was availed by him. Therefore, if it were to be held that without the borrower expressly agreeing that his property is deposited with or in the custody of the bank be utilized for recovering the dues of the bank for which he is liable, the term general lien itself would be inapplicable. In a recent decision of the division bench of this court in CB Ramacharyi versus Indian Overseas Bank, it was specifically held considering the decision of the Honorable Apex Court in Syndicate Bank versus V. Vijay Kumar, which I placed, my lord, as follows. Well, para 11 and 12 of that judgment is set out. I will not trouble your lordship with that, my lord. Para 11, it is also relevant to refer to the order of a learned single judge of Delhi High Court in Rajkumar and others versus Syndicate Bank, considering a catena of decisions of various high courts and held that the rights under section 171 of the Indian Contract Act can be exercised on an immovable property deposited with the bank as security. Even in the affidavit filed in support of this petition, it is stated by the petitioner that he has been very regular in payment and has not defaulted, though the respondent bank would state that the outstanding as on so-and-so date. Admittedly, proceedings before DRT had also been initiated. As the last paragraph, as the general lien exercised by the bank is well within the ambit of section 171 of the Indian Contract Act, the petitioner cannot seek for return of the title deeds that was deposited for the credit facility taken by G. Mahendran. However, it is open to the petitioner to approach the bank for settlement and get the debt extinguished. In light of the above discussion, the writ petition is liable to be dismissed, and accordingly, it is dismissed. No costs consequently connected. One last judgment which I will place reliance on, my lord. Sorry, parasitan. May I hand over a copy? Do you have another copy? The judgment reported in 2016 SCC Online, Delhi, page 4726, 2 paragraphs, paragraphs 8 and 9. On the second page, my lord, if the proposition as is canvassed by the counsel for the petitioner were to be accepted, there would in fact be no general lien, as the banks have been held to have. If it were to be held that without a customer expressly agreeing that his properties deposited with or in custody of bank be utilized for recovering due of the bank for which the customer is liable, we would not be giving effect to the word general in the expression general lien. Supreme Court in Vijay Kumar has held the above passages go to show that by mercantile system, the bank has a general lien over all forms of securities or negotiable instruments deposited by or on behalf of the customer in the ordinary course of banking business, and that the general lien is a valuable right of the banker, judicially recognized, and in the absence of an agreement to the contrary, a banker has a general lien over such securities or bills received from a customer in the ordinary course of banking business, and has a right to use the proceeds in respect of any balance that may be due from the customer by way of reduction of customer's debit balance. Even otherwise, having regard to the mercantile custom as judicially recognized, the banker has such a general lien over all forms of deposits or securities made by or on behalf of the customer in the ordinary course of banking business. The last paragraph which I seek to rely on, para 9. There is another important fact which distinguishes the facts of the present case from that subject matter of the case before the Orissa High Court. Here, the respondent bank has a recovery certificate against the petitioner. Once a recovery certificate has been issued in favor of the respondent bank against the petitioner, the distinction which the division bench of the High Court of Orissa sought to make between the principal debtor and the guarantor or surety ceases to exist. As of today, the petitioner is the debtor of the respondent bank, and if it were to be held that notwithstanding the same, the respondent bank is not entitled to exercise the right of general lien over the title deeds of the immovable property of the petitioner in lawful custody of the respondent bank, it would be as good as giving a go-by to the right of a banker of general lien, and which, in my humble opinion, would be detrimental to the interest of the banks on which carrying on of large trade and businesses depend, and resultantly be prejudicial to trade and commerce. Also, the opinion of the division bench of the High Court of Orissa appears to be premised on the terms of grant of gold loan constituting a contract to the contrary within the meaning of Section 171 of the Contract Act, codifying the general lien of bankers, and which is also not the case here. These are the judgments which I seek to rely on, my lord. If your lordship wants, my lord, I can hand over a copy of the judgment which I hadn't, which your lordship looked at through the iPad. Forgetting. Judgment was this one. This is the judgment which I had placed but not handed over a copy. So, my lord, to summarize, my lord, my case, my lord, firstly, so far as the point of maintainability is concerned, my lord, I am not state. I am not discharging a public function so far as these transactions are concerned. The nature of disputes between the parties are contractual in nature. Thirdly, he has an alternate and efficacious remedy in the form of a civil suit. It is not that he will be precluded from raising any objection. Fourthly, he has no locus so far as these shares are concerned. Fifthly, Citi is not a party before your lordship in this proceeding, nor is the RP or IRP a party. I have exercised, in addition to these points, I'm exercising my right under Section 171 of the Contract Act, Bankers General Lien, and also from the agreement, so far as the pledge agreement is concerned, it is between Citi and me. The petitioner is not a party to the pledge agreement, so the petitioner cannot take the voice of Citi in this proceeding. And lastly, so far as my document with the petitioner is concerned, I've shown that clause where he's agreed that any security given to me in respect of the transaction between the petitioner and the bank can be utilized for other dues which may be payable to me in respect of any other affiliate as well. These are my humble submissions, man. That most grateful.
Yes. Yes, the RBI. Yes. This has been authored by the Ombudsman or the RBI?
This has been authored by the Ombudsman. It has been sent to me by the Ombudsman.
Right.
My submission will be very limited and only limited to the extent of the grievance of the writ petitioner so far as my client is concerned. Because as I understand the issues involved, it is not an adversarial litigation so far as my client is concerned. So I am representing respondent numbers 1, 2 and 4 in the matter.
What have you handed over?
What I have handed over is, instead of coming up with the elaborate affidavit in opposition to the writ petition, these are the written instructions of my client, the basis on which the decision was communicated. And why I'm saying the decision was communicated is much have been stated in the body of the writ petition only in paragraph 39 and 40 with regard to the nature of the communication that was done by my client's end. Now, may I just request your lordship to kindly look into paragraph 39 at page 24 of the writ petition. That is the first point of contention so far as the writ petitioner has against my client. May I just place paragraph 39 at internal page number 24. The purported decision communicated by the impugned email was not arrived at by the respondent number 2, but was purportedly arrived at by the respondent number 4. Under the scheme, the respondent number 4 did not and does not have the authority and or jurisdiction to issue the said impugned email dated 14th of July 2023. Since the said complaint of the petitioner number 1 was not found to be not maintainable and a reply had also been sought for from the respondent number 3, it was not open for the respondent number 4 to make or communicate any decision in the form of the impugned email dated 14th of July 2023. No decision in respect of the complaint has been arrived at by the respondent number 2. As such, the impugned email dated so-and-so was and is illegal, arbitrary, unjust. So that's the first point taken against me. Now, in order to answer that, my lord, may I just request your lordship to kindly take page number 44 once, which is part
But
of...
they also have an alternative argument in para 40.
Yes, I will address only these two paragraphs. So I am just going one by one. So far as para 39 is concerned, I am taking your lordship to the integrated scheme under which the arguments were also advanced. This is the relevant scheme under which Ombudsman acts, and also the letter that was issued or the communication which was issued was also issued by the concerned body under this particular scheme. So if your lordship takes up regulation 6 at internal page number 46, this is regarding the establishment of a centralized receipt and processing center, that is respondent number 4.
Yes.
The Reserve Bank shall establish the centralized receipt and processing center at any place as may be decided by it to receive the complaints filed under the scheme and process them. My lord, I'm pausing here for a moment. The language is very clear that so far as centralized receipt and processing center is concerned, it's the body that receives all the complaints that comes to banking ombudsman. And then it is like a post office. It receives all the complaints and then it processes also. So the word process is very important, processes them. So that was done. And now if your lordship kindly turns to page number 394, which is the communication.
Yes.
394 at page 395. Point number 3. Accordingly, the complaint has been closed under clause 16(2)(a) of the Reserve Bank Integrated Ombudsman Scheme of 2021, which reads as under. Complaint is rejected under 16(2)(a) of the Reserve Bank Integrated Ombudsman Scheme. In the opinion of the Ombudsman, there is no deficiency in service. So what is being communicated is actually the decision of the Ombudsman, and that the decision is taken by the Ombudsman, which is the opinion of the Ombudsman, and which is being communicated by this body of CRPC. Now, if your lordship looks into paragraph 2 in the concerned letter, paragraph 2 of the communication, it records, I am not going into the merits of it and whether it is a sufficient reasoning or not, but nonetheless, some form of reasoning does exist here in this. That is my respectful submission before your lordship. The bank submitted that Indian Cable Net Company Limited is a subsidiary of City Networks Limited. Both companies had availed loans from the bank. Total of so-and-so amount credit facility was sanctioned to City. As security, City being the holding company, as well as, this language is very crucial, my lord, being intrinsically linked to the business of ICNCL. Now, why this has been stated, I'll just point it out, although it has not been mentioned here. The parent body, which is the city, it actually holds 60.02% of shares in ICNCL, out of which 29.99% shares were pledged in favor of the concerned bank. So that is why when my learned friend was submitting, I had interjected and I had submitted that what should be looked into is the pledge agreement, because the pledge agreement and the term loan sanction terms would itself reflect whether the bank did have the right of exercising lien, on which I'm not again reiterating, because I'm going to address on that because I'm submitting that I'm adopting the submission made by Mr. Medora on with regard to that. Now, with regard to this, my lord, if your lordship now takes up what I have handed over to your lordship, towards the end, last but one page, Orbayo's observation and decision. From the submission made by the bank, it is observed that Indian Cable Net Company is a subsidiary. City holds 60.02% shareholding. City is part of SL group of companies. Both the companies had availed loans. Now, point number 3. As security, City being the holding company as well as being intrinsically linked to the business of ICNCL, created a pledge on, this sentence is not over, my lord. It should be 29.99% shares of ICNCL held by it. That completes the sentence. I'm told that the sentence somehow has not come here when it was printed. Then, due to irregularity in payment, the company was requested to 29.99% shares of ICNCL held by it regularize the account, but the company failed to regularize the account and did not meet its payment obligations. Then, hence, on 28th of August 2019,
29.99 up to held by it, this
Yes.
should have been a part of the previous sentence.
this should have been part of the
And
previous
court
sentence.
should have continued due to irregularity in payment.
Yes,
The company was
absolutely.
requested to regularize the account.
Yes, yes.
Very well. I'll read it like that.
Hence, on 28th of August 2019, the city account was declared NPA. The issue couldn't be resolved even after several meetings between the bank and city. In the meantime, ICNCL cleared the dues and requested for NOC. Hence, the bank requested city to extend the security for the credit facility as a sum of rupees 193 crore is to be paid by city to bank. Now, this is in my respectful submission under clause 13.3b, which was submitted even before the ombudsman, and on the basis of which ombudsman decided that yes, there is no irregularity in service. And that is why the complaint was rejected at the threshold and the communication was done. Now, if your lordship once again looks into the integrated ombudsman scheme, regulation 16 thereof, under which it was rejected. It is at page number 53 of the writ petition.
Yes.
What is noteworthy, or what was in fact troubling me also, I was taking instructions while the submissions were going on, because it indeed has to be adjudicated at some stage or the other. Because 16.2a, if your lordship looks into, the language is the ombudsman may reject a complaint at any stage if A, in his opinion, there is no deficiency in service. The language is opinion. It is not a decision. And very curiously, the power of appeal, which exists under this particular scheme, as was placed by, yes, it omits this 16.2a. And the power exists from 16.2c onwards, C to F. So, had it been a decision, is what my respectful understanding of the provision is, had it been a decision of the ombudsman, on the in the lines of 2C, D, E, and F, there could have been a provision for appeal. But in this case, it is a mere opinion, expression of opinion. And on the basis of the documents which were placed by both the petitioner as well as the bank. And after going through all the documents in record, which are now before your lordship, it was decided that there is no deficiency in service. So that is my respectful submission with regard to 39, and 40 also taken into consideration because 40 is an alternative case which has been run by the writ petitioner, where they say that even assuming but not admitting that the decision communicated by the impugned email was that of the respondent number 2. The impugned email and the decision communicated thereunder were and are illegal, arbitrary, unjust, unreasonable, unreasoned, and violative of the principles of natural justice, equity, and good conscience. So, in my respectful submission, if your lordship considers that there is some form of merit in this statement of the writ petitioner, then your lordship will pass necessary order to that effect, where I am not going to address on naturally. But so far as my stand is concerned, we have taken into all the correspondence which were placed by both the writ petitioner. The writ petitioner did not place before us. I have taken instruction the pledge agreement, which is a vital document, but the pledge agreement nonetheless we had gone through because bank had given us the copy of the pledge agreement.
Which is
and,
annexed to the writ
and now it is now annexed also to the writ petition, and therefore we have decided that there has been no infraction of statutory rights or whatever, and therefore we have rejected the complaint and we have dealt with it at the threshold. That is my respectful submission.
Thank you. Yes.
And another point which I have missed out is regarding the Reserve Bank of India circular, which was highlighted by the writ petitioner. In my respectful submission, my lord, that does not have any manner of application to the present facts, because there is a cutoff date, as rightly pointed out by my learned friend, the cutoff date being December 2023. So any document
With or
that is
without
written
that, you have a
with or without that, it
we
has
have to
to be
interpret the
decided.
provisions of
Yes,
this.
grateful to lordship.
Yes. Yes, Lord.
My lord, had I come at a stage when I had not approached ombudsman and a writ petition is filed against Axis Bank saying that Axis Bank cannot withhold the documents, my lord, the argument advanced by Mr. Medora possibly was correct. And the writ petition at the threshold, there can be an issue of maintainability urged there. My lord, I had, my lord, approached the ombudsman under the scheme. There is a procedure prescribed under the scheme, and I can lodge a complaint against a regulated entity, which according to me is a deficiency in service. I did that. The ombudsman passed an order. I am here, my lord, primarily challenging the order of the ombudsman, not the inaction of Axis Bank in returning the title deeds or the, my lord, pledge shares. So, my lord, the argument advanced on the point of maintainability, that I am not a state, Axis Bank is not a state, my lord, should not hold good according to me. And this is, my lord, first, my lord, submission. Then, my lord, he says, my lord, Axis Bank does not discharge any public function, qua the borrower here or qua the petitioner here. My lord, Federal Bank, my lord, after Federal Bank, the law has been, my lord, this part of the law has been discussed at a great length. My lord, it is not correct to say today that just because it's a private bank, it is not discharging any public duty. My lord, under the scheme, the private bank also has a duty as the regulated entity. If the private bank has failed to discharge that duty, my lord, the ombudsman was required to consider whether there was a deficiency in service of the private bank. If that is not, my lord, considered in the right earnest, my lord, my challenge to the decision of the ombudsman cannot be, my lord, dismissed or rejected only on the ground that there is a private bank implemented as a respondent in the writ petition. My lord, the third point, he says there is an alternative remedy, civil suit. My lord, there is the judgments he cite 2008 onwards. Those are, my lord, judgments where there is a statutory alternative remedy. My lord, he says that you can approach a civil court. My lord, I have approached, my lord, the remedy which was available to me, according to me, I had approached that forum. I went to that forum, and once I got that decision, I have come to the writ court, because there is no appellate remedy available from that decision. Had there been an appellate remedy, I should have possibly, or this argument that there is another alternative remedy available, my lord, could have, my lord, been made by Mr. Medora. Then, my lord, he says city has not been made a party. City is a necessary party. Now, my lord, when a borrower repays the dues of the bank, my lord, a facility can be secured by the borrower with his own deeds or by third parties acting as guarantors. Once the facility is repaid, the borrower is entitled to a document called a no-due certificate. My lord, the borrower asks for the no-due certificate from the bank. Bank does not issue the no-due certificate. If the no-due certificate is given by the bank, my lord, the rest is only a corollary to that.
Here you have got the no-due certificate.
No, I have a prayer for that as well, my lord.
So you want the no-due certificate and the property as well as those
as well as the pledge shares. I want the no-due certificate as a corollary release of the securities. And that there is no due in this loan account is an admitted position. Then, my lord, the kindly comes back to the, my lord, clause which Mr. Medora has relied affiliate. Kindly comes to that, my lord, at page 113.
Yes.
My lord, kindly sees 13.3 heading. It's set off. My lord, this clause is being relied to, my lord, try and establish some sort of a right of lien when there is a contract to the contrary. Will that be permissible or not? Now I read, my lord, subclause B once again. My lord, my first submission is this clause does not give right of lien. First, I will read, my lord, this clause. B, in addition to 13.3A above, notwithstanding the payment of any of the loan obligations under the facilities, borrower hereby expressly gives the bank the power to appropriate proceeds out of any and all security interest created in favor of the bank under the security documents or deposited with it, or under its possession or control towards satisfaction of any amount due to the bank on account of another agreement or transaction entered into by the borrower or any of the affiliate of the borrower with the bank. My lord, right to set off from the proceeds is different from the right of lien exercised, general lien exercised by invoking 171.
Explain to me. I don't understand.
My lord, right to set off is once, my lord, during the, my lord's continuance of the agreement or when the, my lord, loan was repaid, security, my lord, some security interest created in respect of an asset is being, my lord, encashed. At that stage, there is, my lord, proceeds are being recovered. My lord, either the borrower or the person who has created the security interest can approach the regular forum to, my lord, seek any kind of an order. Then, my lord, the question comes whether the proceeds can be set off against the dues of the bank in respect of another entity who may be an affiliate of the borrower. Whether that right to set off the proceeds realized from that sale can be, my lord, exercised or not. My lord, right of lien is, my lord, only to withhold the security documents. The general lien under section 171 is only to, my lord, withhold the security documents. Now, if that is understood to mean that under the exercise of this power, my lord, any facility granted to any other entity can be, my lord, also, my lord, exercised.
An affiliate.
Has to be an affiliate. Now, my lord, what is the definition of affiliate?
The nomenclature set off has been used.
Yes.
But the expression here, the words used are security documents or deposited with it under its possession or control.
My lord, power given is power to appropriate proceeds. The language is the power to appropriate proceeds.
Yes.
My lord, lien is a right before that.
Very well.
Lien is a right which I exercise, I withhold the documents. Set off is not, my lord, lien. In exercise of your right of lien, if you take steps, my lord, parties can go to forum and, my lord, challenge those actions.
How can this be implemented without a lien? Without withholding those
Cannot be, possibly cannot be. What
Because
I am on is,
if you have to have the appropriate proceeds out of those,
yes,
those have to be retained in the first place.
So the first thing which the bank, when bank is exercising this right,
it's a greater power.
It is a greater, I understand, my lord. That is why I am saying the language is, my lord, power to appropriate proceeds. So if you have a right of lien, lordship, what is troubling your lordship is if you have a right of lien, you are exercising that right. And if there is still a default,
This gives
you
the
are
power to appropriate the proceeds from those documents.
security documents.
Yes. So that's a greater right than keeping those, retaining those. They have to retain that first and then appropriate the proceeds out of the sale of that.
My lord, if that, my lord, lesser right is not recognized,
yes,
if that lesser right is not recognized, and my lord, I have a contract to the contrary, will this override that contract? Because I'll indicate, my lord, the pledge which was created initially was no longer continued in their revised sanction. They did not continue with that. The only collateral kept was, my lord, the property. My lord, first comes to, my lord, page 83. I showed this, my lord, but I did not show one provision. Kindly comes to page 83, the sanction advice. My lord, clause 6, I referred to collateral security. Lordship has found that pledge over 29.99% shares of ICNCL held by so-and-so in compliance with the extent regulations. Pledge to be released up on perfection of all other stipulated securities. This is the language, my lord. Now comes to, my lord, the agreement at page 115. Clause 13.10. Because he is relying on this clause, set of clause, from the agreement itself. Now sees 115. 13.10. This agreement shall supersede all prior discussions and representations between the parties, save with respect to any terms and conditions contained in the sanction letter. 83 is the sanction letter, which are not expressly included in this agreement and are more stringent in comparison to the conditions contained in this agreement, in which case such condition in the sanction letter shall be binding on the parties and shall also be deemed to be included in this agreement by reference. If this is the provision in the agreement, that clause in the sanction letter is incorporated by reference. They were bound, they were obliged to release the pledged shares, my lord, the shares which were pledged by city. Now, my lord, the next point.
Yes.
Judgment. My lord, now I will, my lord, deal with the, my lord, judgments, my lord, which he has referred to.
Sir, Dr. Before proceeding with that, let us
171,
come to the, no, let us not 171. Come to the definition of pledge.
Yes.
Let us come to that in the Contract Act. Forgotten the section. You have to remind me.
Yes, my lord. My lord, pledge is 172. My lord has 172, my lord.
Yes.
Pledge, pawnor and pawnee defined. Bailment of goods as security for payment of a debt or performance of a promise is called pledge. The bailer in this case called the pawnor, bailee is called pawnee. So I'll just read, my lord, the first sentence. Bailment of goods as security for payment of a debt. My lord, here, my lord, the sanction advice is very clear. The pledge was created for payment of a debt. The debt was of petitioner. And it also said, upon perfection of, my lord, security, the sanction advice said, upon perfection of the security, the pledge would be released. And it is their document. They themselves, my lord, incorporated this term. And this agreement is also, my lord, prepared by the bank. Clause 13.10, which I just now referred to. They say that this clause, if the clause in the agreement is stringent than the clause in the sanction advice, the clause in the sanction advice would be deemed to be incorporated in the, my lord, loan agreement. My lord, my understanding, this is my understanding of 171. My lord, general lien, if I had other facilities, I had, my lord, given, my lord, for security, my lord, documents, security documents, you possibly could have exercised the right of general lien. Not for, my lord, dues of city. Now, my lord, the judgments quickly, my lord. 2008-12 SCC 675. This is a case where there is a statutory alternative remedy.
Yes.
My learned friend has, my lord, cited 37 and 38. I am not for a moment suggesting that the court does not have the power to decide issue of maintainability post affidavit. I am not saying that. My lord, this judgment was on the proposition that if there is an alternative remedy, this issue can be urged even after affidavits, despite the court at the first instance not recording this observation or not, my lord, creating reserving this point. So, my lord, if there is no statutory alternative remedy, this, my lord, proposition will not be applicable. The remedy which was available to me, I had availed of it. And, my lord, there is no appellate remedy which the scheme itself says, since it is under 16(2)(a). My lord, the second judgment he cites is Federal Bank. My lord, paragraph 33, the sentence which lordship pointed out, is, my lord, the reason why, my lord, the writ petition should not be rejected on the ground of maintainability. Coupled with the fact that I am not here impleading Axis Bank only as a party and asking for orders against Axis Bank. I am challenging the order of the Ombudsman in allowing Axis Bank to retain the title documents and the security documents. So, my lord, paragraph 33, there is one sentence, my lord, if lordship permits me, otherwise, my lord, there is one sentence in paragraph. The sentence which lordship read out, public duty and public function.
Yes, yes,
that is the, my lord, relevant, my lord, consideration according to me.
You are focusing on the Ombudsman.
I am focusing on the Ombudsman. My lord, I cannot challenge that order anywhere else.
That takes care of the other
aspects, yes. The third, my lord, decision he cites And the scheme itself says it's, my lord, under the statute. So ombudsman is discharging a statutory function. Writ petition against the ombudsman is of course maintainable. RBI did not take the issue of maintainability, that point of maintainability. My lord, the third judgment, 2023 SCC Online, Delhi 92.
Yes.
My lord, kindly comes to paragraph, my lord, he has cited, my lord, 21 and 22. My lord, kindly permits me to read 15 and 17. Paras 15 and 17. The court here did not intervene because there was no perversity in the order. The reason is recorded in 15 and 17. Banking Ombudsman of RBI with a order dated so and so, while rejecting the complaint of the appellant herein, has relied on clause 11.2 of RTGS regulations. In terms of 11.2 of RTGS regulations, credit under customer transactions received by RTGS member in its settlement account through the RTGS system has to be ultimately credited to the account of the beneficiary on the basis of account number in the payment message. Payment message receiving may put in place a straight-through processing mechanism for crediting beneficiary's account. Beneficiary receiving bank have to credit the account of the beneficiary customer.
Mr. Doctor, actually in paragraph 22 also it has been stated by the court that unless decision is perverse.
Yes.
So if there is perversity, there will be interference.
Yes.
That is what is.
Lordship may take note of the distinguishing feature in 1517 and of course, my lord, 22.
There was a detailed order there in that case.
Yes, there was. There was. My lord, paragraph 15 is the reasoning recorded. My lord, the one which ombudsman had found, that is being recorded by the Delhi High Court.
Yes, yes. Clauses were relied on.
Yes, yes. It was a detailed order. And here it's just an email, my lord, 2-page email. They really quoted the submission of bank in paragraph 2 of that order, the second page of that decision, which I am challenging before your lordship. The next decision, my lord, cited is 1994, 3 SCC, my lord, 552. My lord, paragraph 22 was cited. Kindly takes, my lord, para 22.
Yes,
we are unable to
governed by contract. Writ petition is not maintained.
Yes. So I am, my lord, here, like I said, if I had challenged, my lord, the decision inaction on the part of Axis Bank, I was governed by the, my lord, terms of the contract. Here, my lord, he could have, my lord, come and pointed out that there is a scheme, there is an ombudsman scheme, there is a remedy provided under the scheme. There is a, since that is having a statutory flavor, my lord, alternative remedy argument could have been, my lord, or made, my lord, by the bank. Now at this stage, when I have crossed that, my lord, stage, this argument would not hold good.
All the judgments on maintainability are dealt with by this submission.
This submission, my lord.
If your primary challenge is against the ombudsman order, then
yes,
these do not.
Yes. My lord, on Lien, my lord, he first shows 1992 2 SCC 330.
Yes.
My lord, kindly takes the first the judgment where it starts, my lord, internal page 5. Placitum E and F. 1992, my lord. 1992 2 SCC 330, my lord. Internal page 5 is where the judgment starts, my lord. Kindly takes note of the fact, Placitum E and F.
Yes.
On
internal page 2.
Internal, my lord, page 5, which is the, my lord,
which paragraph?
It's the first paragraph of the judgment where it starts. Placitum E and F, my lord, I'll read.
Yes.
It starts on September 17, my lord. On September 17, 1980, respondent number 3, partner of the judgment debtor firm, deposited by way of 2 FDRs, so and so respectively, after duly discharging them by signing on the reverse. FDRs were to mature on so and so. 2 covering letters were also executed on the bank's usual printed forms on so and so. As per the recital in the said letters, judgment debtor agreed that the deposits and renewal shall remain with the bank so long as any amount on any account is due to the bank from them, that is Jalandhar bodybuilders. So this is, my lord, the letter of lien that was given by the party concerned. Now, my lord, the next paragraph distinguishing, my lord, kindly come to para 6. My lord, he has also placed para 6. My lord, the first part, Halsbury's Laws of England, has been quoted. Lien in its primary sense is a right in one man to retain that which is in his possession belonging to another until certain demands of the person in possession are satisfied. Now, these demands have to be qua that person.
Yes, in the next paragraph also may be due from such custom.
Yes, last paragraph, kindly sees, my lord, chitty on contract, last paragraph.
Yes.
Lien is applicable to negotiable instruments which are remitted to the banker from the customer for the purpose of collection. When collection has been made, proceeds may be used by the banker in reduction of the customer's debit balance, unless otherwise earmarked.
But he is relying on pledge agreement to say that the agreement was with.
So whether, my lord, the pledge could have been, my lord, continued because of 83 read with 113. They say if there is a stringent provision in the agreement, the sanction advice would. So under the sanction advice, they were not even entitled to continue with the pledge. Now, because it was continued, they say, no, I have a right. Next judgment, my lord, Delhi. 2016 SCC Online, Delhi 4726. Para 1 is, my lord, clear. Petition seeks a mandamus to the respondent syndicate bank to release title documents of property bearing plot number such and such deposited by the petitioner to secure repayment by the petitioner of the dues of the cash credit limit availed of by the petitioner in the name of the petitioner number 2, of which petitioner number 1 is the sole proprietor. In these facts, my lord, my facts are completely different. Here, my lord, the entity was the same. Para 9 kindly comes to, my lord, para 9. There is another important fact which distinguishes the facts of the present case from the subject matter of the case before Orissa High Court. Here, the respondent bank has a recovery certificate against the petitioner. Once recovery certificate has been issued in favor of bank against the petitioner, the distinction which Division Bench of High Court of Orissa sought to make between the principal debtor and a guarantor surety ceases to exist. As of today, petitioner is the debtor of the respondent bank. And if it were to be held that notwithstanding the same, respondent bank is not entitled to exercise the right of general lien over the title deeds of the immovable property of the petitioner in lawful custody of the respondent bank, it would be as good as giving a go-by to the right of a banker of general lien, and which in my humble opinion would be detrimental to the interest of the bank, on which carrying on a large trade and business depend and resultantly be prejudicial to trade and commerce. So it was the petitioner's dues. Well, there was a recovery certificate and the petitioner's property was given to the, my lord, bank. So question of, my lord, bank not exercising general lien in these facts did not arise. Hence, my lord, this is not applicable in the facts of my case. My lord, the last decision, my lord, the last decision, my lord, he cites is 20. No, this is, my lord, the Madras.
Madras.
Yes. My lord, kindly comes to paragraph 2.
Yes.
No. Petitioner had stood as a guarantor. Petitioner had stood as a guarantor for a sum of rupees 25 lakhs availed as overdraft facility by one G. Mahendran from the respondents and had deposited the documents of title which he is seeking to be returned. Loan of G. Mahendran was discharged and letter of clearance was also given. During subsistence of the guarantee, petitioner himself obtained an overdraft facility to the tune of 35 lakhs and had executed another mortgage by depositing title deeds, value of which is equivalent to the overdraft facility extended to him. According to the petitioner, the said property satisfied the security of loan extended to him. Petitioner is now claiming return of the said document which he had given as security for the OD facility availed by G. Mahendran, which is discharged in full. So, my lord, the same gentleman who was the borrower of the bank, my lord, he initially acted as a guarantor, then he took loan and, my lord, deposited the title deed. There, my lord, now kindly comes to, my lord, the reasoning at paragraph 9. My lord, in fact, my lord, kindly permits me to read 6 also. Therefore, the question that would arise for consideration in the writ petition is whether bank is empowered to exercise its powers under 171 of the Contract Act by extending banker's lien over the property which was given as security for the credit facility availed by G. Mahendran, though admittedly is discharged. Then 9. It is not the case of the petitioner that general lien that is exercised by bank is for the borrower of a third party for whom he had given the security, but it is for his own credit facility that was availed by him. Now, if in this situation, my lord, ICNCL had, my lord, availed of further facilities from Axis Bank, bank possibly could have said that despite you giving me additional security, I am still going to hold on to the property. I am still going on to hold on to the pledged shares. That is the, my lord, banker's lien he is exercising, qua the person who is, my lord, availing facilities, and there may be
Because the guarantor had put in his own title deeds in
Initi-
his overdraft facility.
Initially.
But those did not satisfy the overdraft facility. That's why it spilled over to the other documents given by the
No,
other.
that is why kindly comes back to, my lord, paragraph 2.
Read it carefully.
Petitioner stood as a guarantor. Initially, he stood as a guarantor for a loan availed by G. Mahindran. G. Mahindran's loan is
G.
settled.
Mahindran took a loan.
Yes.
There are certain deeds of the guarantor were also pledged.
Yes.
Rather mortgaged.
Mortgaged.
Now, the
G. Mahindran's
guarantor
facility is repaid.
Guarantor himself took
a loan.
That took an overdraft facility.
Yes.
There he produced his own title deeds, separate title deeds.
Yes.
But ultimately that overdraft facility was not met by those title deeds. His separate title deeds.
Correct.
Therefore, although this loan was discharged.
So, yes, absolutely. So, my lord.
Spilled over and these were, a lien was held to.
Correct. So, my lord, why was this right of lien exercised by the bank in this case? That is why paragraph 9
What is your case? In your case, that pledge agreement was given regarding the shares.
In my case, first is there is no due at all.
No.
There is no due at all. Second is pledge agreement. My lord, in terms of their advice, they were required to release. Once the title deeds were given,
yes,
they did not release it.
They say they still have a claim against city.
They may have a claim against city. My lord, they are also pursuing against city. My lord, that is not a consideration for this court. Why I say this? Because, my lord, today with the present facts, the court is looking at a situation where whether the ombudsman was correct in recording that there is no deficiency in service. Deficiency in service is this, my lord, Axis Bank retaining the securities which were given to meet a particular credit facility. Once that credit facility is repaid, my lord, this right, the circuitous manner in which, my lord, banker's lien right is being exercised to retain securities of, my lord, the pledged shares, but that is not proper.
General lien is always circuitous.
My lord, only if it is
to be by definition.
This can be exercised. My lord, this judgment in fact aids me. Paragraph 9, if lordship kindly reads once with me, my lord, paragraph 9. It is not the case of the petitioner that general lien that is exercised by the bank is for the borrowal of a third party. This is the case here. General lien is being exercised for borrowal of a third party, for whom he had given the security, but it is for his own credit facility. My case is, it is not for my own credit facility that bank is, my lord, exercising general lien.
His own means city. That his own in this judgment is equivalent to city.
His own means the petitioner's own credit facility here. Kindly, my lord.
In your case, it will be replaced that his own will be city. Because there, the person equivalent to city was making this claim. He said, give me back my title deeds. Because the loan of the borrower has been met. That was refused. Now here his own, this his own is city zone. You read it as city.
My lord, gives me 1 minute.
They just change the perspective, yes.
That's what I'm checking. Is for the case of the petition.
The guarantor had made the application. Give me back my title deeds regarding the other loan.
Will your lordship kindly take para 9 once? I'm sorry to bother you, lordship.
No,
kindly
no
para
question
9.
of bothering. Yes, para 9.
I'll read it very slowly for my understanding. I'm sure my lordship has a point there, but I'll just try to understand this. It is not the case of the petitioner. Petitioner here is the guarantor.
Mr. Datta, before, yes, petitioner is a guarantor.
That the general lien that is exercised by the bank is for the borrowal of a third party. Up to here, there is no problem. For whom he had given. He here means the petitioner who is the guarantor. For whom he had given the security, but it is for his own credit facility. So now, not only he was, my lord, in two capacities he was there. Guarantor for G. Mahindran's, my lord, loan, and, my lord, borrower for his own credit facility. But it is for his own credit facility that was availed by him. So banker's lien, bank was exercising to, my lord, meet the credit. Therefore, if it were to be held that without the borrower expressly agreeing that his property is deposited with or in the custody of the bank be utilized for recovering the dues of the bank for which he is liable, the term general lien itself would be inapplicable.
There would be no question of general
correct.
lien.
So the dues which were yes, absolutely. So the dues which were still pending here was the dues of the petitioner who was in the capacity of a borrower who had taken this loan. Therefore, banks exercise the right of general lien and not only retain the security documents in respect of his loan, but also
equivalent in your case, if city came here, city made the application and said that yes, for my loan I had put in my
yes,
title
yes,
deed.
Lordship is correct. Now I
That's where
yes, Lordship is correct. I
that
got it.
I have put in my
Yes,
title
yes,
deeds.
yes, yes,
This
yes.
is regarding another contractual agreement, and the court
To
says
that extent,
no.
if city had
Otherwise,
come,
there won't be any
yes,
general
absolutely,
lien.
absolutely.
That is what I'm saying.
Mr. Mukhopadhyay wants me to show one last page, page 53.
You have to read it. I won't follow you.
I'll read it, my lord.
That is the right.
59 of AO. Only one document, page 59 of AO.
Yes, what does it say?
This is, my lord, 16 January 23 letter. Axis Bank writing to City Network. They have disclosed. My lord, my lord, last sentence. We accordingly urge SNL to play, SNL is City Networks, to pledge.
59 of AO.
Page 59 of AO.
Page.
Yes.
Yes.
Page 59 of AO. We accordingly urge City Networks Limited to pledge shares of 2 crore 59 shares of 25911, the same shares of ICNCL held by SNL to the facilities extended by Axis Bank to SNL. So if you proceed in this manner and you are asking City Networks to pledge the shares which you had in ICNCL, you are asking him to pledge the shares now, then this contention does not hold good. It is their letter, my lord, January 2023. And with regard to the property, they have no right of lien with regard to the property, because there is no dues with this person, the petitioner here. So this exercise of banker's lien or the concept of invoking banker's lien here to retain onto the title deeds, absolutely, my lord, there is no right of bank. These are my respectful submissions.
Can I just say two things, my lord?
No, what two things?
Since he's shown new clauses in the agreement. That's the
No,
only
no,
reason. He's shown new documents.
I was meeting his point. That is the reason why I showed the clause.
Well, I just indicate one thing. So far as the agreement, the clause which he's relying on, my lord, very clever interpretation given by Mr. Datta at page 115,
yes,
where he talks about the entire agreement, my lord. Well, firstly, my lord, he's relying on, my lord, the sanction letter. The sanction letter is an earlier document, earlier in time, earlier in date, where it has that clause that the pledge will have to be released at the time of payment or something to that effect. But there have been subsequent agreements, the term loan agreement, as well as the pledge agreement, where this clause does not find any place. So clearly that was not the intention of the parties. What is relevant today is the pledge agreement. That is where any right in respect of these shares flow. The term loan agreement, which makes a reference to the security being created, is more like an agreement to pledge. And
in your opposition, have you specifically stated regarding the details of your the loan taken by city from you?
Yes, yes, I've said.
Give me the
how much is due. I've
give me the
mentioned also. I'll just indicate that. Just kindly give me a moment.
Just give me the paragraph.
Yes. Now, my lord, Mr. Datta also relied, my lord, on clause 13.10 at page 115.
Yes.
Where he says that if there are conditions which are more stringent in the sanction letter, then those will be made applicable to this agreement. Question which arises is, more stringent to who? He has not answered that. He assumes that if it is more stringent to, I don't know what he assumes.
There is only one more document prior to this loan agreement. 29th March is the sanction letter. This is 30th March.
Yes.
So more stringent to the sanction letter, obviously.
Let us conclude it now.
So he says that if the terms in the sanction letter are more stringent, that is, the documents should be replaced upon perfection of other stipulated securities, then it should be read.
It is not a rehearing of the matter.
Very well.
Hearing is.
But this clause is not there in any of the other agreements.
Hearing is concluded. Judgment is reserved.
Grateful, madam.
Let us call on.
I'll just indicate the paragraph numbers, my lord.
I'll find it out.
I'll just.
অনন্তকাল চলবে এটা স্টেপল করে দিও কিছু
Page 16 of the
item 3.
opposition.
I'll find out. Page 16. Very.
I'm grateful, madam.
Yes.
Item 3.
Wow, it was time like.
Lordship would like any written notes? I don't think so, but.
My lord, I appear for the petitioner. My lord, this is the third round before my lord. Yes. Because lordship will remember, my lord, this is that matter wherein lordship had held that, my lord, the 35A will, 32A will apply, and my lord, there cannot be, my lord, any claim once, my lord, a party has taken over through CIRP. Now, my lord, that judgment went up to the Supreme Court and it's, my lord, upheld. Now, my lord, thereafter, there was a writ petition filed by us, whereby there was a contempt and then a writ petition filed by us, whereby, my lord, we were saying that they're not giving us connection, neither giving us NOC nor connection. Lordship directed us you will give them connection, you have to put in the security amount as to be put in. We have put that in, my lord, it is there. Now, my lord, the issue in this writ petition is somewhat different. Here, my lord, what is happening is that I belong to an area where there is no DVC. I'm going to start my industry, my lord. The tariff, my lord, in the DVC area where he's operating is lesser than, my lord, the tariff in which, my lord, he has a dominance. So that is what I've challenged. Now, my lord, the first issue is that there is a can because, my lord, after the filing, Vasavi has merged by an operation of law by an yeah, there is a can application. Oma, Shiki. But may I just indicate, my lord, it's a very, my lord, I don't think after
If it's a longish hearing, I think I'll put it at 2 p.m. on any date which suits both of you. Because
it won't be a longish hearing. I don't think so, my lord. First, my lord, first thing is that, my lord, the can is for, my lord, lordship knows there is a merger, amalgamation. Now, my lord, for that, the name of the petitioner has to change. So that's the only point in the can, very technical, but I don't think to that Mr. Kaur will have an objection to.
When did it change?
It-
Was
it has-
before filing the
No,
writ
no, no.
petition or after filing the
No,
writ?
no, no. After filing.
কি বলছি রে?
আমি বলছি after.
Who is that? Oh, Nirmal. No, no. As I said, my lord, it is after filing. So,
But
so my
you
lord,
get a-
absolutely, absolutely. I'm saying, my lord, it is a very technical issue. Mr. Kaur is well aware of it. If, my lord, Mr. Kaur is opposing to it, then I can come back 2 p.m. on any day. Otherwise, this order can be passed and we can come back on 2 p.m. on any day, lordship wants. Lordship, you can see the prayer.
When did the merger?
It is after filing.
It is at page 8 of the IA.
Kindly
Page 8 of the can.
order.
Page 8.
I have
Page 8.
endorsed the order itself.
Page 8 of the can.
Page 8 kindly takes it. It's a very, my lord,
30. Yes, 30th November 2023.
2020 and kindly takes the affirmation date of this writ petition.
Writ petition is October 2023.
This is of 13th of October 2023. So it is after. So it's very technical. That is why I'm saying I can make this, my lord, correction or amendment and come back before my lord with
But I'll allow this application.
I just had that question whether
Definitely.
as on the date of
Yes, yes, of course,
Definitely.
of course. Otherwise, I'm not entitled to.
So I'll allow this application, permit them to carry out the necessary corrections.
And come back any day
Give
at
me a
2
date
p.m.
when both of you will come
Lord,
back.
there are two issues. Lord, the one is that Lord, this is not relating to fixation of tariff. Therefore, Lord, the regulator, the Electricity Regulatory Commission is a necessary party. So, Lord, the Regulatory Commission should be implemented. This is one.
What is the other aspect?
The other aspect is, Lord, there is no scope for any interim order. Because, Lord, the regulator permits where there are multiple licensees, they can, Lord, fix their rate. Maximum rate is fixed. They can supply at a lesser rate. And that is what the statutory provisions is also under the Electricity Act.
Oh, you've asked for a mandamus to revise the
Yes, I have.
Then
I-
direct affidavits, short affidavits, and
Yes, then short affidavits and
I'll allow
fixes
the
any day at
application
2
right
p.m.
now.
on-
Yes, I think.
Yes.
So how long?
The regulator, Lord, should be made a party because, Lord,
Implement the
Yes, I will not. I will not.
That will
Those
be easier for
technical
all of
issues
us.
I'll not stand.
So I'll permit you that. Can 1 of 2023. The present application has been filed for alteration in the name of the petitioner in view of a subsequent merger of the petitioner with one Rajadhiraj Tirupani Vinayak Nataraj Private Limited, page 80 page. Full stop.
আর নাম পেলি না ছোট?
Since such merger has occurred during pendency of the writ petition, comma, can 1 of 2023 is allowed, comma, thereby altering the name of the petitioner in terms of the prayer made in the present application, full stop. Liberty is granted to the learned advocate on record for the petitioner to carry out the necessary amendment to the cause title of the writ petition during the course of the day accordingly. Full stop, no arrest to cost. Full stop, next para. At the outset, comma, learned senior counsel appearing for the respond number 2
Yes.
takes an objection as to non-joinder of necessary party to the extent that the West Bengal State Electricity Regulatory Commission West Bengal Electricity Regulatory Commission has not been implemented, which since our tariff order has been challenged, comma, the said entity is a necessary party. Full stop, next para. there is substance in such contention. Full stop. Accordingly, the petitioner is directed to implead the WBERC as a party respondent to the present writ petition. Full stop. Necessary consequential amendment to that effect as well shall be carried out by the learned advocate on record for the petitioner during the course of the day. Full stop. Next para. The writ petition না the respondents are এটা হয়ে গেল হ্যাঁ এরপরে রিট পিটিশনের উপর অর্ডারটা হচ্ছে the respondents are directed to file their affidavits in opposition within 3 weeks from date full stop reply if any shall be filed within a week thereafter the matter shall be listed in the monthly combined list of cases for March 2020.
Then, my lord, again I have to come and mention this was what I was fearing, my lord. I don't want to get into that, my lord. And lordship will scold me for not mentioning.
In the monthly combined list না করে তাহলে
any day at 2 p.m. my lord.
On March 6, 2024 at 2 p.m.
Great. My lord, only one prayer I have, one prayer. Instead of, my lord, by today, as my lord lordship can may
alteration gulo by
both, my lord, by Tuesday. Both by Tuesday, because of the reason, my lord, which is on the screen, my lord.
Yes.
Just one direction, Lord.
Just let me carry this.
I'm sorry.
ওই যে দুটো দিলাম দুটো অ্যামেন্ডমেন্টই হবে বাই টুডে না করে বাই February 6, 2024.
Grateful.
Yes, Mr.
Lord, let them serve a
Yes, of course. Of course.
First title. Because, Lord,
both, my lord, I'll do. Both I'll serve on them. Of course.
The petitioner shall serve a copy of the amended cost title of the writ petition within a week from date.
Very well. I will.
Yeah.
Grateful.
Grateful to you.
Yes. Mr. Dasgupta is satisfied? You're the most vociferous of all of you.
The most important point.
Most important. Yes, correct.
Item 4.
Yes, Mr. Doctor.
My lord, on previous occasion, my lord, your lordship was pleased to formulate, my lord, the query and the issue, my lord, which is required to be replied by my learned friend. Prior to that, my lord, only I want to cite a one decision because, my lord, in reply, I would not be permitted to place the decision, and he will say that, my lord, in reply.
Let him say first. Then.
Okay, my lord, let him say.
My lord, I'll formulate my arguments, my lord, this way. Number one is, this is a concluded contract which was in the course of performance. And performance, my lord, came to an end. Contract is not, my lord, discharged because payments under the contract remains a dispute. So, my lord, contract is not discharged, performance comes to an end. At this juncture, my lord, parties have claims against each other. Writ petition is filed, my lord, seeking monies which they claim, my lord, is due to them under the contract. Two, my lord, two compartments. One, my lord, is my client's delay in finalizing, according to, my lord, my client, what is the billed amount? What is to be the receivable amount? There is an abject delay over there, which your lordship, my lord, was pleased to recognize, and your lordship directed us to do it immediately. That is, my lord, most definitely, my lord, amenable to a writ court's, my lord, jurisdiction. Because it's an arbitrary act to, my lord, not pay somebody. The second part of it is, my lord, an adjudication as to how much is payable. That, my lord, perhaps your lordship, unless it's very clear, my lord, from the facts of the case, your lordships may not be, my lord, willing to go into. So, my lord, I would submit, my lord, that in this writ petition, the first compartment, my lord, that I must do what is necessary from my part to ensure that they can, my lord, at least crystallize or somewhat quantify their claim. That, my lord, your lordship has already permitted. The second part, my lord, may be left out of this because that is
adjustment for other contracts,
including adjustments for other contracts. That part of it, my lord, the question of adjustment, your lordship may be pleased to decide. My lord, there is no difficulty in deciding that.
No, I don't understand. What part are you asking me to decide now?
My lord, my submission in short is this. Your lordship has already recognized delay on my client's part, and your lordship has directed, and my client has done the necessary for him to now realize that this is his claim and this is my adjustment. A little part of his claim is still being ascertained, but around 85% is ascertained. Now, beyond this, if he wants something, he has to go before a civil court. That's not what I was coming to. Because it relates to, Milord, certain other issues on quantifications, assessment, etc., which your lordships do not do
Then
normally.
the entire thing has to be sent to the civil court.
Yes, because I have, where I was in default.
According to your stand, something is due from them to you, rather.
Yes, it will be. Secondly, my lord, your lordship's question was that when you have quantified and he's filed a writ petition and then you have quantified that certain amount is payable, are you entitled to, or is it not arbitrary for you as an authority to later come and say that I have a further my lord, claim? Whether that, my lord, is permissible. To that, my argument is, my lord, cause of action under a contract, my lord, merges in the decree. In this case, it would be, my lord, an order being passed.
So you say the relevant point will be the date of decree. Before that, whatever arises can be adjusted.
I can always adjust. My rights may be curtailed by procedural laws, by an admission.
Mr. Datta, instead of a piecemeal adjudication on that, why not relegate you to a civil suit? I mean, in any event, the dues you'll have to substantiate by evidence. Whatever are the dues, you'll have to substantiate by bills. You have to prove those documents. At least prima facie, you have to at least tender those documents. And they are entitled to refute those. So go to a civil court. I'll keep this question also open to be decided there.
Milord, my respectful submission is this. Previously, Milord, lawyers was settled that the writ court does not entertain. There is a development. In the development, Milord, it has come that the respondent authorities, the state authorities, cannot camouflage saying that I am having a demand. Suppose, Milord,
So then you are otherwise satisfied with whatever they are saying are your dues. You are satisfied with that, yes, I admit that these are my dues.
There is
apart from those subsequent claims.
Look, kindly appreciate, Milord. Which is on record, they are saying that I have a demand of 1 crore 72 lakhs. Apart from this, nothing is on record. If that would be adjusted, in that event, I am entitled to the rest of the amount. So, Milord, so far as the MP development is concerned, the recent decision which has been passed.
Continue then, yes.
My
এটা দুটোর সময় কিছু আছে ফিক্সড আছে কালকে কি ছিল that gets precedence over everything.
Every other matter.
Should I take it continue? Yes, after that matter, if you get time, continue.
If I miss, Milord, I'll come tomorrow, Milord, if your lordship.
Yes, obviously.
As per a
Milord, tomorrow I am having a difficulty because I will be outside.
If you are in difficulty,
Both
after
try to come today and finish it. Milord.
Yes, if it is possible, then come. If not possible, then we'll grant adjournment. Come back tomorrow. No difficulty.
part had matter fixed at 2 p.m.
Yes.
Item 25, 26.
My lord, may I file the corrected copy, my lord?
Notes of arguments?
My lord.
Yes. Yes, Mr. Mujumdar.
May I continue? But if your lordship kindly takes my affidavit in opposition for once.
Opposition.
But I have already taken your lordships to the minutes of the meeting.
Give me half a minute.
I'm sorry. I'm
Could
sorry.
I take today's written notes of arguments and
Yes, ma'am.
discard the
Today's.
previous
Yes,
one?
ma'am.
Very well. I'll just put a cross on this. Sorry, Mr. Mujumdar.
No,
Yes.
it's mine.
You are respond numbers 1 and 2. So
Yes, my lord.
yes, your opposition.
My lord, if your lordship kindly takes my opposition, I've already taken your lordship to the, my lord, the minutes of the meeting held on 8th November.
Yes.
Kindly take page 27. What did the registrar or the returning officer did immediately? The returning officer wrote to the additional secretary, Department Government of West Bengal. Page 27, my lord has got that.
Got that. Yes.
May I just read it out? This is the prayer for seeking advice on extension of last date of voting paper dispatch, voting papers receiving and counting of voting paper of the council election during the year. I would like to inform you that I was appointed by you, video memo number so-and-so, as the returning officer to conduct election of West Bengal Dental Council under section 21A and 3A. Well, 3A is not happening now. Undoubtedly, because in view of the direction given by DCI, the elections to the election of members to DCI. Yes, that part is gone. But due to some unavoidable circumstances, it is not possible to dispatch voting papers within 10th November 2023 by registered post. In the circumstances, it is my earnest request for your valuable permission to extend the last date of voting papers dispatch, last date of voting papers receiving, and starting date of voting papers counting for the council election purpose. So, my lord, the timeline which was fixed and indicated, provided for in the notification dated June 14, 2023, that timeline now needs a tweaking.
Yes, this is one of the sticking points also.
Yes, madam.
Whether it can
May I
be
just
extended.
broadly give the three issues, outline the three issues, which are now which are now arising for consideration by your lordship. Issue number A is that whether the returning officer has the competence, authority, or jurisdiction to extend the timelines.
Yes.
B, my lord, whether this change of post office for the purpose of dispatch of voting papers, whether it is permissible within the frame of the statutory framework or regulatory framework. 3, my lord, whether the state government could have issued an order including vice president as one of the signatories for the purpose of issuance of checks.
Yes, in the second point, behind the second point, there is an insinuation by the petitioner also that there was some force acting against you, some compulsion.
My lord, I tell you, lordship, my lord,
which was the reason for
my lord,
this?
I tell you, lordship, that is why, my lord, I will deal one by one with your lordship.
You proceed in your own way, but that keep that also.
I
in
will
your-
obviously.
Those emails written by you previously.
Yes, emails written by me. My lord, I have to stand by my emails. Well, as a statutory authority and as a responsible official of the Dental Council,
Yes.
I have to stand by my emails.
So that is the backdrop.
That is the backdrop.
Yes.
My lord, there may be a clamor. My lord, clamor was not warranted. But if there is a reason which is sufficient enough to change the post office, my lord, kindly, your lordship, may I take that issue first? Because my lord, that is perhaps one of the most important issues. Though, according to me, in my most respectful submission to your lordship, that is, my lord, that is the most trivial issue. Which post office a returning officer will pick for the purpose of dispatch of voting papers is within the exclusive domain and jurisdiction of the returning officer. Because my returning officer has been vested with the power to conduct elections. So the superintendent's control and direction for the purpose of election vests in the returning officer by operation of law, having regard to the rules framed for election by the state government under section 55 of the act. Because I will show to your lordship that the returning of only the registrar could be appointed as returning officer. Now, my lord, what was done? Previously, it was decided that the voting papers would be dispatched from Newtown Post Office. Then, my lord, there was a decision
returning officer that GPO is
Yeah, and it was taken that this decision was taken on the basis that the GPO will not be in a position to dispatch voting papers for certain technical difficulties. Now, my lord, if we take historically all along in all elections, the voting papers were dispatched to the GPO.
So was your office situated nearer to the GPO then?
Yes.
Because transit
Absolutely.
because transit may
Yes,
also
I'm
create
bound to answer that. Absolutely.
problems regarding this manipulation.
That may create a problem.
Yes.
Yes,
Not
my
only a
lord.
problem, there may be
Logistic
situations-
problem.
logistic and manipulation also.
Manipulation also in transit. That possibility is always there. So, it is the duty of the returning officer who is to ensure that the elections are conducted freely and fairly.
Right.
And that is this transmission, this dispatch of voting papers is an integral part of that duty.
Yes.
Now, having regard to that aspect, let us take Newtown Post Office. If proximity is the issue which may bother the petitioner, that look, GPO is so far away, Newtown is the nearer post. Very interestingly, one expression has been used in the affidavit in reply. Newtown Post Office is a nearer post office.
Not nearest.
The nearest is the adjacent building, man. There are two post office at Shej Bhavan. So if we take the proximity factor, if it is so decided, I'm always open to direction by your lordship. Because after all,
unnecessarily, why should we?
Yes, then either it can be dispatched to GPO or the nearest post office if we take the proximity factor. And GPO, dispatch of voting papers from GPO, it is somewhat, this kind, it is the dispatch appears to be ironclad because every dispatch made from any post office has to be routed to GPO.
Yes. No, but then it's in course
then
of
it's in the parcel van and all that. Then
yes. that it goes to the post
so,
office.
If we take the proximity factor, it can be the nearest post office or it can be GPO, but not the nearer post office, which is kindly take the distance between Shej Bhavan and the Newtown Post Office. It is not less than 5, 6, 7, 8 kilometers.
All right.
So if the proximity is not the fact,
similar
logic applies. So that takes care of the post office. It's a trivial issue, These issues can be these disputes can be ironed out. These are creases in the entire process. Now, having regard to that, kindly come. May I take your lordship back to the 9? I have outlined the issues. I will answer one by one.
Yes.
The first issue, the second issue, I have tried to answer. I will elaborate it later on. But kindly take what did I do? I immediately wrote to the additional secretary, and the response from the additional secretary is at page 28. In response to your letter, VD number so and so dated 9th November 2023, it is advisable to take necessary action from your end as per existing rules laid down in the interest of free and fair council general elections under section 21A and 3A of the Density Act 1948.
Yes.
So this was done. And then obviously, kindly take the notice for reschedule that your lordship will find at page 29. So the returning officer or the registrar issued a notice for reschedule. But now the elections and of members to the Dental Council of India cannot be held in view of the directive of the Dental Council of India. Now, we'll kindly come to page 30, where the petitioner had written to the respondent, answering respondent had written to the petitioner. Clearly, as per verbal instruction, this is dated November 22, 2023. As per verbal instruction by the Deputy Secretary over telephone yesterday, I would like to inform you that he instructed me to take steps immediately for payment to GPO Kolkata regarding remaining process of the council election through GPO Kolkata. Even he said that the payment document should be produced today before him after completion of signature process for payment to GPO Kolkata. So I request you, to your kind honor, to come today to the council office to put your valuable signature on payment documents to GPO, Kolkata, regarding remaining process of the council election through GPO, Kolkata. Therefore, please confirm me immediately when you will come today to the council office to put your valuable signature on the above mentioned payment documents. Then, my lord, kindly take the next page. The next day also, I wrote a similar mail. There was no response from the writ petitioner. But according to the writ petitioner, as per their affidavit of the writ petitioner, the writ petitioner was out of station in Darjeeling. But unfortunately, the writ petitioner did not even bother to inform the registrar or returning officer that he's out of station. So it is not possible for him to put his signature.
This was emailed.
This was emailed.
Emails can be opened in Darjeeling.
Yeah, they are everywhere, man. Emails can be opened everywhere. But now even in some flights also.
Mr. Basu's client is like Mr. Basu.
Yes, my lord.
But no, he is very savvy.
Yes, he is very savvy.
More on Facebook than on email.
Yeah.
Yes.
This created an impasse. Impasse to the extent that the necessary or the required signatures were not available. The president's signatures were not available for payment to GPO. So this was
just required to justify your powers of extension.
I will immediately do so. Malad, before I do so,
So this is your independent case, apart from answering those.
Yes.
That this non-cooperation was going on from his end.
Yes.
Which compelled you to the rest of the
which compelled me to approach the state government, and the state government
vice president
appointed vice president as an additional signatory.
Yes.
Now, whether the state government can appoint vice president as an additional signatory in violation of the rule 4, that is one of the case made out by Mr. Bose. I have a direct answer from the rules itself. My lord, kindly take, my lord, now the next documents. My lord, I will quickly run through the documents. My lord, kindly take now page 33.
I'm there.
Your lordship will find this is, my lord, the letter written by, my lord, this this returning officer, that during the election process, this was done in the statutorily bound to carry on with the process. I propose to include vice president. My lord, kindly take the third but
I'm looking into that.
Yes, my lord, that portion. So this was my proposal.
Yes.
And then a notification was issued. This notification is under challenge before your lordship, appointing vice president as an signatory, one of the joint signatories.
Cannot be joint if he does not sign.
If it, then my lord, vice president and the registrar will sign. It will be joint in that sense.
Very well.
But not to the exclusion of president.
No, he can also do
He can do it. Not to the exclusion of president. But this is very important.
Alongside.
Alongside.
Yep,
So this is not to the include, only inclusion, not to the exclusion of the president. Kindly take, my lord, page 34. My lord, rule 20, as per the provisions of rule 26, it
Not
should
to
be
the exclusion, Mr. Mujumdar, but unless you exclude him, I mean, without him also, you two can do it then.
Yes. Without
In
him,
that
I
sense,
can.
he is being excluded. Optionally excluded.
Optionally.
At his option.
Yes. If he can sign, he can sign. If he doesn't want to sign, then
His
somebody.
power is not being taken away.
That is not being
Additional
taken.
power is given.
Additional power is given to the vice president,
Right,
in view of the exigency of the situation and the importance of a democratic process of election. Now, Miller, kindly take, this is how Dr. Pradeep Giri, being the vice president, was appointed as one of the signatories. Now, Miller, now kindly take the act.
Yes, quoted rule 26 of the.
It should be section 20. Section 26. It should be section 26.
Right.
Well, kindly take the act. Well,
Yes.
I take you, beseech your lordship, kindly take section 3 first. Well, kindly take section 3A. This is the election of the member to dental council.
But that is no longer.
That cannot be done now in view of the clear directive of the Dental Council of India. Now, Miller, kindly take subsection 2.
Yes.
President and vice president of the council. Miller, kindly take subsection 2.
Yes,
An elected president or vice president shall hold office as such for a term not exceeding 5 years and not extending beyond the expiry of his term as member of the council, but subject to his being member of the council, he shall be eligible for re-election. So, Malad, this is a clear provision in the statute that a president cannot continue beyond 5 years as president. He can continue as member. His status is reduced to the status of a member. It's a clear statutory provision. Well, apropos this, my lord, well, kindly take, my lord, for once, page 79 of the compilation handed up to your lordship by the petitioner.
Yes.
Well, kindly take this one. Mala, this is item 19 or serial number 19, copy of the letter.
Yes.
Dated January 31, 1959, from the Secretary to the Government of India to the Secretary Dental Council of India, New Delhi. Dental Council of India, this was regarding Dental Council of India re-election. With reference to a letter dated so and so and the subject mentioned above, I am directed to say that on expiry of the term of office of Dr. R. Ahmed, Dr. R. Ahmed was then the President of Dental Council.
Oh, this is 1959.
1959. As member of Dental Council of India, the election of the President of the Council should be held even if Dr. Ahmed is renominated by the government of West Bengal as a member of Dental Council of India. In this connection, it is attention is invited to section 6(1) of the Dentist Act, according to which Dr. Ahmed will continue to be a member of the Dental Council of India until his successor is nominated. Notwithstanding the fact he may continue as a member beyond his term of 5 years by virtue of latter part of section 6(1), still in view of section 7(2), he will cease to be president of the council because he can hold office only for such period not extending beyond the expiry of his term as member of the council. The term of membership of the council as stated in section 6(1) is 5 years. So it is 5 years and not beyond. Just like, my lord, the provisions contained in, my lord, part 9 and 9A of the Constitution. 5 years and not beyond, not exceeding 5 years. My lord, his tenure ended in the month of June or July 2023, indisputably. But as a matter of custom, he continued to act as a caretaker president, though the term caretaker is not there in the statute book or in the relevant rules, but I am using the term as a term of general use.
Interregnum.
Yes, madam, interregnum.
Interim president.
Yes, interim president. Madam, kindly take, in this connection, I must also deal with the memo which has been relied on by the petitioner in his affidavit in reply. Kindly take his affidavit in reply, page 12, annexure P20. This is very important, man.
Page 12. Yes.
Page 12. My lord has got that. Kindly take serial number 26.
26 already.
May I read out that?
Yes.
My lord, a copy of the letter being F number so and so dated 27 January 1962 from the Government of India, Ministry of Health, New Delhi, to the Secretary, Dental Council of India. Sorry, serial number 25. Sorry.
Mr. Basu also placed.
Yes, I have to place 25.
Yes.
I'm sorry. Copy of the letter being medical number so and so dated 25th February 1961 from the Special Officer and Assistant Secretary, ex officio, Government of West Bengal, Department of Health Medical Branch, to the Registrar, West Bengal Dental Council. Functions of the President. What is the subject? The functions of the President of Dental Council till election of the next time. I am directed to invite a reference to a letter dated 23rd February 1961 on the above subject and to say that in view of difficulties explained therein, the outgoing president of the West Bengal Dental Council may continue to pass bills and operate on the accounts of the council with the bank till assumption of the charge by a new president after election. But even if assuming, though not admitting, that this particular circular was limited to that period.
But you have a larger issue probably in your favor on
Yeah.
this. Because in that
Caretaker, it is caretaker.
not only that, in that case also,
Huh.
it was subject to the permission being granted
By the state government.
State government.
By the state government.
So
I was coming to that. And my lord, it was only to
this
some
fixes the
kind
source of power to be the state
yes,
government,
state government.
which permitted in that case the president to continue.
And in this case, my lord, the vice president has been allowed to put his to act as an additional signatory by the state government. And during this kind of period, it was a period.
Yes, president, the tenure is over.
Yes, tenure is over. My lord, one cannot have best of both worlds. And this is, my lord, once they rely on this, my lord, my submission, my lord, would be that as a matter of custom, this does not give him any vested right to continue as president, A, and as a matter of custom, he has been allowed to continue as a caretaker president, B, and he does not have any right to decide the policy matters. He does not any right to intervene with the election process. That is my most respectful submission before your lordship. This cannot go on like this. So, Mala, this is what has been relied on by Mr. Bose. Now, Mala, taking on lordship back to the act. Lordship so pleases, my lord. Kindly take.
Yes.
Now, I have taken your lordship to section 3A, 7.2, and now I take your lordship to section 21.
Is it important anymore? I mean, in the view of
no, 3A is not important, but just to show that the provisions are more or less pari materia so far as the election process is concerned. Because my lord, I would be relying on 25.2, which is pari materia to 3A. And I will come to that.
Yes. Yes.
Section 21, except where a joint state council is constituted in accordance with an agreement made under section 22, the state government shall constitute a council consisting of the following members: 4 members elected from among themselves by dentists registered in part A of the state register. So, this is the process of constitution of the state council. Kindly come to section 25, which is couched in a language identical to that used in section 7. Kindly take section 25.2. The president or vice president shall hold office as such for a term not exceeding 5 years and not extending beyond the expiry of his term as a member of state council, but subject to his being a member of state council, he shall be eligible for re-election. So it cannot be beyond 5 years. He can apply for re-election. In fact, Dr. Bishya, subject to correction, is also contesting, would be contesting.
So two riders, not exceeding 5 years and not extending beyond expiry of his term as a member.
Yes.
If he ceases to be a member before 5 years, then it's gone.
Yes.
And the other way around.
Other way around.
Very good.
So in any event, he cannot
eligible for re-election.
He cannot
yes.
enforce his right as president in terms of section 25.2. He may act, my lord. It's a kind of interim management to, my lord, to facilitate the process of election, not to impede the process of election.
But you had subjected yourself to the jurisdiction of the president as president even after that experience.
My lord, that is why
that in writing to the president.
I had been writing because, my lord, I never expected that this will end up in a mess and leading to a litigation before this honorable court.
But can you blow hot and cold?
No, I'm not blowing hot and cold, my lord. I am addressing him as a president because he is an outgoing president and he has been allowed to continue. If we take 62 memo, but that is for a limited purpose. He is a caretaker president. But in view of clear statute, and if your lordship poses that question to me, as rightly posed that question to me, I make this submission. Can there be any estoppel against statute? So approbate, reprobate, fast and loose, hot and cold, my lord, would perhaps, my lord, in my most respectful submission before your lordship, would not perhaps apply in this case. I may have addressed him. I thought that there will be complete coordination, but things unfolded in a different way altogether. So, my lord, there cannot be any estoppel against statute.
But similarly, the vice president also does not have any power.
No.
President was appointed in 2020.
This applies
My
to
lord, the
both.
vice president was appointed in 2022.
So his 2022.
2022. So his tenure is yet to come to an end.
Ah.
2022. That my learned friends must be aware. Now, may I kindly come to the what are the powers of vice president, or what powers can be vested in vice president when there is inertia on the part of the president. I take your lordship back to that compilation which Mr. Bose had handed up. Kindly take, my lord, page 65 of that compilation.
Yes.
My lord, at the bottom of page 65, your lordship will find there is a notification issued under rules issued under section subsection 2 of section 55. This is dated August 26, 1963.
Yeah.
In exercise of the powers conferred by subsection 1 and in particular by clause D of subsection 2 of section 55 of the Dentist Act, the governor is pleased hereby to make the following rules regarding the powers and duties of the vice president of the West Bengal Dental Council, namely, if the office of the president is vacant, or if due to illness or any physical incapacity or any other reason, the president is unable to exercise the powers and perform the duties of the office, the vice president shall act in his place and exercise the powers and perform the duties of the president. But in this case, they are in the complete inertia.
Better case, not why inertia. He's unable because he's no longer the president.
He's no longer the president. And my lord, may I just point out, my lord, having regard to these rules, if these rules are read conjointly with rule 4, my lord, kindly take rule 4 of the rules. এটা কোন কম্পাইলেশনে কত নম্বর পাতা? আরে বল যা সাহেবকে। Yes, yes. My lord, kindly take page 33, no, 24. My lord, 23, the rules start.
Yes.
My lord, kindly take rule 4.
Yes.
An account shall be opened in the Imperial Bank of India, Calcutta, in the name of West Bengal Dental Council, and all monies received for and on behalf of the council shall be deposited to the credit of this account. All checks on the bank shall be signed by the registrar and president jointly. Much emphasis has been supplied to this sub-rule 2 of rule 4.
This has to be read with that.
It has to be read with that. So I answered this question regarding the validity of the government order. Now my power to extend, can I do so? That's the main issue left. My lord, kindly first take the notification, which your lordship will find. If your lordship kindly takes my opposition, if your lordship will find most of the documents there. Kindly take, my lord, the yes, 13.
Yes, 13.
My lord, it is notified for general information that there will be a general election of members of council under, well, I am getting rid of clause A or clause B of section 21. In accordance with the rules framed by the government of West Bengal under the said act, YD notification number so and so dated, this is very relevant. This is 14th October 1915. It is the rules framed by the state government for the purpose of conduct of elections to the of members to the West Bengal Dental Council. Well, I will refer to the rules just after reading out this notification. As well as Dental Council election regulations framed by Dental Council of India. The final electoral roll for the election under clauses A and B of section 21 and so shall comprise of part A and part B of the register of registered dentists corrected up to 5th June 2023. Dentists whose name are borne in Part A or Part B of the above mentioned register of this council are hereby called upon to participate in the election under Clause A or Clause B of Section 21. But I am not reading Section 3. All nomination of candidates shall be made in the prescribed form to be obtained from the office of the returning officer at Purta Bhavan, so and so by application in writing with payment of fees of so and so. The election for both clauses A and B of Section 21 and Clause A of Section 3 will be according to the following program. But if your lordship kindly comes, we are stuck at this stage. So everything has been done till last date of withdrawal of nomination paper, last date of dispatch of voting papers, that is 10th November. So, practically, 3 dates are to be.
You have already dispatched?
No.
Not yet. You have not
yet.
started this schedule as
we have completed the schedule till 7th of July. Kindly take the table. There's a timeline. All the processes till 7th of July, that stage is over. So,
you have to dispatch the voting.
At that stage, all these things happened, and the petitioner came.
Within schedule.
All within schedule, strictly adhered to the schedule. Now, the question now arises that we are now, what has to be refixed? 3 dates are to be refixed, or 4 dates are to be refixed. 1, the last date of dispatch of voting papers. Number 2, date of poll, which appears to be on the 21st day from the date of dispatch of voting papers. And then scrutiny of voting papers and counting of votes. And lastly, scrutiny of. Then let us forget about the last. That is not done. That is no longer relevant.
Previous, yes.
Till this.
3rd December.
So 3 dates are to be fixed now.
Yes.
Now, the question arises that whether I have such power. The rules, if your lordship kindly take page 33 of the compilation. No, 33 কেন? না ওটা না কেন, আগে ওয়েস্ট বেঙ্গল একটা দেখাই। kindly take first page 12. Page 12. Because I would be relying on these rules.
Yes.
My lord has got that compilation, page 12. So these rules have been framed. My lordship will find from the notification that these rules have been referred to in the notification, the election program notification.
Yes.
So these are rules for election of members, including the president and vice president of West Bengal Dental Council and of the members of the executive committee of the State Council. Now, kindly take the definition clause and kindly take clause 1C. Registrar means the registrar of the West Bengal Dental Council, and in the case of first election under clauses A, B, and clause D of section 21 or 25 or 29, the registrar of registration tribunal appointed under so and so. The returning officer means for the purpose of an election under clause A or clause B of section 21, the registrar, and includes any officer deputed for the timing by the said registrar to perform, assist in his duties under the Act. Then, my lord, the process, what is to be undertaken. So, my lord, whether at this stage when the process of election was stalled due to an impasse created regarding the dispatch of voting papers, can the returning officer, being vested with the authority to conduct elections in terms of the statutory rules, is competent to refix the election program so far as the last 3 dates are concerned. My lord, having regard to this, my lord, if we take into consideration section 14 of the General Clauses Act. Kindly take, my lord, section 14 of the General Clauses. I'm sorry. One thing, I'm sorry. One page. Kindly take page 33. First, my lord, 2.1. Who is vested with the authority? In page 12. Thereafter, I will take your lordship to that. I'm sorry. Page 12. I was taking your lordship to page 12.
Yes.
After 3-year election name. The returning officer shall publish in the Calcutta Gazette and in such manner a notification calling upon the dentist registered in Part A or Part B of the state register, according as the election is under Clause A or Clause B of Section 21, to elect the requisite number of members to the State Council, and shall by such notification fix a program of time for the various stages according which the election shall be held. So, my lord, undoubtedly, my lord, the statute vests the registrar or the returning officer with the power to fix the dates of poll, fix the dates of counting, fix the dates for dispatch of voting papers, and so on and so forth. So, whether this power could be exercised on multiple occasions. Having regard to the exigency of circumstance, because ultimate goal is to conduct free and fair elections and adhere to an election program which will lead to formation of an elected body as soon as possible. Because they already 6 months have elapsed. Already 6 months have elapsed so far as the president is concerned and members are concerned. Now, kindly take for once, this I believe this is the Central General Clauses Act. Section 14 would correspond to Section 15 of the Bengal General Clauses Act.
No, you have reached up to which stage you have scrutinized?
I have reached up to the state of 7 July.
Yes, what is that stage?
I'm sorry, Malad, I should have pointed out.
Tell me the
last date of withdrawal of nomination papers. Malad has got that 7th July, something is written there.
Yes, yes.
14 June 2023. It is last date of withdrawal of nomination paper, 7 July 2023.
Because in Rule 5 of the rules you were placing,
yes,
there is a mention of on or on such other subsequent date and time as may be fixed by the returning.
Yes.
Rule 5 contemplates that regarding examination of nomination
papers.
So there is some
so there is, my lord, there is, my lord, if that be so, my lord, I am grateful to your lordship. Therefore, my lord, the already power is vested in the registrar or returning officer to fix such dates or dates.
Such other subsequent dates. That's the language of Rule 5. That is
subsequent dates, my lord, then I can reschedule the entire election.
That is at the stage of examination of nomination papers only.
My lord, the examination of nomination papers are over. Kindly take the examination of nomination paper is on 4th of July 2023.
That is over already. So that stage is over.
Once that stage is over, it is open to the returning officer of the registrar to refix the dates.
Maybe let us see first your clause.
Yes, my lord.
14.
Kindly take section 14 for once.
Yes.
My lord, this is the
I'll also request you to file a short written notes, Mr.
Yes, certainly, my lord.
Just to
my lord, I believe, my lord, this would correspond to section 15 of the Bengal General Clauses Act.
Should I can find out the Bengal.
Yes.
You have the Bengal.
No, I am reading from the central.
Bengal, just try to find out this Bengal.
My lord, kindly give me a second, my lord. I will do it for your lordship.
You also give me a second.
My lord. Yes, section 15, my lord.
Section 15.
Where by any Bengal Act or West Bengal Act made after the commencement of this act, any power is conferred, then unless different intention appears, that power may be exercised from time to time as occasion requires.
All right. Yes.
So, having regard to that, my lord, kindly take, my lord, a judgment rendered by the Supreme Court, considering, my lord, the effect of this General Clause and Section 14 of the General Clause Act. May I just briefly state the facts? A particular order issued by a quasi-judicial order passed by an authority was set aside by the court. My lord, no leave was sought for from the court for passing a fresh order. It was set aside on the ground that the principles of natural justice stood violated. The authority proceeded to pass a fresh order. This attempt to pass a fresh order was carried to the Honorable Court. Ultimately, the Supreme Court held that, having regard to Section 14, but this is a case of quasi-judicial, we are talking about administrative orders. Even in that case, no leave is necessary, is required to be obtained from the court for passing that order, having regard to section 14 of the Act, because that power is conferred on the statutory functionary. And since simply because the order had been set aside on the grounds of violations of principles of natural justice, the statutory authority can proceed and pass a fresh order. Malad, kindly take for once, my lord, pay paragraph 36 of this judgment. Oh, दिए दे
2017-13 SCC.
13
page
is
50
I'm giving
2017-13 SCC, page 51.
page 51. My lord has got paragraph 36.
36, yes.
Any statutory power could be exercised from time to time as occasion requires. Such a principle is recognized by section 14 of the General Clause Act and section 14 of Gujarat General Clause Act. Now, here it would be a section 15 of the Bengal General Clause Act. Power conferred on the courts to adjudicate the rights and obligations of the parties is an exception to the principle. The doctrines of res judicata and double jeopardy prohibit repeated invocation of the jurisdiction of the civil courts or repeated attempts to prosecute a person on the same set of facts constitute an offense. Whether power conferred by a statute on a body other than a judicial body, I could be exercised repeatedly, or there are any legal limitations thereon. And if there are limitations thereon, what are they? Are the questions which require further examination. But for the purpose of this case, those questions need not be examined. It is already held by this court when an order has been passed in exercise of a power conferred by a statute is set aside on the ground that such order was passed in breach of principles of natural justice. Such power could once again be exercised by complying with the principles of natural justice.
But there is a subtle distinction in this case,
Yes.
which may be argued by Mr. Bose.
Yeah.
Here, the rules confer power on you to publish a schedule
Yes.
of dates.
Right.
Now, yes, repeatedly you can do that.
Yes.
But that means that you again have to issue another notice.
Yes, absolutely.
Scheduling
Yes,
all the
yes, yes. Not all the dates, my lord. From the stage.
From the initial stage.
No, no, from that stage is over.
The power conferred on you is not to do it midway. The power conferred on you is to, you can issue a notice giving the entire schedule of dates of the election.
But may I just...
You can do it again, the same thing.
Malad,
But de novo. That is what Mr. Bose was trying to argue.
Malad, may I just indicate to your lordship?
Not extend midway. I mean,
Not midway. Malad, the power has been given to me. I mean the registrar or returning officer.
Yes, yes.
To fix the dates. Malad, that is there in the rules itself. Malad, if for some reason...
Let us once more see the language of that power.
Yes.
Because it depends on that.
Yes, it depends on that. Because we have to look at the election rules.
Yes, yes. That was in their compilation.
Yes, it is at page 11, 12.
11, 12, right. Yes, yes. 12.
The returning officer shall publish in the Calcutta Gazette and in such other manner as he may think fit a notification calling upon the dentist registered in Part A or Part B of the state register according as the election is under Clause A or Clause B of Section 21 to elect the requisite number of members to the State Council and shall by such notification fix a program for various stages.
So by such notification, fix the program for the various stages.
But then, my lord, a notification can also be issued for some of the stages. Absolutely, my lord. The stages are identified and identifiable.
This envisages that you shall by such notification.
Yes.
Such means one only.
Yes.
By such notification, fix a program of time for the various stages. By the same notice,
the entire
schedule has to
be entire schedule, my lord. May I just humbly submit to your lordship?
Yes.
My lord, the power is vested in the statutory authority, in this authority to fix the dates. My lord, rule 2 of the rules say that by such notification fix a program of time for the various stages according to which
the election shall be held.
According to which the election shall be held. For the various stages, when some stages are concluded and those stages that there is no dispute as to the conclusion of those stages.
I'm telling you the difficulty which may arise, Mr. Mujumdar, if it is stretched as what you are saying.
Yes.
Suppose you wait for 6 months in between.
Right.
In the meantime, some of the valid voters who are there at that point of time may have become invalid.
Right.
Or several other changes might have taken place in between in this interregnum, which would have a toll on the effect of the result of the election itself.
Yes.
So some of the eligible voters then might have become ineligible.
Kindly take the last date. The last date was 31st December or something like that. Kindly take 14 June.
Quite recent.
That is quite recent.
Yes, we are in January.
We are in January.
February.
We are in January. Well, we are in February right now.
Just February.
If you are in February, my lord, within
Could not have been. Great.
my lord, so my lord, first of all, my lord,
All right.
and my lord, this election process was, my lord, because of pendency of the writ petition, we did not proceed with the election process.
Great.
Because we thought that in due deference to the pendency of the proceedings, we should not proceed.
And what about the threats received by you now?
My lord, the threats received by my lord, I have to answer one more question.
Yes.
My lord, much submissions have been made on the NDC Act. That NDC Act will operate, what will happen, another election, another something will happen, why will you spend so much money, what will happen to state exchequer, what will happen to my future as president. I'm sorry, that was not argued. My lord, these were the submissions made. My lord, now kindly take my lord, the NDC Act for once. This is extremely important, extremely important.
Yes.
There are some acts where this kind of language is used. Kindly take section 1, subsection 3 of the act.
Yes.
It shall come into force on such date.
The NDC,
the National Dental Commission. I'm sorry, Malad.
What is that?
You're not. You kindly take one.
Oh, I'm sorry. It has been given.
Yes.
Sorry. 1-3.
1-3.
Yes, 1-3. It shall come into force.
Malad, may I just read out?
Yes.
It shall come into force on such date as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of this act, and any reference to in any such provision to the commencement of this act shall be construed as a reference to the coming into force of that provision. So, Malad, the act may come into force on from one date.
Yes.
Yes.
This is there in many other acts also.
Many other acts, but this is not generally used, Malad. Generally, we get that it will come into force. It will come into force with the publication of this notification itself.
Yes.
No. Now, Malad, kindly come. There is no.
Depends on the notification of the central government.
Yes.
Obviously, that is not there. I mean,
and that is not there. And Malad, kindly take, Malad, this kind of provision has been interpreted by Supreme Court in 2008.
But none of the provisions have been given effect.
Yes. So, Malad, today the entire argument on NDC is perhaps subject to correction by my learned friend, subject to correction by Mr. Bose when he lands from Tripura.
Yes.
I tried to get hold of him and restrain him, but
Just
I couldn't.
tell me the reason why he has gone to Tripura.
Yes,
I require only that.
But I have some people out there who will find out what he is doing tomorrow.
Just inform, instead of me, I appoint Mrs. Swaruppal as special officer, inform him that you suffice. You will take care of the rest. Yes.
My lord, kindly take for once. My lord, this is 2008-10 SCC. Now, 368. Well, kindly take paragraph 4. Malras got that? Paragraph 4 of the reports.
Yes.
Quite often, the commencement of an act is postponed to some specified future date or to such date as the appropriate government may, by notification in the official gazette, appoint. Provision is also made at times for appointment of different dates for coming into force of different parts of the same act. Remember, kindly now take paragraph 26. But in my respectful submission, no submission could be advanced on the strength of this act. which is yet to take birth. Section 26. As stated above, quite often commencement of an act is postponed to some specific future date or to such date as the appropriate government may by notification in the official gazette appoint. At times provision is made for appointment of different dates for coming into force of different parts of the same act. An act cannot be said to commence or to be in force unless it is brought into operation by legislative enactment or by the exercise of authority by a delegate empowered to bring into operation. Well,
But this is Supreme Court judgment was required.
No, not required, madam. But my lord,
And you are citing that
but with Mr. Bose
on this on the supposition that the court
no, but with Mr. Bose around, my lord, I had to cite. Not for the court, man.
Certain things, Mr. Mujumdar, I mean,
Well, this is so obvious. This is so obvious. So, my lord,
should not be.
Should I recall this judgment, my lord?
Yes. The Supreme Court, since the Supreme Court deemed it fit to render a judgment on this, definitely it was argued before the Supreme Court also.
But I tell you, Lordship,
Must have been
just a minute's digression. One act, there is an act where there is a removal of difficulty provision. Your Lordship knows that removal of difficulty. The act was supposed to commence from, say, my lord, X year, 1st April, so and so. An order was passed under removal of difficulty provision, commencing the act from an earlier date.
Yes.
Without the act coming into force. It's a fact, my lord, and it is the bone of contention. All the matters are now pending. It's a black money act.
Oh, actually that happened?
Yes. It's the Black Money Act, where there is a removal of difficulty order provision. Removal of difficulty order is issued before the act is born, and my lord, the act is given effect from an earlier date.
So that is under challenge.
That is under challenge in different high courts, in our high courts.
Challenges are all pending.
Pending.
That is the more important issue.
And there is an interim order passed by the Honorable Supreme Court, presided over by His Lordship Justice Mishra, as His Lordship then was, that this may be permissible, but this is
Deepak Mishra or Arun?
Arun Mishra, my lord. My lord, that ends there. My lord, now, my lord, may I just proceed? So, my lord, there were 3 limbs of submissions, broadly, my lord, which I could gather. Yes. My lord, so far as the now threat part, correct?
Threat, yes.
Yes, threat part. Yes, there was a claim.
Whatever you are doing now is another threat.
Yes, my lord.
There is a presumption of
it. My lord, that is why it was also my suggestion, kindly get rid of me. Kindly appoint your lordship.
So you took down the CCTV. That gave the.
Well, the CCTV, the keyword, the password was taken on 17th of November. The alleged incident occurred on 8th of November.
Yes.
My lord, it was categorically submitted by Mr. Bose. Since I was in possession of the CCTV password, I switched off the CCTV on 8th of November. When clearly
he showed something like this, you took it down.
Yes,
he physically showed that he took it down
from the just like when a calendar from the wall.
Calendar, many other.
So, Mala, this is not done, and threat was there. Mala, there was a clamor. Clamor, my lord, there was a clamor.
There were obviously threats against you.
But my lord, there are n number of mails which I received as the returning officer that why are you departing from the usual practice? And those n number of mails, reference to those n number of mails have been made in the minutes of the meeting held on 8th of November 2023.
So, but that doesn't have anything to do with your...
No, the decision-making process was not influenced by the clamor. But my lord, to maintain the sanctity, purity, it's a question of purity of the election process, and to allay any fear or apprehension that the election process might be subjected to some kind of extraneous influence, to conduct a free and fair election, that decision was taken. But I am open, my lord. The nearest post office is Shej Bhavan. I will do that from there. Not the nearer post office, my lord. The nearest, if the proximity is the only issue. And my lord, may I put the question to my, is this an issue, my lord, which could be, my lord, brought to this honorable court? But these are broadly my submissions before your lordship. I know, my lord, there will be 1 hour reply from Mr. Bose on Monday, and your lordship will not be reprieved on Monday till 3 p.m.
Anyone else in the response? You want to submit anything on this?
I'm sorry, my lord, one thing I missed. Just that too. My lord, this memo, your lordship will find the memo once again, 30th November. This memo was issued in terms of section 26 of the Act.
Yes.
Where, my lord, the state government is vested with the power.
That memo pertains to the vice president powers, that
Yes,
signatory.
vice
Yes.
Section 26 provides so. My lord, I have given up the point of maintainability.
Section 26, what does it say? Does it empower you to do the
Yes, state government. Kindly take state.
I'll just
No, alternative kindly take section 20. I'm sorry. Kindly take section 26. Well, section, my lord has got.
Let him argue that, Mr. Mujumdar. That is his only point. So let him argue that.
Section 26, read with Rule 4, read with the Vice President rules.
Let him place that. Yes. Yes, you argue.
But these are my most respectful submissions. But my lord, when do I submit the notes?
Not before Monday, obviously, Mr.
My lord, let Mr. Bose conclude.
Very good.
Within
After
a
that,
couple
I'll
of
keep a
days,
date.
my lord, kindly give me a
I'll
time,
give
my
you.
lord.
Just draft the broad outline.
Yes,
So that
my
if
lord,
you have
it
to add
will
anything
be-
after
it-
Mr.
my lord,
Bose.
it will be in reality short notes.
Thank you. Yes. Yes, be fast. Yes. Be fast. Section 26, mode of elections. Place it.
Lord. In section 26, my lord, the state government is vested with the power to
Where dispute arises, it shall be referred to the state government.
and
Where
state
dispute
government
arose,
can,
it has been referred to you.
it was referred to the state government, and the state government, my lord, is vested with power under section 26 to resolve that dispute in any manner it prescribes fit, and that decision of state government is to be final. My lord, when the memo or when the returning officer wrote to the state government on 28th of November saying that the current the incoming president was approached on 3 different occasions pursuant to the meeting dated 8th of November, and he's not available, or rather he has made himself unavailable for signing checks, and that has created a stalemate, and there is a strict timeline, and the returning officer is running against time. My lord, it was the secretary which issued this memo, my lord. He deemed it fit to appoint another person, the vice president, as a signatory of the said memo in terms of the power exercised under section 26 of the Act to resolve that dispute, so that the free and fair election, the process is not stalled and checks can be issued. This is not without jurisdiction in my humble submission, my lord. We trace our jurisdiction from the Act itself.
Good. At the order, the heard learned counsel for the respondents, push up for rejoinder by the petitioner, the matter is adjourned till February 5, 2024, when it will be taken up at 2 p.m. Or it's a 2 p.m. Fakat? 2 p.m. 2 p.m. on Monday.
Grateful, my lord.
Right. No.
In regard to item number 4, my lord, if your lordship kindly pleases to fix it in any day convenient to your lordship, my lord.
What did I do? Item number 2.
4, my lord.
Oh,
which
4.
was- which was fixed at 2 p.m, my lord.
I fixed at 2 p.m. today.
My lord, today.
Oh. When should I keep it? 2 p.m. ফাঁকা আছে ররিত্র।
Monday, Tuesday, any day convenient to your lordship, my lord.
Monday, another matter. You want it at 2 p.m.?
2 p.m. my lord.
দেখো কথা।
Kindly put on Wednesday, Mr. Jisnu Chaudhary will not be there on Monday and Tuesday, my lord.
Wednesday ফাঁকা আছে? তারপরে কথা। 8 ফাঁকা আছে? 8th Thursday.
Great. Okay.
Very good. তাহলে ওটা 8th এর করে দাও। 8th 2 p.m.
Great.
Item 4, right, sir?
হ্যাঁ।
Item.
হ্যাঁ, item।
এটা নাম দিতে হবে নাকি?
My lord, may I have your lordship's kind leave to mention a matter pertaining to the original site?
Let them come. Yes.
My lord, it's for correction of an order passed by your lordship day before yesterday.
Hand over.
I'm deeply
Enough
obliged,
to
my
be
lord.
mentioned correction.
My lord,
I'm
may I
deeply
permit to
obliged.
mention an original side matter. My lord, item number 12 of your lordship's list, my lord.
Yes.
The time to file affidavit and reply has expired, my lord. I just seek 1 week's time to file the reply, my lord, and the matter can be fixed for hearing, my lord. I've served the notice of mentioning also on the other side, my lord. If my lord may kindly extend 1 week's time, my lord, to file the reply.
Very good. File the reply?
Yes, my lord. The affidavit reply. Opposition has been served upon me.
13 একটা order record করে
12, my lord.
12 একটা বোর্ডে দেখি। The matter is taken out of turn for the limited purpose, as mentioned on behalf of the petitioner, for extending the time for filing affidavit in reply, on the prayer of learned counsel for the petitioner, The time for filing reply is extended for a week.
1 week, my lord.
For a week from date, full stop. The matter be listed under the same heading on February 8, 2024.
Grateful, my lord.
8 February, please inform your other side that
I'll do that, my lord.
in
Grateful.
writing, just do it.
Yes, yes. Grateful, my
My lord, may I have my lord's leave to mention, my lord, item number 36, my lord.
36, yes.
In spite of your lordship's direction, my lord, respondent has not filed affidavit in opposition, my lord. And this is a very short matter. I have also written to letter to them asking whether they will file, but there is no response, my lord. So I was praying, my lord, if it is given precedence, my lord, so that
There are so many top matters. Let me hear these first. Right now, I cannot give precedence. I'm sorry. Not now. Yes.
Original side, item number 1.
My lord, I have mentioned this matter
What is the
yesterday.
correction?
The correction is the name of the petitioner advocates didn't came into the order sheet.
Kaushik De Tapan Bhanju.
No, they appeared on behalf of the custom authority.
Give on a piece of paper, give the names of the petitioner's advocates.
Yes, my lord.
Learned counsel for the petitioner submits that there was an error in the recording of appearances in the order dated January 30, 2024. Mr. Kaushik De and Mr. Tapan Bhanjo were recorded to be appearing for the petitioner, whereas they appeared for the custom authorities. The next para. Accordingly, let the order dated January 30, 2024 be deemed to stand corrected to the effect that the names of Mr. Kaushik De and Mr. Tapan Bhanjo be treated to be appearances for the custom authorities. The names of the advocates for the petitioners as given hereunder, comma, be also deemed to be the appearances for the petitioner on the said date. Colon দিয়ে, please give on a sheet of paper, ওটা দেখে লিখে দেবেন নামগুলো। যেখানে ডট ডট দিতে কোলন দিয়ে বললাম ওখানে। Thank you.
Item 2.
Lordship, Mr. Vishwarup Bhattacharya is on one matter in courtroom number 8 and just praying for short possible.
And make it not today then.
tomorrow, my lord, or not today, my lord.
You are for the respondent.
I am for the responded hospital.
On the prayer of adjournment sought by the respondent, the matter is adjourned for the day.
Grateful, my lord.
Item number
My lord,
3.
may it retain its position. It's a part heart matter anyway. So
Whatever, I mean,
My lord, in item number 3, Mr. Trivedi is appearing for the respondent. My lord, he is on his legs
Let it
before
be called
court
on
number
first, yes.
14.
Yes, Mr. Trivedi is on his legs. Mr. Chakravarti, what can be done?
Lord, we have made our submissions, my lord. Your lordship has passed an interim order, my lord. Let it be taken up next week. Tomorrow I have some difficulties.
On the prayer of learned counsel for the respondent, on the prayer of learned counsel for the respondent, the matter is adjourned and shall next be placed in the.
Because he will take some time.
Oh, no, he's
Yeah,
there.
that's a
Get it,
bolo.
get it.
My lord, I apologize.
No,
Bolo.
you can argue now. You are ready in the matter.
My lord.
Yes, yes, absolutely.
My lord,
Mr. Chakravarti was trying to take advantage of your.
may I say something, my lord? My lord will not take judicial notice of it. Even today, my lord, when we prepare for the matter, it feels as if I am forgetting everything. Before I was coming on the lift, I was thinking that whether I.
No, everybody. That happens to everyone.
That is still
That
there.
happens to me now when I pass my orders.
No.
Yes.
We were rest. We could be rest.
Lord, only
assured.
one thing, my lord, on the last occasion wanted us to prepare a list of date, lord, because there was some, lord,
You are copy to them
confusion.
also?
Yes. A copy? A copy? Or it? With the page numbers, document গুলো একটু confusion ছিল না? So we have prepared it.
Mr. Trivedi, ask your learned junior to check whether these are correct or not. If Mr. Chakravarti has settled, there must be some error in it.
My lord, I have, my lord, it will be correct, my lord. If not, then I will see, my lord, and it will be, I think that he is very competent, my lord, that. Lordship, why on the last occasion, my lord, since I was left with only 10 minutes, my lord, I had just in brief, my lord, told my limbs of argument, my lord.
Yes.
First is, my lord, the jurisdiction part of it, the territorial aspect. Second is, my lord, there is an arbitration clause. And third, per se, is the writ petition the writ petitioner has reached that state where without giving a show cause has been given, and my instruction which has come, my lord, we have not yet issued any debarment, something. My juniors are coming, my lord, but before I get a concrete instruction, my lord, because what I understood from what is there, the debarment has not been issued yet. And what has happened is that it was an auto, because 5-day, this is GEM is a auto-generated system, my lord, which is there for facilitating this avoid competition and facilitating all these tenders and applications. And whoever is member of whoever subscribe to this particular, he becomes a member and he has to follow all the norms, and whatever is stated by them in the on that particular portal, my lord, is taken to be sacrosanct. And in case there is any deviation, then the buyer who has basically who is the buyer who's wanting to procure these products or goods, they write a letter to the GEM portal saying that we have received this information that there has been deviation or there has been some suppression which requires certain further action. Now, those actions have been, as very rightly said by my learned senior friend on that, are of 3 categories: grievous, severe, and normal. And whether they will be debarred or not, under which category it comes, it has been given now. So, my lord, first I would take, my lord, to the jurisdictional part. My lord, here, my lord, if my lord kindly takes up. मैं तुमको इतना फोन किया, तुम तो वापस ही नहीं आई. क्या इंस्ट्रक्शन भेजा कहानी नहीं, वो दीवार किए कि नहीं किए वो भी नहीं मालूम. My lord, look at this. My lord, first of all, my lord.
So territorial jurisdiction, show cause is at the show cause stage, it is premature.
My lord,
These are the 2 main.
Yes, my lord. And third is, my lord, arbitration clause.
Oh, arbitration, right. Yes.
Now, my lord, I will take, my lord, first, the guidelines, my lord.
Right.
Guidelines is that, my lord, will kindly come to page 25. These guidelines, my lord, with regard to the territorial jurisdiction as well as arbitration, my lord, I will try to point out from these guidelines, and then I will come to the factual aspect. Now, my lord, will kindly see, this is the contract and an agreement in itself, my lord. If my lord kindly comes to page 25.
Yes.
5. Annexure 1. My lord, may I read, my lord? Please. The document is an electronic record published by GEM under the provisions of the Information Technology Act 2000 and the rules made thereunder, and shall act as a valid agreement between the seller and buyer, petitioner, and the respondents. Respondent number 3, in fact.
You are appearing for all the respondents.
My lord, actually, my lord, I will read that also. It has been said that they cannot be made parties under the agreement. If my lord kindly comes, 1 and 2 cannot be made party, my lord. 2 cannot be made party, my lord. My lord will. My lord, I'll come to that later because it's just a page 56. If my lord
so cannot be made parties are different, but now you are appearing for all 3 of them.
My lord, I am appearing because, my lord, with regard to page 56, if my lord kindly comes, 16.3, my lord.
Yes, point 3.
If my lord kindly sees, both the parties understand and agree. That means the buyer and the seller.
Yes.
That GEM, being an intermediary, cannot be made a party to any dispute in connection with or arising out of the contract and the arbitration proceedings between the parties. Because it's a portal, my lord. If my lord kindly sees, basically, my lord, what it is. Basically, my lord, it is an active website, my lord. It can be terminated as an active website.
But they are probably also challenging the provisions of the GEM, these provisions.
My lord, therefore, my lord, provisions.
So then they have to implement the GEM as a party.
My lord, in my respectful submission, my lord, Union of India is there. The policy has been made by the Union of India. GEM happens to be a company incorporator who run this particular website on the norms and rules, set general terms and conditions as per GEM.
Mr. Tibi, I will not expunge that party. I will keep it open for being decided.
I'm not wanting, my lord. Just I'm trying
to.
This
is a valid point. I'll keep that in. I'll also decide that along with the other point.
Because, my lord, I am technologically challenged, and these things, my lord, it becomes, my lord, that he is a portal, whether it's an active website, whether it is a passive website, or whether it comes within the interactive website. You know, these things are, and then comes the jurisdiction part based on whether it is an active website or a passive website, my lord. So, my lord, therefore, my lord, GEM, what I could understand is just a portal which is being used for facilitating this particular process, my lord. Therefore,
That's
this is
true.
the, now, my lord, I am not wanting, my lord, to expunge at this stage, my lord.
Yes.
Now, my lord, so, my lord, I was reading, my lord, then, my lord, if my lord comes to page 25, so this is the valid agreement between the parties. Whoever subscribes to that particular website and he enters that website as a particular buyer or all the government organizations are buyer who have to
general conditions will be binding.
Yes, binding on both of them. So it is binding on myself as well as on the petitioner. There I start from, my lord. Then, my lord, the goods, my lord, will kindly come to paragraph 2, clause 2, paragraph B, my lord. A is the applicable laws, my lord. Then goods. Goods shall mean articles, products, and intangible products like software, technology, transfer, licenses, patent, and other intellectual properties being offered for sale on the GM portal by the seller on the GM. The term goods shall also include work and services which are incidental or consequential to the supply of such goods, and as transportation, insurance, installation, commissioning, training, guarantee, warranty, obligation as defined, the scope of supply. So, my lord, this is the definition of goods. So, they were wanting to supply us with these bags, which are the goods, my lord. Now, my lord, will kindly see. Buyers have been described in with 2F, my lord. And G is the seller.
Yes.
So, F, my lord.
There is no dispute regarding this definition.
Yes, so, my lord,
make it a Guru Rachana, go to the main point.
So, now, my lord, will kindly see. Now, this D is the service agreement, which is. Now, my lord, will see page 55.
Yes. Yes.
16.1 is the conciliation clause and 16.2 is the arbitration clause. Now, my lord, now, my lord, this is the arbitration point of it, my lord. And then, my lord, now, my lord, will kindly come to clause 16.2. My lord, that is at page 55. And, my lord, then, my lord, will kindly come to page 56. Subparagraph Romans 7.
Right.
The contract shall be interpreted and governed in all respects in accordance with the laws of India. All disputes in connection with or arising out of the contract shall be subject to the exclusive jurisdiction of the court within the local limits of whose jurisdictional principal place of business of the buyer department organization is located. So, my lord, we are all located in Jodhpur. If my lord kindly sees, or in Delhi. So, my lord, even if I am not taking, buyer is respondent number 3 and seller is respondent number petitioners, my lord. So, we are, as far as this is concerned, my lord, there's an arbitration clause. Then jurisdiction is where the buyers are there. Admittedly, we are at Jodhpur. And this was something which was on a portal. They were operating from here, but they have subscribed and they have accepted these terms and conditions, because whatever has been done by them has been done pursuant to in terms of this particular terms. Now they cannot, my lord, turn 360 degrees and say that we are not going to abide by these rules and regulations. Then, my lord, will kindly come to page 57, my lord. Clause 17, if my lord kindly takes, that starts at page 56. Clause 17. Now, my lord, 17, subclause 1, my lord. The contract shall be governed by the laws of India for the time being in force. Then, my lord, will flip over the page, my lord. My lord, I will read that. Irrespective of the place of delivery, the place of performance, the place of payment under the contract shall be deemed to have been made at the registered address of the buyer and the primary buyer. Then, my lord, jurisdiction of courts. The courts or of the place from where the contract has been made shall alone have jurisdiction to decide the dispute arising out of or in respect of the contract. Then, my lord, 5, my lord. 5 minutes. In case the seller service provider makes GEM a party respondent in any case involving any dispute between the buyer and the seller arising out of the concluded contract or arising of the bidding process initiated, concluded by the buyer on GEM, it would be obligatory on the part of the buyer, that is me, Milind, to represent the GEM also through their counsel lawyer in the proceeding before the legal authority and ensure timely filing of replies affidavits provided in the GM also through their learned counsel lawyer before the concerned legal authority during the course of litigation as standard reply. So we have been said only the standard reply we can say, which I submitted before my. Well, this is this is what it is.
This is really an auto thing.
Computer, my lord, is a wise fool.
No, this has been, the computer is as wise as the makers of the programs.
That's what I'm saying, Miller.
Computer is a tool only.
Well, it's a tool, Miller, but it does a monotonous job.
Wisdom of the people behind the software. And
no, AI has come, Miller, but AI is also not doing very good job, Miller. But whatever it is, Miller, I will not.
AI is doing some good jobs, very good jobs. I mean, this morning I was looking into the newspapers and I saw some person he had died. The body was discovered. His eyes were closed. Those eyes were formulated by the AI, and by that he was identified, and his killers were identified within 48 hours. I mean, AI is doing magnificent things also. It depends on how we use it.
Exactly. My lord, actually what happens is, my lord, our brains work much faster. AI does on a particular pattern, and we defy that. Again, laws come, my lord, because now having my exposure to the criminal side of the bar, my lord, I am seeing that how these.
No, but Mr. Trivedi, we had an advantage in millions of years of evolution.
Yes.
Let AI have that advantage and then compare us with.
Yes. Let
us see, you are better or God is better on in creation.
My lord, we are the generation, my lord, we did not have mobile phones during our college times.
It is rapidly.
Now, my lord,
and
now we are the people who cannot live without mobile phone. We think that we are losing something every day. So, my lord,
many of us.
Many of us.
Last 2 years, everything.
I'm learning, my lord, how to use the tab, but my lord, it is
absolutely necessary nowadays.
Necessary, but my lord, I think that
if you want to have paperless courts and save the trees and everything involved.
What happens is,
you have to shift
while you are flipping from your notes to the main petition, that becomes when I'm addressing my lord, or for that
we have to have 2 or 3 softwares, Mr. Trivedi.
There is liquid text, but then you need to learn them.
No, not much of learning, because it's in the software. You can the annexures are bookmarked, and if in the touch of a button, I mean, not even a button, you can touch the screen and you get the relevant annexure. If you can do that and take notes on the tab, then everything is solved. We have to
get acclimatized to that, because what happens?
We have to get acclimatized. I don't say that the general public, because there's a great social divide on this. You cannot expect the person who works in your home to go back and use a tab and monitor her case. Definitely not. Definitely not. But for that, advocates also can act as intermediaries.
Even the advocates who are practicing before this honorable court, they also have a divide, Millard, because some people are more young generation, are more accustomed, and they can take up these technology.
The older generation can always take help of the younger generation.
We are trying to do that.
It depends on your mindset.
Yes, we are changing our mindset.
Absolutely.
So, Millard, this is what was that.
So
now, Millard,
this is already.
Now, so, Millard, 2 points.
Predetermined pleadings.
Predetermined. So, Millard, what the first point?
I think I should set aside this first.
Millard.
Anyway, then
Millard, so Millard, 2 points.
Territorial jurisdiction is a very good point.
Territorial jurisdiction, Millard, because now, Millard, what I'm humbly submitting is, and now Millard will show the territorial jurisdiction if Millard sees, Millard. Millard, now, Millard, in my respectful submission, therefore, arbitration clauses there, Millard.
Yes, that too.
Disputed question of facts are there, Millard, because of the reason whether they have given a notice. Initially, they were not called for a show causes there. They gave a letter that I have challenged this particular letter before this honorable court, and therefore I'm not wanting to give a show cause as of now. There's an auto-generated system. If you don't give a reply, they block you for a certain period of time.
According to you, Mr. Trivedi, you said it's a premature.
Well, I'm coming to that.
Yes, because according to you, still they have an opportunity to reply to the show cause.
Yes, Millard.
And being heard or representation being given.
Yes, Millard. But Millard, first, Millard, without going on, my lord, as far as jurisdiction, territorial jurisdiction is concerned and arbitration is concerned, my lord, these matters can be gone into in arbitration, my lord. Now, my lord, I am coming to the third branch, which has fallen from my lord. Now, my lord, will kindly see. My lord, will kindly come to page 80. Just the garnishing, my lord, that annexure P3, my lord, the bid document, my lord. Right. Now, the big document, my lord, will kindly see the office name, that is at 7th column, my lord, is FTR headquarters BSF Jodhpur. Right. Now, my lord, this is. Now, my lord, so, my lord, the jurisdiction should lie with, my lord, with Jodhpur. Then, my lord, this action was cancelled, that is at P4, page 89, my lord. Though they were declared as L1. They were declared as L1. But this was cancelled, my lord. This tender was cancelled, my lord, and they did not challenge that, this cancellation. Now, my lord, now where it all started, my lord, is page P5, page 90, my lord. Here, my lord, we made a complaint. Page 90, my lord, has got. My lord will see buyer, ministerial. Now, buyer made a complaint as per clause 20. That is page 58 if my lord kindly comes.
As per clause 25.
My lord, if my lord kindly comes to page 58. My lord, we had made a complaint for taking action on grounds of administrative action. That is at page 21, which was. Now, my lord, here, my lord, what description, indulgence, and now, my lord, will kindly come to page 90 once again. Indulgence in anti-competitive behavior or cartel formation. The complaint is at, my lord, that is complaint dated 2nd of Dutarik, na? Dui. My lord, at page 91. My complaint dated, my lord. Here, my lord, what we said, my lord, the complaint, my lord, may I read the complaint, the second paragraph. As per complaint lodged by Sarthak Mittal, Director, Hartree Energy Systems Private Limited, dated 14/11/2023, in subject procurement regarding the Sri Durga industry is having common owner with Messrs. Securado Industries Private Limited, received through FHQ, BSF, GEM desk, signature so-and-so. This headquarter approached the GM authorities, wide letter dated 22nd November 2023, and through mail dated 22nd November 2023 to ascertain its authenticity registration in the GM portal, whether both firms have common owners or otherwise. Now, that letter was initially in the month of November, which we had given. That has been also next, but in order to cut my argument short, I'm just reading this letter because this has put forth what has been the sequence of events. In response to Bharat Bhushan, intimated through their mail dated November 24, 2023, which was appended below. With reference to point number 6 of your attachment, letter dated 22/11/2023, present details entered by the two sellers, namely Sri Durga Industry and Securado Industries Private Limited, are enclosed information of further necessary actions at your end, please, as per the address entered by these two sellers seems to be the same. However, as per data retrieved by GST pertaining to these two sellers, further corroborated being allied firms, as name of proprietor, director, promoter, and addressee are matching. This violates GEM's GST clause 29, one bid per bidder. In order to arrive any conclusion, it is suggested that GST and data may be re-verified at your end. If found conclusive, incident against errant sellers may be raised at your end as per GM incident management policy, clause 2.2, incidents not variable through the data available in GM, indulgence in anti-competitive behavior or cartel formation. As per vigilance report submitted by GM authorities, it is determined that both firms are allied firms, common owners, as per GEM clause number 29, bit so-and-so, as well as the GEM incident policy, once dated so-and-so,
So
matter
you
has
received
been
the complaint, you verified that yes, addresses are common and according to you,
He
they
made
are
a
allied
complaint in
companies.
November. They replied.
Yes, allied companies, and so therefore you
this is
raised,
now
raised the incident.
we said paragraph 7 at page 92.
You raised the incident at
Yes,
paragraph
we
6.
said
Yes.
that hence it is requested that due administrative action may be taken.
Right.
This is what we did. Now, my lord, and my lord, that 22 complaint is at page 93, which I did not go through because that is at page 93, that 22nd of November. Now, my lord, will kindly come. To grounds of administrative action, that is at page 80, page 58, my lord.
Page 80?
Page 58, my lord. Of my
58,
lord's
yes, yes.
Now, my lord, administrative, my lord, ground 21. Administrative action may be taken by the GEM against the buyer or the seller, either suo motu on the basis of this platform mechanism identified through analytics, or on the basis of complaint or report made to GEM by any stakeholder or any third-party information, or upon court order inter alia for non-adherence of GEM website policies, including terms and conditions, and the incidence of management policy published on the GEM website. This is my lord, the complaint which I read, my lord. The seller would be liable for administrative action such as suspension, debarment, removal from GEM if they fail to abide by the website policies, including the terms and conditions stipulated in the document, and or any one or more of the following grounds. Now, my lord, if kindly comes flip goes to the next page, my lord. That is ground M, my lord. Performs any activity which is listed as prohibited activities on GEM. Then, my lord, note the ground mentioned above illustrations only, users are advised to read the list and prohibited activities. So we have already made it very clear that whoever prescribes to this GEM terms and conditions will have to see and adhere to all this. Now, my lord, will kindly come.
The list of prohibitive activities
Yes,
are annexed here.
Yes, my lord. Now, my lord, will kindly see at page 137, page 125, 124, my lord.
Okay.
My lord, the list is there, my lord. Why I'm
63 is the list, yes.
Page 124, my lord.
124.
That is, my lord, government e-marketplace incident management policy. Now, my lord, will kindly see. If my lord kindly comes to page 127, even at the cost of repetition, because it was already, my lord, placed before my lord by my learned senior friend on the last occasion.
Yes.
Page 127.
Yes.
There are, my lord, 3 categories. That is clause 2, my lord, clause 2.1. Based on the severity of the incidents, the deviation of GEM are categorized into 4 levels, namely mild, serious, severe, and grave. Now, my lord, we'll kindly now turn to page 137. Lordship has got it?
Yes, yes.
14, my lord. Indulgence in any anti-competitive behavior or cartel formation, severe. Now, my lord, now the procedure which is to be followed as far as severe is concerned. That is at page 130. 130.
Yes.
Lordship will kindly see C. Just about a 3.3 million. 3.3. Severe deviation. The severe incidents are those which adversely impact the reputation. This is not more than based on the outcome of the finding of the show cause notice. Now, they have not given us a show cause yet. That page 100 is a letter of their own accord.
You will give the show cause. Who will give the show cause?
They will have to give the letter which
they'll have to give a reply to the
I apologize, my lord. I stand corrected. Now, my lord, the show cause first notice will be given, my lord. Now, how we have issued a show cause and no reply has come yet.
Where is the show cause notice?
My lord, will kindly see initially. May I place this first, Milord? Just for my satisfaction. If no, Milord, finding of the show cause noted, if no deviation at the users and incident will be closed. Then, in case there is an unsatisfactory explanation by the buyer seller SP, the following steps shall be taken. Buyer, primary user, and competent authority to be notified for necessary action. Seller, SP suspended. Now, this necessary action. Now, Milord, what happened is, now, Milord will kindly come to page 100. Initially, Milord, page 100, Milord has got it. On 9th of January 2024, they give this particular letter, Milord. And Milord, how they've described it, that is at page P6, Milord. Now, Milord, we kindly see page 5, paragraph F of the petition.
Yes.
In terms of the incident management policy of the GM platform, a notice period of 7 calendar days is provided for rectification of a deviation after it is reported on the GM platform, and accordingly the petitioner firm, via a letter dated 9/1/2024, provided an explanation to the incident, mentioning therein that the fact that Navonita, being the senior manager of tender and works coordinate department, was pregnant and working from home, and while coordinating with the junior staff, namely Nitish Shah, inadvertently without being properly instructed, proceeded to apply in the said NIT for both petitioner firm and Securado Industries Private Limited, in spite of SIPL as a reselling seller being technically ineligible to participate in the tender. So they accepted this on 9/1/2024. Now, on the basis of this, we
accepted that they had both had applied.
They had both applied.
Reason for that, which had to be considered.
Yes, we considered that. Now, my lord, what happened is,
yes,
if my lord kindly comes to page 102.
102, yes.
Last paragraph. In rectification to the report, corrective action, we would like to inform you that in future we shall ensure strict vigil in our group and ensure that the sister concerned do not participate in the same bid process and comply. So there's an admission. Now, my lord, how we have replied. Now, my lord will kindly come. Yes. Now, everything, this is the trail mail, Miller, which starts, Miller.
Which page?
Miller, page 118, piece 7.
Yes.
And supplementary also, Miller, it is an amplification of that. Now, Miller will kindly see created on 2/1/2024. At top, Miller, date.
Right.
And 19/1/2024. So, Miller, whatever incident happened, which was before my lord, is this chronological events, Miller. Now, Miller, when they saw that we had raised a complaint, whether this thing has been made or not, they gave a reply, rectification action. Now it is upon me whether to accept it and close it or to escalate it. When we escalate it, then they are asked to show cause. There they gave a letter that writ petition is pending.
What is the escalation?
My lord will kindly, this is this page 118. Now, my lord will kindly see. This was 2/9 they have given that letter. Now, my lord will kindly see. না না আমি এইটা পুরো পড়ছি আমি এটা পুরো না আমি আমি ওই সাপ্লিমেন্টারিতে বলছো না তুমি হ্যাঁ আমি বলছি এটা তো লেখা আছে তো লেখা আছে my lord will kindly see the justification submitted through the reply, their reply against so and so dated 2/1/2024 regarding the participation in the sandbag bid, the two sister concerns firm is not satisfactory and in violation of the GM general terms and condition in this regard, the headquarters so and so dated 19 January 20 attached. This is where we raised this on 19th January 2020, which is at the next page. My lord, have you got it? This is where it is from the ministry, means respondent number 3.
This is the escalation.
This is from the respondent number 3 to CEO GM and Sri Bharat Bhushan, who had initially given us the information through our letter dated November that there has been violation or not, because there has been a complaint. So then he said that on 2nd, this is the situation. They gave
initially you complained.
Yes.
Incident was raised. They gave a reply.
2nd and 9th they gave a reply. 100 is 9th.
Then
9th they said rectification measure.
Yes.
That was a rectification measure.
And 118 is the indulgence you give.
Yes. Then rectification came. We did not accept the rectification. That is on 19th of January.
Further reply from them within 5 days.
Then yes. Now with that further reply on this, they did not give. They came before my lord. And my system is automated.
My system is also automated in these sort of procedures of the government.
My lord, I apologize. My lord, I apologize.
Government system can be automated. Court system can also be automated.
Wrong,
This sort of procedure,
wrong,
this sort of orders.
Wrong terminology. My lord will not take. I am used to making such
Mr. Trivedi,
exuberance. My lord knows. My lord, sometimes I
in LOCs, we have got automated responses now.
My lord, I am in a habit of using wrong words.
Same applies to me, Mr. Trivedi. Don't blush about that.
So I'm not. Therefore, my lord will not take me amiss.
Then
So my lord, what happens is then this my comment comes and we say that these are not acceptable.
Yes.
Then, my lord, we will kindly see.
Right.
They are supplementary. अच्छा इनसे अभी तक ये हमको नहीं पता लगा है प्लीज बोलो मैंने ऐसा नहीं किया हम लोग को पता my lord verbal instruction from departments it becomes very dicey for us
very risky for you.
Therefore I am asking my manager because this instruct वो क्या बोलते हैं
Not to pass the buck.
My lord, I always want a email recording of whatever because of
telephonic buck. Yes.
Now, my lord, will kindly come to the supplementary affidavit. If my lord kindly sees supplementary affidavit annexure P10.
Right.
Reference show cause notice. Without prejudice to our rights to file appropriate reply to the SCN, we have filed a writ petition. So, my lord, show cause they have not filed. They have given writ petition is pending. My fault is this, that it was an automated thing. So through that automation of 5 days, it has given, we have not debarred. They will file a show cause. We will consider it.
What is the further scope of show cause after this?
My lord, they will show cause, my lord. My lord will kindly see there is an automated system. That does not mean that they have been debarred from what my lord will kindly appreciate. I am trying to make it clear to the best of my ability. Now, my lord will kindly see the sequence of event. I raise a complaint. 1.
Yes.
I raise a complaint. I come to, they raise a rectification. After receiving the rectification, we say we do not buy this rectification. So escalate. As soon as escalation goes, they are asked to give a show cause. When that escalation show cause is asked for, they come up with this letter that they have challenged it. On when, my lord, and we in the 19th letter we had said that 5 days we have been given. Now, when the matter was heard by my lord, 25th had come. So if my lord kindly sees the supplementary, this escalation. Now, my lord will kindly come because 6. Yes, my lord. Page 7, my lord.
Oh.
Page 6 or 7, no?
Seven.
Seven.
My lord, if I am wrong, my lord, because my learned friend is saying that I am not the.
No, I am not saying anything.
No, sorry.
Page 7.
I always stand corrected.
Auto action this.
Now, my lord will kindly see. 25th, my lord, on top, my lord. This is what they are saying, my lord. Since they had said that give us within 5 days, if my lord kindly comes to the sect, 19/1/2024, my lord. There are 3 segments, the middle segment. Now, my lord, may I read for my satisfaction? It has been reported to GM that there has been indulgence in any anti-competitive behavior or cartel formation of GM. This kind of infringement on your part is affecting service standards, which you have agreed while registering in the portal. This infringement is a severe deviation as per incident management policy of GM. You are required to provide your reply, comments within initial 5 calendar days of issue of this notice. So this is the show cause. Issue a notice. In case no response is received, then you will be provided 5 final calendar days to provide your reply, failing which auto action will be taken by the system against your account in accordance with the IM policy.
So 5 plus 5 days. 5 plus
No,
5 days.
my lord.
It says you are required to provide your replies to comments within the initial 5 calendar days of issue of this notice. In case no response is received, then you will be provided a final 5 calendar days to provide your reply comments, failing which auto action. Therefore, 5 plus 5, 10 days.
10 days. Now, my lord.
Take an auto action on 25th.
My lord, that I have to take instruction, my lord.
No, it is there on record.
My lord, may I? Now, my lord. So, my lord, what I am on.
As an innocuous order, Mr. Trivedi, I'll just set aside this portion and then take instructions.
My lord, they have not
given give even 10 days to them.
No, my lord, it is not.
But the territorial jurisdiction point remains here.
Territorial remains, my lord, arbitration remains.
Yes.
Both remain, my lord. And it's my lord's judgment in my respectful submission where my lord has held.
I have held both ways. Forget my judgment.
No, in this case, which my lord has held, I've got that judgment, my lord, because I'm used to.
No, then what happens?
No, my lord, may I apologize. To provide reply, no, my lord. In case no response is received, then he will be provided final 5 calendar days to provide your reply, failing which auto reaction will be taken by the system against your account in accordance with the IM policy. Kindly note that upon receipt of the notice, you are required to acknowledge the same, failing which you will not be allowed to do any other activity. So this, what has been done, is not being allowed to do any other activity. This is not debarment. Now, my lord, will kindly come to the first portion, that buyer is requested. The first which they are saying, it is, they have told us that if we have taken any debarment decision, then we should upload it, then things will go on. Because they have not filed a show cause. So whatever has happened is, my lord, it is not because they have chosen not to file their show cause and they have that opportunity of filing show cause. It is not that without giving them an opportunity, they have been debarred. It is wrong interpretation of this auto-generated emails.
No, my simple question is, you had to give them 5 days. 5 plus 5, 10 days.
My lord, I am lacking answers to my lord. So my lord will give me 1 day's time. Let me come back tomorrow.
Every time you lack answers, I'll give you 1
day. No, my lord. Today, yesterday, on that day, my lord, I did not even, my lord, utter a single word. I was just on jurisdiction and arbitrational point.
Go on like this whenever you are.
My lord, it is.
It's there on record. You answer on the records. Buyer is requested to upload and share the debarment order. How can you do that? This is on 25th.
Debarment. However, whether uploadment have stopped automatically or not. That is what I want to know. So that is the instruction which I want. My lord, because I have to understand, because debarment has not been done. What my lord, upload korte parche na কিছু ওটা করে দেখেছেন আপনি মানে আপনার client.
Buyer is requested to upload.
My lord, because my lord, that is totally on a different footing. They are asking me that you upload your debarment, but whether they have been, what they have come with this supplementary affidavit is about debarment. not about.
What does it mean by the the debarment order issued by competent authority? Who is the competent authority?
My lord, we are the competent authority, the buyers.
Competent authority of buyer organization
yes,
or
my lord.
ministry.
Yes, my lord.
That is you. Yes.
Yes, my lord, I will. So I am still deliberating on it.
All right.
I am. My lord, so my lord, why they have come before my lord is being perturbed, my lord, by this particular email.
Mr. Trivedi, if they get an opportunity to give a show cause, to give a reply to this show cause,
yes, my lord.
After that you can take your decision. So they are not prejudiced in that.
Yes, my lord. In my respectful submission, that is what I understand with the series of events, my lord. But, my lord, in my respect, I again repeat and reiterate, my lord, territorial jurisdiction as well as arbitration, my lord.
Mr. Mujumdar will have to answer first.
Because, my lord, what has happened, these things happen pan-India basis, my lord. Right. Then, my lord, anywhere person being from any part of the country will apply in this particular site, and, my lord, taking into consideration, my lord, if my lord sees, my lord, these type of sites, my lord, as far as my lord, the IT Act is concerned, it says that the buyer's place will have jurisdiction where it ends. Supposingly, I have sent an email.
The IT Act says so.
My lord, there is a section, my lord, I
am not aware. I mean, I don't know.
Maybe. But I also read everything yesterday, my lord. I was also not aware.
IT Act was.
But this agreement remains. This agreement fixes the territorial jurisdiction to that.
My lord, and they have adhered to it, my lord. So when their jurisdiction, territorial, arbitration, everything is staring at my face, my lord. Right. Now, my lord, so, and since if it is not adhered to, my lord, it will open a Pandora's box in my respectful submission. Reason is that, my lord, everything now is happening on websites.
Yes, yes, absolutely.
So, my lord, anybody can, my lord, pick up a jurisdiction from any point of, from any place where he has a laptop and he has accessed this site, my lord. So, my lord, in my respectful submission, then the entire GM terms and conditions which they have vouched to adhere to will become just a piece of paper.
So let me hear Mr. Mujumdar on territorial jurisdiction and all the points.
My lord, as far as GEM is concerned, because this particular supplementary affidavit and this particular communication which has been made is just what is going to happen, the middle one which I had placed before my lord, where my lord was pleased to, my lord, ask me, my lord, as to whether we have given that 10 days time or not. Yes. Now, my lord, we are totally aware because my learned friend will put light on it that whether his client has tried to, because he has come up before my lord with regard to debarment. No, but we have not given any instruction of debarment. We have not uploaded any debarment instruction on the website. My standing instructions I have.
Stay
because of the stay. My lord, stay. My lord, on that day
is operating.
Yes. No coercive action, my lord.
That is on the basis of this, the order.
No. This is putting word into my mouth. Something which we do not attribute ourselves to. We have not debarred because if we would have, my lord, when they came before this honorable court, my lord, and my matter was taken for hearing, my lord, that was on Tuesday, my lord. Till that day, nothing had happened. We had not loaded anything. So, my lord, in my respectful submission, my lord, so, my lord, these are the 3 points, my lord, as far as that aspect is concerned. If my lord gives me a breather till tomorrow, my lord, I can get specific instructions in writing.
Which aspect?
That 10 days, whether we, because if GEM has not stopped them in their operation.
If you have not uploaded the debarment order, you have given them the 10 days there. Obviously, you have given them.
Yes.
Obviously.
We have not uploaded the debarment. That's my instruction.
Let me hear. Mr. Mujumdar, territorial jurisdiction is a very strong point.
Very strong point. But according to him.
Yes.
Kindly takes note the.
Nice.
No, but you have challenged the action taken on the basis of this contract.
Please see pages 56 and 57. But I recollect, in courtroom number 16, the Honorable Presiding Judge scolded one of the counsels for Union of India saying, how can the Union speak of territorial jurisdiction being elected?
We didn't start the fire. We didn't start the fire. they have
No.
they are something else.
Something else.
Something else.
You are listening to too much 90s music because you didn't start the fire. Yes.
My lord recollects it.
Please see page 56, clause 7.
Yes.
The contract shall be interpreted and governed in all respects in accordance with the laws of India. All disputes in connection with or arising out of the contract, C appears with a capital. Contract appears with a capital C. Shall be subject to the exclusive jurisdiction of the court within the local limits of whose jurisdiction principal place of business of the buyer department or organization is located. Principal place of business of the buyer department is located. Please now see 57. Jurisdiction of courts. The courts of the place from where the contract has been made shall alone have jurisdiction to decide any dispute arising out of or in respect of the contract. So this is the choice of place. Now please come to the definition of contract in the document at page 28. Clause J. Contract shall mean the purchase order created or issued by the buyer on GEM for supply of goods or services in electronic form, which includes scope of supply, delivery instructions and specifications, etc., as ordered by buyer against such contract besides the subject GTC, STC, ATC as the case may be.
The purchase order was issued from their place.
Purchase order might be that tender, bid. It's not the bid. Purchase order has not been issued yet.
Yes, the tender, yes.
Tender. It's a bid. It's at the bid stage.
Achha.
Number one, when the union is trying to identify a party for the purpose of entering into a contract, then this may apply.
So all this pertain to only to the when the contract takes place.
Yes.
Pursuant to the tender.
Tender.
Not at the tender.
We are at the stage before. Your Lordship, kindly recollect Radhakrishna Agarwal, which has now been a little watered down in that MP power case. But the question was, at the time of entering into contract, one may allege violation of Article 14 against the state. But once contract is entered into, then a different test will apply for the purpose of admissibility of a writ petition.
Yes.
That's how it distinguishes. Now, so also the arbitration clause at page 55.
Everything else then relates back to this.
Yes. Can I take page 55? This will make the thing all the more clear.
Yes.
The parties, that is the buyer and the seller, undertake that any conflict or dispute that may arise between them shall first be dealt with in the manner stated below, irrespective of any other recourse which any party may have in law or in equity.
This is your placing?
Page 55, clause 16.1.
Conciliation, yes.
Then arbitration, 16.2.
Yes.
16.2. In the event of any conflict or dispute arising out of or in connection with the contract placed through GEM, the parties shall endeavor to settle such disputes amicably. If a dispute is not resolved within 30 days after a written notice of any dispute by one party to the other, the same shall then be resolved through the mechanism of a dispute resolution committee. The dispute resolution committee shall so and so.
So nothing comes in because the purchase order has not been issued.
And please see the arbitration clause. In the event of any conflict or dispute arising out of or in connection with the contract placed through GM, which has not been resolved in accordance with, contract can only be bilateral. Resolution of dispute either through conciliation or the arbitration clause, this must be between two identified parties. Unless the seller is identified, I don't understand how this conciliation or arbitration clause can step in the way of admissibility of a writ petition.
Right. And what about this being premature? Because you have a right to give a show cause.
Oh, now please see the flow of events. But first is BSF writing to GEM at page 91.
91, yes.
Then we reply at page 100.
First is actually page 93 probably.
Yes.
From where it started.
93
the first complaint.
Yes, the complaint.
Then 1991.
1991.
Right.
Then
first 91, then 90.
91, then 90.
Yes.
Then 100.
Then 100.
100. After that 118.
Then 118. 119, then 118.
119 reject করলো upload হচ্ছে 18
Yes. So after that,
there are two two-prong attacks. Not one by the buyer, the other by the GM company.
GM only facilitates the attack.
Yes,
basically.
he should be acting as an agent or a facilitator. Now, to have a different consequence arising out of a single bid, that's not arbitrary. That's the ground of attack in clause that 21.
Where is that page?
That's page 58. This is now a compulsory platform for the purpose of participating in tenders of all governmental authorities.
But why not? This is the administrative discussion. I mean, they can make a common platform. Why not?
Can, but not the consequence.
But they will give an opportunity to show cause also.
That's right. Not all action, not which will have the effect of debarring me. Not there are two debarment now. One is debarment by the buyer, not which BSF has initiated. The other is a possible debarment by the GM company on the strength of page 58, which is now being escalated. And this I challenge on the ground of the consequence which may befall or entail. But if one is acting as an agent for a particular, I have shown to your lordship pages 38 and 39. What is the purpose of the policy? Is to identify a seller, apropos a buyer in respect of a particular tender. I cause a breach.
But GM, you will be debarred from GM only if you don't adhere to the GM website policies.
Yes, this is the policy.
ও বলছে যে আমাকে এই যে অ্যাডমিনিস্ট্রেটিভ অ্যাকশন নিচ্ছে বিকজ আই হ্যাভ ডান সামথিং হুইচ ইজ প্রহিবিটেড ডাবল বিডিং ইজ নট প্রহিবিটেড অ্যাক্টিভিটি পেজ প্লাস 21
page 63 page 63
2am performs activity prohibited. It is not a prohibited activity, double bidding.
That you said tantamounts to a blacklisting in the sense. I mean, otherwise, if this was not there, then the government could have said that yes, the government can debar you from participating in all government transactions.
Yes. Same note for Union of India, BSF, I am debarred or blacklisted for say 2 years.
Or all government companies also government may say.
They not state.
That will be a specific blacklisting.
Yes.
Upon you have to be heard, show cause has to be issued.
Yes.
That must be on a much more serious footing.
That's not the consequence which we entail by reason of that page 58 document. Not page 58, that's page, yes, page 58 document. Please see the consequence at page 64. Clause 11.
Yes.
If any seller has been debarred from GM, then such seller or their authorized sellers shall also not be permitted to register and offer or sell their products on GM and or participate in bids or reverse auction on GM. Similar, I want to participate in a tender floated by state of West Bengal. I am debarred.
The next one is more serious. Using
GM prices for making outside GM portal. Not whenever I upload this price, this is available to all. Everybody is having access to my price quoted.
Clause 21 is very serious, yes. This part of
this is the
GM.
consequence, yes.
But I don't find much inconsistency in the other portion, because first an incident is raised, you are given an opportunity, it's escalated, you are given an opportunity of show cause. After that, finally the decision is taken. On the other aspect of the matter regarding the buyer having that power, I mean, I don't find any incongruity in it.
No, buyer may have the power to blacklist me. Not that it's always there.
Not blacklisting.
Or say take any action of debarment.
Take any action. Yes, blacklisting in a sense.
Yes.
Debarment. But that can happen once, because the other part, I don't find any discrepancy in that. Because you have been given opportunities to show.
That's right. Not I had
have given a reply. Further chance of reply is there.
Not the consequence was not BSF got it verified from GM, and GM said you take action.
Yeah, there are two aspects of it.
Yes, it's
GM is a facilitator. Now you are giving 2 or 3 opportunities. First, they complain. GM gives you raises an incident, and then that incident is replied to by you, then again it's escalated. After that, you get a chance of show cause, and then you are blacklisted by the buyer on a particular allegation.
Now, please see page 91. This will probably give an indication.
So there I don't find anything, any irregularity or illegality. 91.
91. As per the complaint lodged by so and so, director of Hatchery, dated so and so in subject procurement regarding Sri Durga is having common owner. I did not trouble your lordship. This headquarter approached GM authority on 22nd November 23 through email dated 22nd November to ascertain its authenticity. So this is now verified. Kindly turns over the page. This is through email on 24th November 2023, which is reproduced below. Then the next page. As per vigilance report submitted by GM authority, it is determined that both firms are allied firm or common owner. As per GM GTC clause number 29, one bid per bidder, as well as GM incident management policy with effect from 1/7/2023 clause number 2.22, and B, matter has been approved from competent authority on the issue under this dispute. Apart from this, the following firms have done this. In such circumstances, incident is hereby raised against Sri Durga, being allied firms with common ownership and so, for having indulged in anti-competitive behavior and cartel formation by using same IP address as the above, that is the other firm, in bid GM number so, in procurement of sandbag dated so, in which Sri Durga Industry Kolkata L1 is in said procurement after opening a financial bid. On seeing the documents and other reports received from GM Vigilance Cell, it is decided to cancel the above bid. So this is the action of the buyer. Hence, it is requested that due administrative action may be taken against the above firms. Incident has been raised for blacklisting and intimate to all concerned accordingly for your further course of action.
Further course of action does not mean immediate publishing it on the website.
No, this is
next steps has taken.
GM. That's why I have carrying the policy.
And you have also, Mr. Mujumdar, your client has also admitted that you two are common firms, and the management is common, and you have cited the pregnancy of a lady.
No, I say that the one was ineligible. Apropos the tender.
Even then, even if it was ineligible, knowing fully well, why did he participate? Why it participated? There is no doubt on that.
Yes, not
subsequently saying that it is ineligible. Then why did you participate in the first?
So admission was this, that the firm was ineligible to participate. Be that as it may, same not with a clandestine intention, I have participated.
You have given two reasons. One, that a lady was conceiving, and another was careless. Now, they may very well not only dispute, may not accept these.
May not accept. Not
you are given opportunities twice. You have been
given the opportunities in respect of two separate courses of action. Your lordship will be pleased to find that when the action is being initiated, it is being initiated jointly by the buyer as well as by GM.
Yes.
Now, not the consequences of the action initiated on the basis of a single complaint. It can be, not is manifold in this case. What is the manifold?
You are blacklisted from the participating in the GM website. That is one aspect of the matter, which is more general. And the buyer is blacklisting you. That is another aspect.
Now,
regarding the buyer blacklisting part, Mr. Mujumdar, I don't find any discrepancy here.
No, buyer blacklisting part is once again on the basis of this, because the reply is not being considered.
Reply has been considered.
No, please see. Please see any of the documents.
They have not considered.
Page 119. Please see 119. As per incident number so and so dated 2/1/2024, incident was raised by GM against Sri Durga Industry in bid number so and so dated 21st August 2023 in procurement of sandbag. The reply submitted by the firm are as below. Left hand is reply received from the firm, right hand is the comments of the buyer. Please see, it ends there. Page 120, please see. Owing to such reason, almost 5 months period was wasted since publishing a bid to till opening a financial bid. Later on, bid has been cancelled, which is a major concern for a department as action on the part of the firm create hindrance or obstacles in procurement of stores immediately. Further, GM authorities may like to take action as per policy matter in dealing with such defaulters, referring it to GM.
No subject.
No,
that's the second component.
No finding at all that very well these are not acceptable to us, and therefore I proceed to move further.
Decision of the in terms of 3.1.2.
And if your lordship kindly recollects, not the procedure for taking action on the basis of mild deviation is same as the process for taking action in respect of severe deviation. Please see 3.1.1 at 129.
1.1.2 তখন আমারটা accept করছিল না তো ওটা থাকতে হবে কেন accept করছিল
Mild deviation, not the processor in both the deviation is same. Page 129.
Yes.
Clause 3. Process flow for handling incidents on GM is as under. 3.1 is mild deviation. Just to show that the same process will apply, lordship may turn back to page 127. No, 127. I'm sorry. 130.
130 top and 130
130.
top and 8.
3.3 severe deviation. The severe incidents are those which adversely impact the credibility of the platform. The process flow for handling severe incidents shall be also the same as mentioned for serious incidents based on the show cause notice. What are the serious incidents? At the top. Serious deviations are those which have the potential to adversely impact the market ecosystem. The process flow for handling serious incidents shall also be same as mentioned for mild incidents. Now, what is mild incident? 129. First, seller against whom an incident is raised shall be provided with a notice period of 7 calendar days to rectify the deviation and report such corrective action through IM module. In case of rectification or reconciliation at user end, no further action is required and the incident reporter can close the incident.
Here there is a scope of rectification because you have already submitted.
Submitted. Now, it could have been, look, I want this we have found.
You are not
I am withdrawing.
Proceeding with this.
Yes, I am withdrawing. In case of non-rectification, the reporter of the incident can escalate to GM admin. Auto show cause notice is sent by GM portal upon escalation of incident.
Rectified. You are given the opportunity. You never reply, but you did not say ever that yes, I withdraw the other bid.
But by that time, it has been opened and it has been disqualified.
Therefore, there is a scope of rectification.
In rectification, report corrective, we would like.
How can you rectify?
No, please see 121. No, that we have said that it was by mistake and there is no scope for a recurrence.
Will never repeat.
That is different.
Please see in rectification and to, no, please see in rectification and to report corrective action. We would like to inform you that in future we shall ensure strict vigil in our group and ensure that the sister concerns do not participate in the same bid process. Not maybe in the not in the same tender.
You might have been rectified, but the act has not been rectified.
No. In case of non-rectification, the reporter can escalate to GM admin. Auto show cause notice is sent by GM portal upon escalation of incident to GM and it will be reflected on the respective user's GM dashboard. Issue of show cause notice shall not have any impact on the business of the buyer provided in GM. Then show cause notice shall be responded or corrective action be taken and the same reported to the IM module against the incident by the user against whom the incident is raised within 5 calendar days. In case no response is there in 5 days, a warning will be given by system to the to be raised against the party. If show cause notice is not responded by clicking on respond to SCN option, even in 10 days post SCN sent, system will automatically take action against the raised against party. GM admin may seek further clarification from any of the stakeholder. After the response of the show cause notice has been received, the concerned stakeholder has to respond to so and so. Now, not the after 5 days, the decision taken is you take action for debarment.
After 5 days not. এই কোশ্চেনটাকে কনসিডার করতে যেটা আমরা দেখলাম আমাদের কাটেন ফরমেশনে কোনো ইন্টেনশন ছিল আমরা ডিল করতে
Is there a limit for the debarment? Is there a limit?
Not yes, not there is at page 130. 3.3.2. Based on the outcome of findings of the show cause notice, please see B. In case there is an unsatisfactory explanation by the seller, the following steps shall be taken. B. Seller suspended by GM admin for a period of 60 days for first and second deviation within a period of 180 calendar days, up to 90 days for third and subsequent deviations within a period of 180 calendar days, and up to 2 years with approval from Chief Marketplace Officer GM. Deviation reflects in the overall seller or buyer rating. Now, not if GM, my question before it, I flagged this issue before this honorable court. If GM is acting as an agent of the buyer, why should the action percolate to any process beyond the subject tender? And that's clause 21 under challenge. But what fell from the honorable bench was, what about your action in the subject tender process? Not apropos the subject tender process, I run the risk of facing a debarment from the buyer.
But is it absolutely, I mean, unheard of that blacklisting cannot be in respect of all government companies? Suppose you do something of that sort, you are giving an opportunity to show cause, to give a reply. You give a reply, they're not satisfied, you are blacklisted. That blacklisting may not be restricted to that particular wing of the government. It may be for other wings of the government also.
Not,
That the
and
government,
that's why I have,
all government contracts you are debarred from.
that's why I have shown to your lordship that rule 149 of the GFR.
Yes.
It's covered, the field is covered.
এইটাই ওদের পাওয়ার। This is a source of power.
आराम से আমাকে একটা
শুনি তো 149
আমাকে একটা কপি দাও না দাদা কি বলছো বুঝতে পারছি না
This is where you get the power.
আমার কাছেও তো নেই আমার কাছেও তো নেই আমার কাছেও তো নেই
পেয়ে গেছি কোনটা দাদা ছিল
and please see this with 151.
Yes, 151 is very important.
And the source of power for framing this policy stems from 149.
Yes, it is.
Please see the 151 II. A bidder debarred under subsection 1 or any successor of the bidder shall not be eligible to participate in a procurement process of any procuring entity.
No, that is regarding Prevention of Corruption Act and IPC.
These are the two circumstances.
You are not falling under that.
So that's the debarment from
three,
bidding.
3 comes in. Roman 3
A
comes
procuring entity, a procuring entity.
Then
But 2 is wide.
restricted to only one, that procuring.
Yes. A procuring entity may debar a bidder or any of its successors from participating in any procurement process undertaken by it.
Yes.
Suppose not today BSF debars me, not I have a right to challenge it. But not GM portal has acted that rule 21, policy number, that clause number 21 in the policy.
Yes.
Is dehors 151 too also. Page 58.
Right.
Not 2 and 3, interplay of 2 and 3 leads to the only possible conclusion that 2 is wider and general on the happening of 1A and B. That's why a wide power is given and a larger consequence befalls.
Gravity of the incident. It has to be seen. To beat the
Whereas 3 is restricted to an individual procurer. এই তো আছে কি বলে
সুস্পষ্টত ওরা বলে দিচ্ছে সব জায়গা থেকে এবার দেখে kindly note that upon receipt of notice you are required to acknowledge some failure which will be allowed to do any activity on GM. তার মানে শোকজটা ওই জন্য চ্যালেঞ্জ করেছে because that is contrary to these rules and so the showcause.
And regarding this violation of GM conditions, the second part of Rule 21,
yes,
this administrative action may be taken by GM against the buyer or seller either suo motu or on the basis of platform mechanisms identified through analytics by any stakeholders for non-adherence to the GM website policies, including terms and conditions. This is independent of
independent of the buyers.
Entirely independent of that.
Now, GM says to buyer, you debar. Buyer says to GM, you proceed.
I don't come under him, Dada. I don't come under. It's not a prohibited activity. Prohibited activity করে দেখায় না আমি দেখিয়ে দিচ্ছি কি আছে it's not there in the list of prohibited activity ও বলছে I come under this name M. That's where the action is taken.
No, but the specifics have been given when you will be debarred from participating in the GM as a whole.
Yes.
In 2, Roman 2.
Yes, please.
21-2.
Please have a look at 21-2.
Yes.
Although not exhaustive as mentioned in this
Not exhaustive.
clause
Yes, yes.
also.
That is very risky though.
Now, please see clause M. Performs any activity which is, that's what they are claiming. Page
Yes.
59. Performs any activity which is listed as prohibited activities on GM.
But those are very serious. I mean, please come
Yes.
to
Please
page
see,
63.
please see what are the listed prohibited
Indulging in
activities.
cybercrime and other criminal activities. It's
Yes,
on
yes.
a very, if you do that, you should not be permitted to participate in the
Yes.
G.
Now, please see now page 63. They are referring to clause M. Performs any, this comes under the residuary clause. Clause M. Performs any activity which is listed as prohibited activities on GEM.
Yes.
Now, please come to the list of prohibited activities at 63.
Yes. They include
indulging in cybercrime.
Cybercrime is very serious.
Yes, that's right. 11. If any seller has been debarred from GM, then such seller, that's the consequence. Can't be a prohibited activity, that's a consequence.
Selling, refurbishing, complete
But just out of the blue, a consequence is roped in as a prohibited item. না না ওটা বলছি না
কোনোটাই করিনি
আরে ওটা বলছি না clause 11 is a consequence, can't be a prohibited act.
Prohibited activities. কিছুই নেই। Prohibited activities.
But it does not come under prohibited activities list.
Even
As
is
such.
an aberration.
It does not come under prohibited activities list.
But the others are very serious. Harms minors.
Yes, the others are very serious. But clause 21 is this, clause 29 is one bid or one bid. And what is one bid? If you have persons in having more than 10% control or like that, then it is not a single bid.
Yes, that is to make it widespread. I mean, so that it's not, there is no cartelization or monopolistic activity among the.
Yes, not
that may be a valid.
That may be not tested. Not
that's government policy also. I mean, we
yes,
cannot
not
do
now
that after a limit.
Now, not the competition so far as cartelment is concerned. That's covered by a law.
Anti-competitive act or anti-competition.
Anti-competition act. The competition act.
Competition act. Yes.
Now, that defines cartel in a particular manner. The other point would be, how can cartelment be defined in a different manner by this administrative guideline? If the purpose is already covered by a legislation.
Well, Mr. Mujumdar, please put your points in a short notes. And Mr. Trivedi.
On the territorial jurisdiction,
Yes,
Mr. Chakraborty had succeeded before your lordship in another judgment. But I have been educated by him now.
The combination is bad. Don't cite it. Combination is bad. Mr. Chakraborty and I know.
So, my lord, we'll file it on Monday or Tuesday.
Mr. Mujumdar, if you can, please just hand over your written notes of arguments to Mr. Trivedi so that. So, how soon can you do that, both of them? Cannot be before Tuesday.
Tuesday.
So, you give a copy prior to that on Monday or Sunday.
It on Wednesday, my lord.
তোমাকে ইমেল
Email করে দেবে।
Oral arguments are concluded in the matter. The matter be listed under the heading to be mentioned on February 7, 2024 for the purpose of filing of written notes of arguments by both sides.
I'm grateful.
Thank you.
Oh.
I'm not, parties have agreed to get it sashed out without affidavits, kindly.
As director line at Kutra. As
no, my lord, we have not agreed. My lord can relegate it to, because my lord, we don't have instruction, because I was not prepared for.
Relegated to what?
My lord, we cannot be recorded, my lord, on consent that we don't want to file affidavit, because
no, I'm not recording that at all.
Because they is challenging a particular.
How can I record that? You're not given the consent, I record that.
Well, my lord, I apologize.
Actor and Kodin, in view of the issues involved being based primarily on the interpretation of the documents annexed to the writ petition, comma, no affidavits are invited by the court. Accordingly, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents. I take it on myself. I have not directed.
My lord will not take me.
No, I have not directed affidavits. Why should I?
Item number 4.
1 minute, my lord. I know this is not the mentioning time. This is not the mentioning time. But out of the compelling circumstances, a set of lawyers, a group of lawyers who have come before your lordship.
Yes, what happened?
Your lordship kindly allow us to mention one very, very important matter.
Original
about the-
side?
About the bar association election.
Acha.
Your lordship knows this very well. Secrecy is to be maintained in when I will cast my vote. This is the ballot paper, and the upper portion is perforated, and the counterfoil is there. This is the counterfoil is taken up by the authority, and the ballot paper is given to the voter. Now it is detected. I have cast my vote. I have not detected. Now today,
I have detected it.
yes, one or two learned lawyers have detected that in the counterfoil that is number. No difficulty, no problem. That is serial number. But in the ballot paper, when after perforation it is given to me, a long ballot paper, which contains all the names of the candidates of all the groups. There is also serial number. There is also
can be identified who has.
that has
Yes.
So there is no
So
secrecy.
election commission may be called, my lord, as tomorrow vote is going to conclude. Let it be stayed, my lord, until
be mentioned.
Otherwise,
before the
election will
chief
be
justice.
fast.
today, right now, we have detected it.
But it has
When
been
I-
mentioned before the
When
chief
I
justice.
told lordship what will happen, because your lordship is already session over one matter filed by Mr. Bhattacharya.
That is on a different
And this
ground.
is, what I'm on is this, my lord, because today, right now, because tomorrow vote is going to be concluded. Now, if it is allowed to, because I requested also the secretary, present secretary, also the other members of the association to stop the vote. They said it is continuing. Yes, many.
Can you please give a written complaint to the returning officer? Whoever is the returning officer, give a written complaint to the returning officer.
But
and
unless
just
it
file
is
a one
stayed,
page.
Unless it is stayed, it is useless, because tomorrow vote will be concluded. Election officer.
Give it to the election officer and just put it by way of a one page affidavit.
Lordship, but may I request make humble submission?
Up to date, already several votes have been cast.
Yes,
How
that
do
is
you,
correct.
how do you recall that?
Most of
We cannot rectify that.
So it has to be stayed as on date, because it will be practically futile exercise, because all secrecy is disclosed.
Secrecy has been disclosed till today. Only 1 day remains, so nothing hinges on that.
At least at this stage, let the election be stayed. They have further there.
What is the use of staying the election now?
Well, if they are saying what is correct is till date secrecy has not been disclosed because they are in a ballot box, duly sealed.
Yes.
So until unless
I have already written on my ballot. I wanted to give complaint. They said you go and lodge complaint. I have written on my ballot paper that how this vote is being conducted, reciprocating the serial number of the counterfoil and the ballot paper. They said,
can you give a notice to the respondent in the that matter and come back tomorrow morning? Tomorrow. This was in the original side.
Yes, original side.
Are they available?
Please come back tomorrow at 3, because before 3 p.m. the election won't end. The boxes won't be open.
Yes.
So come back at 3 and ask for an interim order, please, on that.
Lordship.
On opening of
And
the
also
ballot.
we are giving notice to the election commission so that he may remain present tomorrow.
Please give notice to the
Lordship,
that is
Lordship.
most vital. File that
Lordship.
receipt and mention them at 3 p.m.
It should be taken at
3 p.m.
3 p.m. 3 p.m.
3 p.m. I take up original state matters.
ভোট তো 4:30 অবধি আরে জজ সাহেব স্টে করে দিলে আর সেখানে তো ভোটের কি
Please ask somebody to just give a slip of paper. Ask any of your juniors to give a slip of paper giving the number
Lordship.
so that it can appear tomorrow as to be mentioned. at 3 p.m.
Original side, item number 1.
Is it appearing in the list already?
No. Already lordship heard and
That I remember.
Yes.
But then in a slip of paper, Mr. Bhattacharya, please just give a number. এটাকে কালকে টপে
I'm grateful to your lordship.
3 p.m. বসে এটা।
My lord, can it be at 1 p.m.?
No, 3 I take up original state matters from 3 p.m.
Lordship.
That's right.
Because only for this reason, because so many learned advocates are going to, in fact, they are continuing with their rights.
Whatever has happened has happened.
And now, from onwards, if your lordship,
So that the ballot boxes cannot be opened. If that order is passed, then it will take care of
yes, lordship, grateful to you, lord. Grateful to you. At 3 p.m. What is the number?
it. Please give the number.
Yes. Number. We are grateful.
Item number 4.
Mr. Trivedi has cast his vote. You have cast
my lord, the first day, my lord.
your vote, everybody knows who it is.
Yeah, my lord. Therefore, I am not afraid, my lord. I am not afraid.
2008, same thing was happened. It was cancelled by us, members of the bar. Again, it is repeated since 2020.
But my lord, what happens, my lord, I tell you, as far as I am concerned,
You are
it is-
veteran members of the bar. You should take care of these things, Mr. Bhattacharya.
No, that was taken care. They said that from 2020 it was again started. Unfortunately, I couldn't give the vote. Otherwise, I could have detected it. Today I have detected when I have gone to give the vote for the first time.
But
When
I
approached
also
all
could
the
not
members, they said I didn't notice it because they are putting the scale on the counterfoil so that none can see the number. So I said, ki just push off the scale. Then I found the number.
It was beyond
And
our
it-
imagination that this may happen.
Again,
Electricity.
after 2000.
I cast my vote, I came out and Mr. Bhatta told me, you have cast, what have you cast? This is not a secret ballot anymore. Then I realized that yes, I
And this is the registered
appreciate
now.
that this thing can be happening.
Registered as and now registered as again is doing.
when it was unregistered, nothing was happening. As soon as it became
No, then also it happened, Mr. Trivedi, you know.
Yeah, my lord. My lord, this matter, my lord, I am cutting a sorry figure before my lord. My lord.
Very sorry.
Very sorry figure, my lord. The affidavits, my lord, we have not been treated. My lord gives me a breather, my lord.
Lord, there is an interim application that we have filed. Lord, when the writ petition was admitted, your lordship, Lord, considered the submission and Lord passed an order. Your lordships may kindly take GA1. Lordships will find your lordship's order at page 31.
The application has not been served.
It has been served.
It has been served. It has been served. Sorry. बोले नहीं दिए हैं।
Lord, page 31, if your lordships kindly look at the order. There's a lengthy order where your lordship admitted the petition, but Lord, insofar as my prayer for interim order of stay of the demand is concerned, that your lordship's passed, Lord, at page 34, internal page 4. The paragraph, Lord, starting with the word, insofar as the stay of further charges being levied. Has your lordship found that?
Yes.
By the respondent is concerned, such an order would be an unnecessary interdiction at this premature stage. However, it is made clear that whatever charges are levied from the date of filing of the writ petition on the assumption that the petitioner is a licensee under the 1885 Act in terms of the impugned notice shall be subject to result of the present writ petition. All such charges paid by the petitioner will be without prejudice to the rights and contentions of the parties insofar as the present writ petition is concerned. Then, Lord, your lordship gave directions for filing affidavits. They are to file it by 20th June 2023. Lord, affidavit has not been filed, but Lord, in the meantime, the demand for the next year has come. Your lordships will find the demand, which is at page 35.
So the affidavits were to be filed within 20th of June that year.
2023.
So you have not yet filed your affidavit?
No.
My lord, 1 week.
They have not asked for extension also.
My lord, 1 week. My lord, 1 week.
Then I'll have to
Ma-
say this demand notice then.
My lord will kindly give us a breather.
You cannot have it both ways, Mr. Trivedi. I'll extend the time definitely.
My lord, my respectful submission, my lord, a week's breather, my lord, this weekend's breather may be given, my lord, till Tuesday, my lord.
No, you cannot give effect.
My lord, they have not paid, my lord. Yeah, they have not paid, my lord.
No, you'll disconnect their electricity for that.
No, my lord,
No,
this
this
is
is
not
Lord,
disconnected.
this is Lord, they will Lord withdraw the license. I tell your lordship what the facts are.
No,
Lord,
Mr. Trivedi, I'll restrain you from taking any coercive measures on the basis of this till disposal of the writ petition,
Well,
and I'll
what-
extend your time.
Well,
20th of it was the last date for filing the affidavit in opposition was 20th of
June.
20th of June last year, almost a year back. I mean, several months back.
My lord, my department, my lord, we have written mails, my lord, and it has.
And they did not ask for extension also. They did not come to court. They never asked for extension.
My lord, my respectful submission, my lord.
No. Learned Act Order. Learned Senior Counsel appearing for the petitioner submits that by the order dated May 18, 2023 passed in the writ petition, the respondents were directed to file their affidavits within June 20, 2023. Full stop. However, till date, no such opposition has been filed. Full stop. Learned counsel appearing for the respondents seek an extension of time to file such opposition. Full stop. Next para. However, it is pointed out by learned senior counsel for the petitioner that in the meantime, on January 10, 2024, a fresh provisional demand has been made by the respondents Full stop, it is submitted that the petitioner is being subjected to the rigor of such payment only due to the fault of the respondents since they did not file any opposition in the meantime. Full stop, next para. Considering the submission of learned counsel for the parties, comma, the time for filing affidavit in opposition is extended for, should I give it for a fortnight, Mr. Trivedi, or a week?
Not a fortnight, because we have been writing it to them, Miller.
For a fortnight from date, full stop, reply if any shall be filed within a week thereof.
Make it till the disposal, Miller will kindly make it for us.
Reply if any shall be filed within a week thereafter, full stop. The respondent shall not take any coercive action on the basis of the demand stroke bill dated January 10, 2024, annexed to GA 1 of 2024 till disposal of the said application. Full stop. GA 1 of 2024 shall be listed along with WPO 1168 of 2023 on till February, on February 27, 2024.
Much.
Till disposal of the application. I'll keep the application pending along with the writ petition.
That's it.
Need not be so much indebted. Okay.